So thank you for being here. I think this will be a wonderful conference. I'm going to transition here now to the next session on, let's get through. On how did we get here? And this is the history and background of the civil commitment laws and the overall regime of the civil commitment process. Go ahead, Angie. Would you like to? And Elizabeth. So I'll introduce so we have Angie Youngerberg from Blue County, who is the Community Service Financial Director. Is that right? Something like that?
The Director of Business Operations for Blue Earth County
Thank you.
Services.
And Elizabeth Balto, who was until recently at the Hennepin County Attorney's Office and worked in this area quite a bit. So thank you for leading this next panel.
Do that.
Here's the clicker with this stuff.
Stand.
Good.
Yeah.
I don't know if we can move this over here like this.
Oh, we'll stand.
You sure?
We'll hover
Okay.
by the podium.
And then Angela and Elizabeth, if we can just remind you, if you guys will repeat questions from the audience, if we can.
Right.
That would be helpful for our remote attendees to hear.
Okay.
Oh. Get this out of the way for you.
This.
You sure can.
It should be. Okay.
Actually, you know what, that one's a real terrible one.
Yeah. Good morning, everybody. So I'm Elizabeth Beltos, and I know many of you in the room because of my practice in the Hennepin County Attorney's Office, where I worked for 19 years, mostly in criminal divisions, but the last several years in the area of mental health and commitment. So we are going to talk about, Angie and I are going to talk about the history of the commitment statute, which is 253B, as Kevin mentioned, and talk about what he said. How did we get to the point that we are at? Some of this history with respect to the statute, I find fascinating. I don't know if you will as well, but I find it fascinating to understand how we got here. So Minnesota statutes 253B is, as Kevin said, a civil process that results in a court order with a judge ordering an individual to obtain treatment for mental illness or chemical dependency. I put chemical dependency in here, even though we're not really going to be talking about it this morning, because commitment orders with respect to mental illness and chemical dependency are probably the most common ones that we see. Do you think so?
Yes.
Yeah, okay.
I would agree.
So the statute again is 253B. This is the basic structure of the civil commitment statute. It has 3 parts, which makes it seem like it shouldn't be complicated, except when Angie gets to talk about her slides, you're going to see that it isn't as linear as it appears here. But the basic structure is not complicated. There has to be a diagnosis or some kind of an impairment that's articulated. There has to be evidence of harm to the person or another person. And the judge has to make a finding that commitment is the least restrictive alternative, and there's no other option but to order commitment. One thing I want to say about 253B is that when Kevin was talking about the population that's in the jails and the difficulty of having mentally ill population in jails, the commitment statute was not designed to treat defendants who are mentally ill. It was designed back in the, I don't even know when the first commitment statute was written, if it was in the 60s, but it was designed for people in the community who are suffering from a mental illness. So that's why, as Kevin is talking about the problems that he's identified about, like Kevin said, that most, if not all of the patients who are at Anoka and now come from our jails. And that was not the intent of the commitment statute. I find that interesting. The reason that happened, in other words, these jail populations are now in line to receive treatment at Anoka, is because of Rule 20. So, which is a whole another topic, which I love to talk about. But Rule 20 is a criminal rule of procedure that was written, I don't know, in the early 70s. And it told courts that if a defendant who is found incompetent must order a referral for civil commitment. Up until Rule 20, there was not that connection between commitment and a criminal defendant. So that, I think, has contributed over the years to this increase of people waiting in jail to be treated at Anoka. All right. So one of the first significant changes to Minnesota's commitment law occurred in 1982. And the previous statute was 253A. It was renumbered as 253B in 1982. What was significant about 1982 was that it codified the rights of patients into the statute. That hadn't been there before. This is really significant for treatment of individuals. The other thing to point out, in 1982, the title was called Minnesota Commitment Act. It is now called the Minnesota Commitment and Treatment Act, and there's a reason for that. We'll talk a little bit about that. But this slide shows what the rights of patients were included in 1982. And again, this was really, really significant at that time. All right. Right to counsel, periodic assessments. Their due process did not exist before 1982. So this was really an important development.
I think and she said I could speak without the microphone, so if you can't hear me, let me know. The interesting part for me on this one was the visitor designation, because that would imply that the person is somewhere other than home. And what we see with civil commitments today is the majority of people are at home or in the community. And so this is reflective of that they're somewhere, that they are somewhere and they have visitors. So it was just interesting to me that that was written in there.
100%. That is such a good point, because in 1982, if you were to read the old statute, it uses words like institutionalization. So people were in fact sent to an institute for treatment. They did not receive treatment in the community or at home. And so that's why that language is in there. And that you'll see in a different slide that we're getting to, partly why the title was changed to commitment and treatment. There was this paradigm shift that happened in the late 1990s, where we're talking about not institutionalizing individuals. Okay. Part of this is really important, obviously, the definition of someone who is mentally ill. And the definition in 1982 was what is on the slide, that the person had to have a substantial psychiatric disorder. That was amended really quickly the following year to include an organic disorder of the brain. That definition has not changed. That is the one that we still rely on. And those are the two factors that we look to in determining whether or not somebody meets commitment criteria. This is the definition of somebody who is chemically dependent. That definition from 1982 also has not changed, I don't think. All right, harm. This is the piece that I find interesting, that I think sometimes we can forget about, the connection between the harm and the condition. So it isn't just that harm exists, there has to be proof that because of the condition, harm resulted either to the person or to another person. So I think that's an important causation thing to keep in mind as you are in this practice.
About harm, the definition of harm in the civil commitment statute is fundamentally different than the definition of harm when being clinically evaluated in a hospital. So although we might be talking about the same person that has the same presentation, or I mean, the exact same person, from a civil commitment standpoint,
Yeah.
we're looking at this definition of harm. When they're sitting in an emergency department in a hospital, a doctor or a physician is looking at it from the clinical definition of harm, which is often more about imminent risk of harm. And so we sometimes see this convergence or this conflict come forward because you can meet the threshold for civil commitment, but hospitals are saying, I can't keep them. And so it, as a
Yeah.
as a person, you're like, how can this be the case? We're talking about the same individual. And so it's two completely separate constructs.
Which makes commitment sometimes very difficult because hospitals don't want to hold an individual because of what Angie just said, which is very real and happens. But those of you who practice in the commitment arena know that committing somebody who is already in the community is really difficult. It's difficult because we don't have access to the first part of commitment, which is what is the diagnosis or impairment? You need that medical information in order to proceed. So sometimes there is this tension, like Angie is saying, and we are not able to move forward with a commitment because the hospital has released somebody. Yeah, good point. Yeah,
Happens in Minnesota, Mayo has decided to let people out in the middle of the commitment process despite a hold.
Yes.
And I'm always ethically kind of confused. Should I stop? Because they've now found them to be well enough to leave and safe enough to leave the hospital. Even though I have an examiner saying you should be committed, I've got the treatment team releasing them from the hospital.
so I'm going to repeat the question, and I hope I'm going to paraphrase it accurately, which is you practice in southern Minnesota and Mayo has a policy or practice now of releasing individuals from the hospital sometimes during the middle of the commitment process. So you've already started the commitment process and you're a lawyer and you want to know ethically, can you proceed with your commitment when the Mayo has made a decision to release somebody? And Angie, you might, I mean,
I can.
I'm a lawyer, Angie's not a lawyer, but Angie has experience on this topic because of Mayo, and I'm happy to pipe in too as a lawyer.
So I'm based out of Mankato. So Mayo is a couple blocks from my office, and we're partners with Mayo in so many different ways, and we're very grateful and thankful for what they can do for our community. But I would be lying if I said it wasn't a tension point between us, because it's very, very difficult to see the practice change, to understand it, to figure it out. I'm not giving you advice, obviously, but I've had multiple meetings with Mayo leadership, and we've asked that direct question, like, so we're in the middle of the civil commitment process and you're discharging because of the imminent, they're not, yesterday they said they were suicidal, today they said they're okay. We have a long history that says they're probably not. Where does it fit? Where does it fall? They choose from a clinical standpoint to discharge according to their policies. We in Blue Earth County have been considering that very same question, like, is your examiner going to say that they no longer meet the criteria for civil commitment from a clinical situation? I think we're so new into this, we've not seen that happen, but I will say in my conversations with Mayo leadership, they have continued to reiterate that their action or their decision doesn't diminish their earlier clinical opinion that civil commitment still needs to occur because of the fact that the majority of civil commitments are managed out in the community. But it is perplexing when it happens in the middle of the civil commitment process. I am with you with that. I understand. I don't have a great answer. I think every county needs to, every county needs to look at it on a case by case basis and use that information to make the best decisions. But I will say in those conversations that I've had about our people that are going through that, they have not said that it changes that original clinical opinion that started the process.
Can I just ask, in that situation, are the people that are being discharged after the preliminary hearing, are those on petitions that that Mayo Hospital caused to be filed?
Yes,
It's not like they're taking them and read it,
no,
it's their own petition.
yes.
Oh my God, okay.
Right? Oh my gosh. So in case you didn't hear the question, Judge
Thank you.
Carey asked whether or not the petitions are involve those individuals who they petitioned on initially, who were in their hospital. Did I get that right, Judge?
Yeah.
Okay.
Yes.
Yes, Anne.
I'm just curious how long between the filing of the petition and the commitment hearing is occurring in your counties?
How long between
The petition being supported and the hearing.
the petition?
Wait, between the preliminary hearing and the final hearing.
So
The petition being filed and the hearing, what's the duration? What's the timeline?
We have, usually ours are getting let out. We've probably had 4 of them let out now between the preliminary hearing, when the court has ordered them to be held, and the final hearing.
yes. So,
Probably like 8 or 10 days.
so I will say in Blue Earth County, and I can only speak for Blue Earth County, what our experience is. Again, every county may be different. So the question from the preliminary hearing to the final commitment hearing, what's the time frame? We generally see that happening within a 2-week time frame. To apply it against the situation that we were talking about in the earlier question, the discharge occurs sometime between those two, so within that window.
Christy?
One last question, if I could, on this topic. Are they doing that in violation of court order, like preliminary hold order?
Are they doing that meaning Mayo? Are they releasing individuals in violation of the court order? The answer from the audience is yes.
I just think that that is a trickle down effect of DHS routinely ignoring district court orders. And now that's trickling into our local hospitals who have seen DHS do it without remedy.
So the comment is that this is a trickle down from DHS and trickling down into the county levels. So, I mean, to get back to your question about your ethical responsibility and should you proceed, I'm sure you've sought guidance from your supervisors. If it were me, I would have no issue continuing to proceed. If there's an examiner statement that's supporting commitment, and honestly, it's the right thing to do, I could defend it in court. Yeah.
And I would need to confirm with staff at Blue Earth County, but to my knowledge, anytime we've been in that situation, we have also continued that process. Those that I'm aware of, yes.
Kara.
I'll let you know, I'm hearing questions come through pretty well.
Oh,
so
okay.
I'll let you know if you need to repeat.
Oh,
Okay.
excellent.
Question from the audience. Elizabeth, this is focused at you. Could you distinguish the measure or standard of harm which a court appointed examiner for a Rule 20.01 evaluation is typically ordered to assess versus the level or standard of potential harm to self or others required to meet the statutory criteria for commitment? A little more. It often appears the court-appointed Rule 20.01 examiner finds no imminent harm, which would require immediate hospitalization versus the level of potential harm necessary for commitment.
Okay, I think that whatever that lawyer is experiencing, I'm assuming it's a lawyer asking that question, that happens with frequency. I think we all see that, sort of, I don't want to say a discrepancy, but, what is the level of harm? And I don't want to say it's squishy because it's not, but the definition is a substantial, likelihood of harm to themselves or others. You know, depending on your examiner, you could hand the same set of facts to two different examiners. One examiner is going to find that the harm that is presented meets commitment criteria and a substantial likelihood of physical harm to self or others, and another examiner who won't. And I'm not sure how to bridge that. You know, I'm sure that there are lawyers who have proceeded on commitment cases, even when an examiner is not supporting, if that's the only, if they find the other criteria are met, and then you make a legal argument to the judge. But I can see that happening. I hope that answers the question for the person in the audience. If not, please let me know.
Suppose there's yes, that brings a broader question in my mind regarding examiners or institutions or even the courts. Is there a misapplication of standard between substantial likelihood and imminent harm? Do any of those places that often confuse the two?
So I have to say, I don't think there's a misapplication. That hasn't been my experience. I think just in the practice of law, you are going to get different opinions, even with forensic psychologists. So I don't think it's a misapplication. I think some psychologists may be more conservative than others. And I guess I don't see it as a misapplication. Yes.
Rule 20, we've seen it a lot lately and have been having to go back to our examiners and ask for clarification. That when they're looking at the Rule 20, they're seeing them in jail and not in the circumstances that cause them to get there. They're saying, no, there's no imminent danger because they're in jail, they're safe, they're not acting up. When we're thinking about all the crazy and dangerous stuff they did to get into the jail when we're committing them. So we've had to ask for clarification, like, if he walks out the door today, would your circumstances change?
Oh, that's interesting to me, that they're focusing the analysis on
Right
the
now.
time, right, the time period while the person is in jail, and not considering the behavior before. That's strange to me. That should not be happening. So that's a good way, I think, to bridge that, to ask for clarification about the behavior before. Yes.
I think some of this could be relieved by our examiners. Some of them are still using the old criteria of 2001, and that asks for imminent harm. 611 point, I think it's 4.3 updates now and asks about substantial likelihood of physical harm to self or others. So, and then 2001 was just recently amended and it removed that inappropriate. The imminent was about if somebody is psychiatrically unstable at that very moment and they need to go to the hospital. It's been conflated over the years to be this somehow applicable to commitment, which is just not. And so I think that is, because that's the standard law enforcement are looking at, is that imminent and to take them to the hospital.
Right.
Once we get to commitment, where it's substantial likelihood.
Right. Right. So good practice to ask for follow-up. And the new Minnesota statute 611.40 to 0.59. And okay, you guys, I'm sure you've all heard of it, but that is the new statute that we hope someday will completely replace Rule 2001. Anyway, that's a different topic. So moving on, oops, let's see. Okay, commitment duration. This is basic information. It lasts 6 months. And it may be extended on a request by the court. The court has to order it. The key to commitment is that commitment is not a place. It used to be a place. You know, 40, 50 years ago, it used to be to an institution. It is not a place anymore. It is a court order to follow recommendations for treatment. And that, I think, is a misconception, probably not among professionals, but certainly it is a misconception among people in the community. If you say the word commitment to individuals, they'll freak out. They really picture in their head an institution with no windows and, just like one flew over the cuckoo's nest, that's what they picture. But just to keep in mind, if you're talking to people, that they may have a different picture in their mind about commitment.
I think one of the ways to look at it is, commitment is technically to the Department of Human Services Commissioner. That is what is written. And it is to follow a treatment plan that has been essentially prescribed and authored, individualized for that person. And as you were saying, it is frequently confused with the word admit. Commitment is not admission to a facility. And I think that there are many that think, I can say in practice a long time ago, it was, we would have people that would be so frustrated, like, I committed them to that facility. No, you transported them and they were admitted for evaluation, but they were not committed. That is a different process. And so the language sometimes gets mixed up.
So this is the 1997 amendment that I just want to touch on briefly, which added the word treatment to the title, which is important because this really signals the paradigm shift away from institutionalization to community-based treatment options, more person-centered treatment. And the 1997 amendment also included the administration of neuroleptic medication, which also is a significant development in the treatment of those who are committed. So 253B.10 is the provision in 253B that Kevin was talking about this morning, which talks about procedures upon commitment and the 48-hour rule. The initial, back in the 80s up until 1997, this was the language in 253B, which was essentially, if there's an order for commitment, you are going to go to an institution, and that would have been a no-go. That's it. There was no 48-hour rule. There was no timeline for the person to be transported. You're committed and you go. And in 2013, as Kevin mentioned this morning, that's when the 48-hour rule was instituted. And it required that individuals who were in jail be prioritized. This is when that shift is starting to happen, when we see more individuals who are in jails needing to go to treatment because there's been a commitment order. So this is where that intersection between the civil process and the criminal process really starts to, amplify.
Again, my applied way of looking at it, we talk about this in the human services realm as saying the person needs to be in jail. They need to be found incompetent based on a Rule 20, and they need to be civilly committed. Then the 48 hours starts. Doesn't start until all three of those things occur. So all three have to.
That's right. That's exactly right. And that's the intersection between the civil commitment process and the criminal realm, which didn't exist before. All right. And then recently, I think it was in 2023, right? This is when the framework started. Okay, so the 48-hour rule was tinkered with again in 2023, and the legislature came up with a set of criteria. They refer to it as a framework of items that they're going to look at to determine whether or not an individual may be admitted from a jail or other correctional facility into one of their state-operated facilities. They have sole decision-making authority, and here are the criteria. There are 7 of them. This sunsets in June of 2025, and Kevin, you're part of that task force, right?
Right.
Yeah, so Kevin's part of the task force that's looking.
As it's aimed.
And Angie, thank you, to come up with hopefully a more workable solution for this population. Some of this, my hope is, I don't know, maybe in 10 years, my hope is that this section will truly become obsolete when we have enough infrastructure with Minnesota statute 611.40, which deals with incompetent defendants and treating them, that we don't need to worry about commitment. So that's my hope. But in the meantime, this is the criteria that DHS looks at. Okay, here's my sense. I feel like these were criteria that they already used, that we practitioners didn't really know about, but now it's out there and now we know what they're looking at least. So I find that helpful.
So this started July 1st of 24. So the priority admission group met through 23 or the end of 23 and into 24. And so the session of 24 is when this was adopted. It was an attempt to move away from first come, first served methodology, which was if you're first on the waiting list or once you get up there on the waiting list, then you'll be taken. And frankly, if we had enough capacity, we wouldn't have to have a waiting list, right? And so we're going to set that aside. That'll be part of the later discussion. We have a waiting list. How do you manage that? Is it first come, first serve? Or do we take other criteria into account? And the task force agreed that it's not perfect. This isn't perfect at all, but that we were seeing jails really, really struggle with individuals that were super high acuity and people were suffering and they were low on the list because of one factor, time. Their acuity, their need for clinical intervention did not matter. So when we put that up against how we would handle a heart condition, right? So we're talking about healthcare. So you put that up against how we would handle a heart condition, we wouldn't necessarily say, oh, I know you're having severe chest pain, but this person has elevated levels and not experience, and we're allowing the medical decision-making to be part of the factor, not the sole decision, but saying, here are things that are important. Some of these weight differently than others, and they're adjusting that, and we are reviewing that. Again, the real fix would be more capacity. So unfortunately, we have to have this. And one of the unintended consequences of just having first come, first serve is that there were instances in counties where once someone would get up on the waiting list, they may be civilly committed, they may be in jail, they may be deemed incompetent based on a Rule 20. But they didn't meet hospital level of care, believe it or not. And they got admitted to Anoka or to elsewhere, and the county had to pay thousands of dollars because they didn't meet medical criteria on day one. And that's a different 4-hour conversation that we can have.
It's more than 4.
Yeah, right. And so that was an unintended consequence of that. So that we had people that were actually top of the list that didn't meet hospital level of care. Yes, jail was not the best place for them, but we had another person in a jail that's seriously, seriously suffering. And so it's a step to try and do that. It's not great. There's so much volume. There is so much volume.
It just listening to Angie talk, it's just like, there are no good options. And as a practitioner, that feels so frustrating, so frustrating. Judge.
What is the current cost to counties when people are at Anoka or St. Peter but don't meet hospital care criteria?
So question, what's the daily cost of care? Yep, every facility has a different charge. So if you're at Anoka, it is what, is it 1,700?
It's more than that.
Is it
That
twen-
sounds like 2023. I think it's over 2,000 a
It's-
month. We're paying.
It's,
50,000 a month.
yeah,
Other numbers.
it changed a day. Yeah, it's
2,000
not
a day.
to about 2,000 a day. Yep. A community behavioral health hospital is usually about $300 to $400 less than that. If, you know, if it's, and it changes annually. So, I used to be able to rattle those numbers off the top of my head, but
And do you know what it costs daily, for example, at your jail? I mean, I realize you're in human services, but.
the number I've heard is, you know, right around 100. I don't know. That's a number.
100.
$100 when they take all of the costs. I don't know for a fact. That was years ago. I would need to, it's less than the hospital care, but not the same because they're not receiving
They're not-
the health care that they're needing.
Right.
It's not apples to
Yeah, I'm not
apples.
saying they should.
The EMRTC costs are 2,320 a day.
Thank you.
Cash cost is 1,989. Or the CDHH, excuse me, is 1,989 and cab is 2,450.
Cabs is for children.
Cass County currently contracts with Itasca County, pays $56.65.
Okay.
Yeah.
So
Obviously, that number differs, bill to bill, or having daily population, but.
Yeah.
But why we're doing it.
did you have a comment?
Oh, I think DOC reimburses county jails $50 a day.
$50 a day. So you can see just with this discussion that, you know, it isn't just about what the criteria are in the statute, which as a lawyer, you know, bother me, but it's also about money and how we apply this and how we do it in real terms. So it's complicated.
I have another cost related question. Do counties reimburse community hospitals for days patients board in EDs when they don't need hospital level care?
That is a county by county decision. So I can't answer that question.
We've been talking a little bit about the impact, sort of in our discussion here about the priority admissions and the historical changes from everyone being admitted to a state operated facility to the structure that we have now. Counties don't have a whole lot of say anymore in terms of who gets placed. And that feels a little difficult when you're a practitioner, that you really don't have a say in that. It eliminates reviewing the need for competency treatment as a consideration. So that's not a consideration anymore if you are somebody who has been committed. And it's not just wait time or the wait list, as Angie was saying, we've moved away from that. And individuals will remain in jail for long periods of time awaiting placement. And that's really the crux of the issue here, is that we have too many people who are in jails awaiting treatment.
I just want to restate my answer to that last question about if counties are responsible for payment. There are instances in where counties are responsible for payment for a 72-hour hold. When the person does not have a payment source or payment option, it becomes the local mental health authority or that county's responsibility to pay that. Beyond that, so beyond that statutory requirement is really a county by county decision on how that might happen.
Yes.
Clarify, someone who receives a commitment order and dismissal of criminal charges, are they required to then be held, or can they be laid in the community for placement?
So that's an issue. In Hennepin County, I am aware of individuals who had serious charges that were dismissed and they remained in custody. And they were committed, awaiting a bed, And there were motions filed by defense attorneys seeking those individuals released because there is no criminal charge anymore to hold that individual. And so that happens, and that's part of the issue too, is what is the basis? What is the legal basis for this individual to remain in custody? Because just because you're committed doesn't mean that you're going to be held. And so that's a problem.
What is the statute unclear on that issue?
So 253B has a provision, I think it's 253B.045. And Judge and Christie, correct me if I'm wrong on that, but I think that's the provision that says that counties are actually supposed to have holding facilities to hold individuals pending placement. Many counties, including Hennepin, don't have those facilities. I think Ramsey does. No, not anymore. You used to at Regions. No, okay. Counties don't have those. So the statute is very clear, actually. We're supposed to have them. We don't have them. I'm not a policy maker. I'm not in the budget conversation, but I suspect that's a budgetary issue. But we should have them.
They're only supposed to be held if those separate facilities exist.
They're only supposed to be held actually if certain criteria are met in the statute. And those criteria actually do relate to imminent harm of other people. I don't remember exactly what the words are, but you can't just be held because you've been committed.
Okay.
You have to meet additional threshold.
Thank you.
Yes.
How are we doing on time?
10:18.
Okay, and we go till 10:30 and break roughly? Is that what it was?
Go till 10:45 and then a break.
Oh, 10:45, okay. All right. So, I know that, I've spoken a bit already this morning, but just a little bit of background about who I am. I am not a lawyer. I'm in the human services realm. A bit about my background. Years ago, I worked for a small county and I was a case manager who also did their pre-petition screenings and managed civil commitments in the community for adults with mental illness. So I have direct experience in maybe how it used to be, right? And now in my leadership role, I'm working with our team who are dealing with the realities of what it is right now. And I see the differences, the challenges. Some things are good, some things are not. I've also had a role in regional mental health planning and design. So I did that for a number of years, and implementation of programs, so community-based programs. So community-based treatment is really at the heart of what I like to do and try and serve people in the community whenever possible. But it's not a one-size-fits-all model, it just isn't. We need these higher levels of care for individuals at times. In my role, it is essential that we partner constantly. So the Mayo question that came up, we're struggling with the same thing in our community, yet I rely on Mayo greatly for the services that they provide in our community. And so I can be frustrated and grateful at the same time. And that's challenging. Same thing with DHS and direct care and treatment. We see such good work that they do, yet I can be so frustrated that they don't have the resources that people need in the time that they need it. And I have to remember that people come into this work because of the mission and what they want to do, and they want to do good. And we're all seeing resource depletion right now. We're all seeing the need raise in our communities. So part of this priority admissions work, and they're going to talk about it more this afternoon, was highly enlightening to me in that, you know, I frequently work with people across different areas, but to work closely with Kevin, so really learning that attorney perspective, that county attorney perspective, working closely with Brian to really understand and see the sheriff's perspective on this. And then with Commissioner Clark, who will be here later today, to see that policymaker, that local policymaker perspective as well. I live in human services and I see what that is. And all four of us had to open up kind of our blinders. We all did. And it took us a while to kind of come around to it. And we all see, and you'd said this earlier, it's just this massive thing. And what we're going to talk about is there's a whole history before all of us here. We can learn from some of this, but this is like moving a mountain. So the things, and Kevin talked about it, we've got to start, can't boil the ocean, he said. We've got to start doing some things that start making that change. I will ask today that if I say something, I might say it wrong. Please give me some space for that. I do like to use analogies, similes to illustrate a point. It is not to diminish the nature of what we're talking about, but it's more of a teaching strategy. And most importantly, the whole goal is to be able to get people the care, the access to care that they need. So that's what we're all here for today. So as we dive into a little bit of the history, I'm going to go through this very quickly. I'm not going to talk about all these facilities, but Minnesota used to look very differently than what it does now. So you've said today, like when someone's committed, they go to Anoka. I remember when they went to St. Peter.
Me too. I
There,
remember that.
there are other people that remember when they had this list. I'm not saying it's a great list. It has its pros and cons. Feels like a bigger list than what we have today. I'm not sure I would have wanted a family member there. I'm quite certain I wouldn't want a family member sitting in a jail right now. So the 1900s was the institutionalized model. Everything was about institutionalized care. If you had a mental illness and you needed treatment, this is where you went. If you lived in the community and you needed some treatment, you could go on an outpatient basis, but more often than not, you were there. These titles got changed as some of them went away. They got changed to regional treatment centers. So right along the same time as the Commitment Act title changed. Yep, go ahead. So what was it like? They had centralized resources, lots of people all in one space. As many as 10,000 people in Minnesota were institutionalized at one time, at one point in time. 10,000. Anoka has a capacity of 100 today. Think about that. They had specialized treatment providers, doctors, nurses, therapists, social, vocational supports, rec therapy, you name it, they had it all in one spot. Sounds fantastic, but it's also got its pros and cons. It's secluded, it was away from the community and family of people. People were highly secluded. They were alone often. It's a very controlled environment. So from a therapeutic standpoint, it made treatment much easier because you're able to control the environment around people. You're able to control the stimulus. You're able to control what is impacting them. So from a clinical standpoint, you can do that much easier. There are lots of reports of abuse. It was a costly model. Workforce was difficult. You had to have a lot of people doing the same thing all at one space. And then the biggest thing, it's easy to get into, but really hard to get out of. Took forever, took years, took a lifetime for many people. St. Peter, they have a cemetery there. They have, if you ever get a chance, they have a museum in St. Peter. It's worth going to learn what this was all like. 1963, we saw a federal shift from President John F. Kennedy signaling that institutional-based care is dying. It's going away. And we're shifting to the community-based care. 1980s, the funding that was supposed to be coming for all of the community mental health centers didn't quite cross the line. So we had this great vision that didn't come to fruition because funding wasn't there. So if any of you hear Sue Abderholden testify, she will say in almost every bit of testimony, our system is not broken, it was never built. I tend to think the system's broken, but I totally agree with her, it was never built. Completely agree. And it started then. 1990s, it became, we have to have a plan to close the regional treatment centers. These are not people's homes. We need to have their homes and communities. It's a great aspirational goal. The funding then, nothing happens till money changes. Funding shift began away from institutional care to form adult mental health initiatives. There's lots of other things that happened during this time too, but the adult mental health initiatives formed. We'll talk about what those are here in a little bit, but basically money that was once operating some of those facilities got peeled away and given to groupings of counties. Not all the money, believe me, not all the money. Some of it went to community-based care. This is only for adults. We're not talking about kids yet. Early 2000s, thank you. Significant efforts to reduce census at most all remaining state hospitals for people with mental illness. There was a huge push. In fact, in our region, for every time we took an inpatient bed offline, we got a bucket of money. We said we didn't need it anymore. We built out community capacity. The state gave us more money, or they gave us a staff resource. They gave us something. 2005 to 2008, the state said, all right, no big, large institutions where you can't bill Medicaid. We're going to build 16-bed hospitals all over the state. Not all over the state. Throughout the state. Because 16-bed is the threshold for which they can build Medicare, Medicaid. We don't have all of them that were built anywhere, so some of them have closed. But there are some CBHHs, we love our acronyms, that are still in existence. And then 2010 to present, we've seen a trickle and a flood of loss of community hospital inpatient beds. And here we are. We went from having 10,000 people in institutions at one time to having very few beds. And we don't have a fully built community-based mental health system. We've got some really good things going in the community, but it doesn't cover all the bases.
Isn't that just so sad, like just listening to Angie describe that, where we are and the loss of beds and the lack of funding? I mean, I don't know. I wish our legislators were listening to this presentation, because this just makes me sad. Almost everybody knows somebody or loves someone with mental illness, and this impacts all of us. And it just makes me sad listening to it. So I just wanted to say that out loud.
Adult mental health initiatives is, again, another topic that would be a couple hours worth of conversation that we're not going to spend time on today. But this was a strategic move on the part of the state to say, let's build out community capacity, and we're not going to do a one-size-fits-all model. Love it. We're going to give money to local governments so that they can build out what their needs are locally. Great, wonderful. The funding was not enough, but it was a start. It was a start. There are mental health initiatives across the entire state. Your county, where you live, where you work, has an adult mental health initiative. They all look different from each other. The core concept is the same: build community capacity to prevent the need for greater hospitalization and higher level of institutionalized care. Build out that community capacity. The problem is we were given money, and the money didn't keep up with the cost, right? Sounds familiar with lots of other kinds of community developments in all sectors. So what a lot of the adult mental health initiatives are trying to do is trying to maintain the community resources that they built. A little bit of resource with high aspirations can tend to produce some very innovative results. Some of this is working really well around the state. in no way is it a one size fits all. It's working really well for some people though, that once would have lived in a regional treatment center. So I think we should be proud of this. This is a huge development for the state of Minnesota. We need to continue to pursue this from a community-based service standpoint. We also need to pursue this same model for children. There is nothing like that for children. Kevin.
Can you say something about the division of the districts or whatever they're called?
Sure. This is my version of it. They occur often because either those counties frequently work together with mental health services. They are large in size and maybe their own initiative like Hennepin County. Or they may be like my region here. We're centered around where the St. Peter Regional Treatment Center was. And so therefore, we stayed together and worked together because we had resources that came from the St. Peter Regional Treatment Center. Region 3 had some of that from regional services up in their area. So it's generally those counties that work together on their mental health planning, and it has a lot to do with their community mental health centers as well. Oftentimes community mental health centers cross county lines. And so the state said, if you're already working together, why would we make others not work together? So interesting. Oh, they have this is a DHS map. Wrong. Waseca is not in ours. Waseca is actually fully here. Why? They're like almost in the middle of ours here, but their mental health centers are together in these 3 counties. So they work over there together.
What are they called? What is DHS called?
These are adult mental health initiatives,
And that denotes the district.
AMHIs.
Okay.
Yep, yep. And everyone has its own name.
Okay.
Crest. You did. Interesting. It's gonna take me a long time to get the name changed down. Yep, go ahead. Community-based care in Minnesota. This is opinions that we hear. Again, it works well for some, not for others. What happened in regional treatment centers, there's consistent support, 24/7 support. We don't have that in the community. That's nearly impossible to replicate. It can be super challenging for some, but the independence was really effective for some others. The lack of inpatient hospital beds, never fully funded. Workforce concerns. Yeah, we have poor reimbursement rates for mental health services. Absolutely. Hospitals, just so you know, hospitals get paid more for doing an x-ray for a broken arm than they do for an inpatient psychiatric hospital stay. Kind of bizarre.
So from a prosecutor perspective, I think one of the issues with community-based services is that there are individuals who require treatment but are also dangerous. So where should they be placed? And a community-based facility may not work for that population, and that population does exist. So I think that's something to consider. That's part of, one of the stakeholders' concerns.
Absolutely. And with this, we see more and more reliance on law enforcement. I mean, law enforcement, just thinking about the amount of mental health training that is going into law enforcement right now, in my opinion, we need to keep cops, and social workers, but we need to work together. And it feels like there's a blend happening or an expectation that we're all things and we're not. So the pendulum, did the pendulum swing too far? I would say this, here's an analogy. COVID happened. And a lot of people went home to work and still may be at home to work. And so prior to COVID, a lot of people worked in office settings, in business settings, in work environments where it's highly structured. There's clear expectations, there's sight lines, there's observations, there's lots of verbal communication. Now people work from home. And there's more independence. There's more trust. Got to be more self-accountability. How did that go for people who were struggling in an already controlled environment for workforce? They were struggling to do their duties in an environment in which they were highly monitored, observed. They had all the tools and structure and expectation around them, and they were holding it together. And then they go home. Chances are not very well. Chances are. I liken that a lot to institutional based care. Some people did really well. They were holding it together when they have structure around them. And now we shift to a community-based model where you don't have that 24/7 accountability. And it gets really hard. And that's maybe an unfair expectation for some people. It could be an unfair expectation. So did the pendulum swing too far? Now are we coming back? I hope so. I hope we're coming to this middle somewhere. I want to talk about a case study scenario. Let's call this person Dennis. Someone said, that's your brother's name, isn't it? And I said, yeah, one of them. This isn't my brother, but you know. So Dennis, my years ago working as a case manager, Dennis was someone who I regularly met with, military background, kind of rough and tough guy, physically intimidating, had a record, aggression, assault, blah, 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 whatever. Diagnosis, post-traumatic stress disorder, depression, borderline personality disorder, would make suicide attempts. Calls me one day and says, I'm suicidal. I talk to him. He's not coming down. I determine, have to call law enforcement. He lives out in the country. Law enforcement responds. Law enforcement drives into his yard. He lives, as I said, out in the country. They see him in his garage, and he had a rope around his neck. And then he sees the cops. He takes the rope off and starts running. And the cops are like, what are you doing? Right? And he's making statements, just let me kill myself. We know he has access to weapons. We absolutely have the history on him. We know what that level of risk is like for him in the past. He gets in his car, starts driving away. What's law enforcement do? Follows him. What happens? High rate of speed. Thankfully, no one got hurt. In that scenario, he was taken to the emergency department. Within a couple of hours, he was determined to need hospital level of care. He ended up going to St. Peter for about 3, 4 weeks, 5 weeks, stabilized back on his medications and home. Let's fast forward to today. I'm not sure what would happen to Dennis, but I can say what happened then is not going to happen today. It will either be law enforcement shows up and says, we're going to monitor the scene. We're not sure because so much of the landscape has changed that response is different. Or he gets in the car, drives away, breaks how many laws, flees a law enforcement officer, ends up in jail, unmedicated, right? How this, I don't know. I don't know what happens. All I know is I can't imagine a scenario where what once happened would happen today, let alone be in the emergency department for 2 hours and have a bed. I mean, that's just not going to happen anymore. So that pendulum, it's swinging, and I don't know where it's going to stop. And so the reason why I bring that up is, does the civil commitment statute in this case, if he was civilly committed, which he had been and was after that, would that even be effective anymore today? I don't know the answer. I tend to think no, but I don't know. Questions?
I have a question now before we break for our law enforcement partners in the back. Did what Angie described as what happened back then wouldn't happen today? Does that sound right? Yeah,
You're spot on. In fact, most of the law enforcement training and in the tactical arena with the National Tactical Officers Association, if they respond to a suicidal situation and there's no crime been committed, they're told to stand down and leave.
thank you.
And I'm not saying what happened the first time was the right thing. What I do know is my person ended up in the hospital. He was treated, he was safe, and he was home within 4 to 5 weeks. It's a pretty good outcome. I'm not saying what happened was exactly right either, but I don't believe it would happen today.
What happens if the crisis response team
Mhm.
were to respond, where you have law enforcement and trained mental health professionals there?
Yeah,
What's the scenario then?
depends on how he responds. It's completely it's a totally different
I guess
variable.
what I'm wondering is, assuming that they are able to communicate and calms down, are they able then to get him into a facility that can provide some sort of?
Potentially,
If he goes voluntarily.
Yeah.
if he goes voluntarily,
They
I will.
won't, right? And my law enforcement won't put hands.
So then, so
Yeah.
if Dr. Downey goes voluntarily, but if he's
So
not.
transport will still happen.
Immediate response, or they won't even respond unless law enforcement is safe, otherwise it's a whole.
And I think mobile teams and law enforcement response occurs differently across the state. I mean, I can say in our region that even within our region, the response is different. Same team, different law enforcement jurisdictions. From a mental health standpoint, I'm not gonna tell law enforcement how to do their job. That's not my role. I'll follow their lead on that. And our mobile team will do what they can in that situation. I will say for this individual, it would be a minimum of a 45 to 1 hour response time for our team. And he had a rope around his neck. I don't know. I don't know.
I think often, because it's easier, we want to compartmentalize and try to make, this fit whatever this response scenario. And when we've seen the crisis response and some of the co-responding elements, you still have law enforcement at the scene. And what we call the no people are still going to be the no people. And so whether it's a family member, whether it's a police officer or somebody showing up with free pizza, they're still naked in the street swinging a sword. And somebody's going to get hurt if it's not handled very delicately, obviously. And to have law enforcement conceptually back off and let the crisis response teams deal with it, they're still gonna be encountering no. And somebody's likely to get hurt. One, put that aside. The other side of it is with the mild crisis response teams, we have a hard enough time finding new law enforcement who think it's okay to work 24 hours a day, weekends and holidays, much less somebody who went to school to most of the time be working in a controlled environment. And so the number of candidates that are out there and interested in this type of response team is very, very small. So it's great concepts, very difficult to apply.
Absolutely. Very well said.
Yeah, that excellent point.
Yeah, folks on online able to hear this discussion?
Kara?
Fairly well.
Okay.
Fairly well. In the back, if you can speak up very well, that's very helpful. I'm getting most of it.
Okay, good.
I'm gonna keep trying to see if we can
Take
do
a break
better.
then.
I think so.
Okay, take our break.
Till
See
11.
you in a bit. Yep.
I love him.
I read your reports on that.
Like we- Keep going.
We got this nice done already. And travel time. And a hotel. Actually, the company car. Free ice cream on the way down and on the way back.
Thanks. That's very nice. How are you? We've got a slide later on the competency, all that stuff, and since you worked on that task force, you're going to jump in and correct me if I'm off on anything.
Hi, how are you? How are you?
Oh my God.
Yeah,
Oh,
so great, okay,
That'll be good.
awesome. Awesome, awesome, awesome. Oh, jeez, I know what this is to do.
No.
Wow.
See that information, I didn't like.
You can't see it?
The-
Oh,
it-
it's too tiny, the print.
Right, I know, I'm like, well, okay, let's go through a case study, and I'm like.
Oh.
Really.
Yeah, we might fly through some of this
Yep.
stuff a little sooner.
Love that you play nice with them, because I'm constantly at work.
I know, don't you like that?
I'm not in
Because
Austin.
you know my thought
All
bubble.
other mayors.
What's your name?
I'm Kristen Nelson from Moore County.
Okay, all right. I feel like maybe I'd met you.
I was at that class a couple weeks ago at MCAA.
Oh, the
on
sex
STD.
offender
Yeah,
ones?
yeah.
Oh, got you,
Yep.
got you. Yeah.
And I used to
okay.
be the president of MCAA a few years ago.
Got it. Okay, nice
Um,
to meet
You
you.
too, but yeah, I'm at constantly at war, and I've even had a couple people mails let up that I then couldn't find
Yeah,
for the
See?
commitment hearing.
yep, we've.
I appreciate she wants to play nice because I'm like,
I,
hi,
I get,
just
I
like,
tried to get my judge to hold him in contempt.
Yeah.
and it wasn't-
I mean, I. will
that's
say that
tough.
We've had not so nice conversations, you know, at times, but.
You are nice though, Angie.
To,
Well,
like,
yeah.
it's,
I've kind of been at war with them for years because I also they want me to always commit people from our hospital that are so horribly mentally ill or take them into the jail. And I'm
There you go. Okay. Thank you. So we've been talking a little bit about how 253B, what it's really like when it's applied and in practice. And that's what we're going to talk about this session as well.
We're actually gonna do 2 questions
Oh,
from the
okay.
last one first.
Okay.
So we had a couple questions come in during the break from online participants. And we'll do our best with those and then we'll jump into this.
Okay.
So when a preliminary commitment order is entered, which directs a respondent patient is to continue to be held at a local hospital, is the daily care expense entirely the responsibility of the county? Or is there some shared expense if there's health insurance provided MNsure medical assistance? It gets billed to MNsure medical assistance to a payer. If there is no payer source during that 72-hour space, that goes to the county. That is my understanding of that. Next question. Prior to the 2023 statute change, the county is to house the individual as we are to have housing facilities, but prior to 2023, the state does not have to follow the 48-hour rule placement.
Okay, so if I'm tracking the question, yes, counties did have to follow the 48-hour rule before 2023. So yes, they did. They didn't, DHS didn't always admit individuals from jails within 48 hours. That was in the statute. It was a requirement, but it wasn't happening.
And that is like a perfect segue.
Okay,
to
welcome
this
to
next
the
part, 'cause
labyrinth.
we are going to get into some of that data here.
So we talked a little bit about the civil commitment process, but again, we were talking about it just in terms of its, did I skip ahead?
Yeah, I wonder, did it?
Oh, that's okay.
Okay.
We'll just go.
All right,
this way.
we'll roll with that.
We'll roll with it. We talked a little bit about the commitment process having a basic structure of 3 elements: diagnosis or impairment, harm, and the least restrictive alternative. This is sort of what the process looks like. It looks linear on the slide, but when it is applied, it's not. And we're going to show you slides that demonstrate how it's not linear. One of the things that the amendments to 253B did, the amendments to 253B, is added a provision requiring pre-petition screening, which means it's an independent team that evaluates requests for commitment. That was also really important amendment, because before that, a family member, for example, could petition to commit somebody. And for example, it could be a husband who wanted to, I don't know, get rid of his wife and commit her. And anyway, I mean, those were real things that happened. So pre-petition screening is part of the amendments. That's super important. And then before the commitment trial, there is a preliminary hearing, also called the hold hearing. So this is sort of the linear line. It's not really like that when we're talking about Rule 20s. A straight commitment case looks like this. It's linear for the most part. Okay. And are we all mixed up? We're all mixed up, but that's okay.
Okay.
Kevin had this slide up earlier, and this just shows you again the increase in wait time for admissions to AMRTC, which is Anoka Metro Regional Treatment Center.
So when we talk about 48-hour rule, another phrase that we hear is the individual meets high priority. So that's what direct care and treatment, so the state, calls individuals who are what we would call 48-hour, call them high priority, right? This data is data that we had in the task force, and it was part of a much larger data set. And we pulled out one element of it to say, Did the 48-hour rule work? I would say it did. For a while. It worked. Because in 2013, the average referral days to admission to AMRTC, which is where high priority or 48-hour people would be admitted, their average referral days to admission, so it's not how many days they're in the jail. So remember that they have to go through this whole process before they're deemed Rule 20 civilly committed in jail. Then the time starts, 1.3 days, 1.8, 2.3, and so on. Then the hospitals got full. And there was one hospital in particular that wasn't full for a long time. And that was the forensic hospital in St. Peter. And all of a sudden the forensic hospital in St. Peter got full. And they're the most high need, high complexity individuals that the state has to care for. And so where did they have to place them? Anoka. What happens? A backlog. People stay in jails, they stay in hospitals. So it worked when there was capacity. And so it shows there is responsiveness. It can happen, but we don't have capacity. The average wait list time for admitted referrals, Kevin showed this earlier. This is data that is brand new. So this was shown at our priority admissions review panel just a couple weeks ago. So this is right now. This is July 1st to the end of September. And when we're looking at MSATs, which is primarily ANOCA and the CBHHs, generally speaking, it's about 26 days. If someone's mentally ill and dangerous and needs to get into St. Peter, 250 days. Wait. That's how long it's taking on average to get in there. One of the reasons these hospitals have average wait times ranging in the couple of month span, 3 months maybe, treatment, sometimes less, sometimes more. Forensics, the average treatment time is over 7 years for an individual. So the bed turnover is not there, the churn, they cannot serve as many people because people have to stay there longer. I would ignore the CBS one. We don't have to talk about that. That's community.
Those are only for people who are in jail waiting.
Yes.
Yes,
That's right.
I think these are these your slides, Kevin?
Yes. We're just gonna skip over Kevin's.
Yeah, how did they get there?
I'm not sure.
That's all right.
Oh, it went right back to the beginning.
Just close your eyes if this bothers you.
Seizure.
I know, sorry. Okay. There we go.
There,
No,
this
no,
is-
no worries. No
That's
worries.
okay.
No, we pivoted just fine.
Those are
Um,
things that we expected to see.
Yeah.
So just in a different order.
All good. So we've been talking a little bit about this, so this might be a little bit repetitive, but there are some, these are the facility options that Angie was talking about earlier. Now that we don't have that whole list of regional institutions anymore, these are the options. You can go to a local hospital, but you're not going to stay there long because they're not treatment facilities. They will treat somebody who has acute symptoms. And then a community-based treatment option, which we've talked a lot about, ANOCA, and then CBHHs. And there are, how many are there in the state? Like 6 of them?
5 now?
Yeah, there are very few.
5 maybe?
And for example, in Hennepin County, a CBHH is not available for individuals in Hennepin County. CBHH beds are reserved for greater Minnesota and not urban areas. So we don't have access to that facility. And of course, there are very few of them.
So this slide is really looking at intensity of treatment type of treatment, length of stay. This is when we're looking at direct care and treatment, so state facilities, just for context, because I think that we can get into this alphabet soup so much about CBHH, AMRTC, MSATs, you name it. The most secure is over here, most secure. This is forensics in St. Peter. Again, average length of stay plus or minus 7 years. Before 2013, so we're gonna do pre and post 48-hour rule. Before 2013, they had ample bed capacity, no wait lists. I remember I had someone, well, multiple people being determined as MIND, and we would admit same day. Not a problem. Now we have wait lists of 8 to 12 months for one bed. That's what it looks like now. That's our reality. They're full. They weren't full before, they're full. What I'm not getting into is how many beds they had, how many beds they have now. That is totally dependent on the resourcing that they're given by the legislature. But this is our reality. Then we go the next step. Anoka Metro Regional Treatment Center, we like in our priority admissions work, like to call it the ICU for mental illness. So it's, if you are committed as mentally ill, this is the highest level of care that you're going to go to, most likely. It's very rare that anyone would go to forensics committed just as mentally ill. You need that dangerous component. Average length of stay, multiple months, give or take. Pre-2013, most admissions came from community hospitals. And AMRTC had about 200 beds at the time. Now, admissions are only high priority. They're only coming from jails. And they have, as of the time of the slide, 96 beds. It's going to ebb and flow on any given day based on workforce, census, acuity, lots of things, but it's right around that mark. They're serving at times very high numbers of forensic patients because they can't get in here. So they have to get pushed here and they're waiting to get into forensics. Then is the least secure setting, which is still inpatient that the state operates, is community behavioral health hospitals. The average length of stay can be weeks to months. And pre-2013, there were 10 hospitals, 16 beds, 1,660, do the math. They accepted voluntary admissions. Voluntary admissions. Just doesn't happen anymore. I think we might have 5 hospitals, maybe it's 6. It's right around there, 5 to 6 hospitals now.
So this is what treatment looks like as applied, depending on if you're committed as mentally ill or chemically dependent. If you're chemically dependent and you're committed, your treatment options are far fewer. And the other thing that those of us practitioners have seen is that hospitals don't like to petition for chemically dependent individuals. And I have had cases where I basically begged hospitals to please be the petitioner on a commitment because that person was in such danger. So I think that's part of our reality, which is also sad to me, that somebody who is really, really ill and has chemical dependency cannot get the help that they need. But here are the options again, where you are going to go, depending on if your commitment is as mentally ill or chemically dependent. If you're mentally ill, you're essentially going to be in the community. That's really your option. Unless you are in jail, then you are considered priority to go to Anoka. But you're not going to stay in Anoka very long. They want to, there's the churn at Anoka. which doesn't exist at St. Peter, which Angie was saying is really reserved for those who are committed as MI and D. So there's not a lot of churn, but there is an Anoka. They want to release people so that they can open up beds and let others in. So, and it's just a massive issue.
So question online, can you explain briefly what secure means in each setting? And so I'm thinking that was on the last slide.
Yep.
And I would say secure, individuals don't have access to freely leave the facility. And then within each facility, they're all three are designed very differently, from having security measures to access to just themselves, to a small group of people, to a larger group of other people, to being able to walk around the campus. And so it depends on where they're at in their treatment and what their what the clinical team feels their safety risk is in terms of what level of security. So they're able to kind of ramp up and ramp down. But I mean, my interpretation of secure in that is they're not free to leave. They must stay within the facility.
What do you do with persons that are both mentally ill and chemically dependent? What do you do with people who are committed as both mentally ill and chemically dependent? Then the options are greater, and you would have the options that would be available to somebody who is mentally ill. They'll tailor the treatment, but you do get more options.
And I would say on a case-by-case basis, you'd have to look at clinically, what is the primary factor? What is the primary need? So is the primary need more about substance use treatment? Or is the primary need more about, say, managing psychosis in order to make substance use treatment effective? So it's going to be very individualized on what pathway, but usually they're treating both at the same time, but one is primary.
I agree with that, and I think it is mostly treating the psychosis to prevent chemical dependency. That's been my experience.
Current reality, we've talked about some of this already. To me, the big thing is time. Our mental health system is not as responsive as a person may need or expect. So time is the major factor. We've talked about other health problems, likening it to a heart condition or something like that. The time to respond and to provide interventions to the need greatly increases or decreases, depending on the time of intervention, the chance of treatment success for the individual. The longer that someone stays in jail untreated, generally speaking, treating the individual is going to be harder once they do get to treatment. If they receive treatment quickly, generally speaking, treatment can sometimes be easier than longer periods of not having that treatment. Unlike things like diabetes, where there is a blood test, there's not a blood test for mental illness. You can't just go do lab work and say, here's your diagnosis. What it takes is observation. What does observation take? Time. And that is something that we don't have. It's a super precious resource. And our system, we need to be quick to respond to the need, but we also have to make sure that we're giving enough time to assure stability. And our system is not set up to do that. It just is not. You were saying hospitals, it's to treat the acute need and then out the door.
Right.
That gets really hard with mental illness. It's not super effective.
Yeah. And on this point, on this top bullet point, that the system isn't as responsive. As a practitioner, I really see that this is where the criminal Rule 20 intersects with the Commitment Act. That is making the Commitment Act less responsive, because again, it wasn't intended for the population of criminal defendants. That was not its intent.
The other thing on this slide that we had talked about that has changed over time is the value in revoking a provisional discharge. the threshold that needs to be met from a legal perspective for revoking a provisional discharge is different than that of hospitalization.
Yes. The other
Right.
tricky part about revoking provisional discharge is that when you revoke provisional discharge, where does the person go? That's an issue, and that's an issue I know for law enforcement when they are asked to go pick somebody up on a revocation of a PD. So this is the applied piece of 253B that gets super messy and is not linear and sometimes feels like we are chasing our tails to try and do the right thing. But that's part of the problem. The threshold, legal threshold might be here, but if we don't have anywhere to send people, then we're going to analyze those situations differently.
And I think it puts, from a human services perspective, it puts our staff who are managing the commitment in the community in a very precarious position. Because their job in managing is that person following what's listed on their treatment plan, and the answer is clearly absolutely no. But they don't meet hospital level of care, and the case manager doesn't act. What kind of a risk is that case manager then taking? What is the county then taking by not legally responding as they are supposed to? And it's very frustrating then when the case manager follows through with what they need to and are ethically bound to, and there are no options.
I don't understand why there's such a chasm between hospital admission once the statutory requirement for a provisional discharge revocation is the case manager has said they're not doing well. They haven't just blown their case plan, they're also a risk of harm. And then an independent pre-petition screener, so not someone frustrated with their client, who's clinically trained, has also said, yes, risk of harm, revoke. Then a lawyer at the county attorney's office has said, legal criteria is met based on this clinical report. And then a judge signed off and said, I agree with their legal analysis, revoke, transport to hospital.
Yes.
But I don't understand, like, I mean, is there that much of a chasm between what a person sees in the community? Like, where's the disconnect with the hospital? Like, what does the hospital need, sort of a video of the person drinking bleach or whatever?
Excellent example. I mean, you painted the picture very, very well. And from what we've seen, that's what I can speak to, is sometimes we do take them to the hospital and everything is visible and present. And the provisional discharge has been revoked and they're admitted to the hospital. And everything works as it should. That happens. It's great. And then there are times that the person drank bleach, whatever it might have been, but by the time that it took to get through those steps and they get in that emergency department and they're saying, I shouldn't have done that. I won't do it again. I'm really fine. I have a plan. I have a family member that's going to stay with me. I'm good. And the doctor, that is what they observe at that time. And so they're making their decision based on what they're seeing at that point. That's the clinical decision-making.
And how much of it is a question of liability for the hospital as well?
And so the comment was, how much of it is a question of liability for the hospital as well? I will say that the doctors that I've spoken to are very clear in saying they're making their decisions based on the clinical need of the patient. The other side of me has that question. You know, it just does. It's there. It's that question's present. I don't have an answer for that. I am choosing to believe that people are making the best decision they can with the information that they have in front of them.
I think that's helpful to the analysis, though, to realize that the professionals have, like the doctor professionals and the nursing staff have a different lens, which is, and the level of care that the person needs in a clinical lens. That's helpful for me as a lawyer because I get frustrated that they're not seeing things my way. And so it is helpful to understand that I don't get to run the show.
I don't have to like it.
I don't have to like it. Yeah. Should I move on,
Yeah,
Angie?
yeah.
Okay, we did this. And
And so this one is the same chart, but just saying when there was a Rule 20 present, there's two more boxes in the front of it. Saying there has to be a request for the Rule 20 in criminal court, and then the county attorney begins the civil commitment process. So there are two major factors that lengthen that process. You will not be able to read this. I'm not expecting you to be able to read this.
This is simplified, right?
This is
simplified.
this is simplified.
this is not linear. That's the whole point of this slide.
I don't think you can see this one. It came through the chat, Angela. Have you ever encountered a situation where a local hospital chose to ignore a judicial hold order and discharge the patient from their hospital?
Yes, yes, yes.
Kristen.
Regular basis.
So this process map was put together by MACSSA, which is the Minnesota Association of County Social Service Administrators, as an educational tool. And what we had was someone that worked with counties across the state to say, what does this really look like? And what are the questions that come into play? And how do we try to capture it all, but yet keep it simple? And the whole point, it's not linear. Every single person, it's individualized. There are different factors that come into play. And when something happens, you turn left for one person, for another person, you turn right. And so those decisions are being made. Now you put in the situation that we referenced at Mayo. What happens when we're halfway through and they're discharged from the hospital? We don't even have that on the slide. So that just changes things. It just changes things.
The other thing that's not in the slide, that would make this process map look differently is the new statute, Minnesota statute 611.40, which is the statute that has the framework to treat an incompetent defendant, which was effective in April of 2024. So that also would be in this process map.
We have a raised hand. How do I do that?
Yeah, great question. Sorry, I was trying to do multiple things at once here as well. I will address the raised hand in just 1 second. We had another question come through the chat. I was
Okay.
trying to get it to the Q&A for you. When you revoke a client and they get picked up and taken to the hospital, but present as no immediate risk to self or others and no medical behavioral concerns, the hospital decides the client is good to discharge, but the judge has signed the order indicating to be held and hospital lets them go. What do you recommend?
That's similar to Kristen's situation, although this is is it a revocation of a provisional discharge? I think at that point you have to make a decision about, as a lawyer, about whether or not you're going to proceed. It becomes more difficult when the individual is in the community. It becomes more difficult when you have professionals saying they are no longer in imminent harm. So I think that's going to have to be a conversation between the attorney and the case manager, and maybe you don't move forward. Yeah.
Yep, I would agree. At least that's how we've seen that play out in our county.
Should I move on?
Yep.
Okay.
Oh, I think just go ahead. So in general, this messy nonlinear timeline. When there's a Rule 20 involved, and again, the 611 statute would, changes things. 2 to 3 months of court dates before a Rule 20 is ordered is what we commonly see or saw during the period of this draft. 2 weeks to a month before an examination takes place. So we can add that on to there. Then up to 30 days before the report is sent to the court. Then, if they recommend civil commitment, then the pre-petition screening process begins. And that takes a couple, I mean, the pre-petition screening, the hearings, all of that, we know that takes a couple of weeks. And so if they're committed, and at this time, they were waiting about 90 days waiting for a bed. Now, depending on where they're going, it could be 20 days, it could be 250 days. So that's how long we're talking. So when we say 48 hours and they're meeting that, we showed that chart, that's 48 hours when before or after all of these things are done. All of that. So I have 2 case studies and unfortunately, I was like thinking I wouldn't be able to see it. So these are 2 case studies presented by counties. And they're a little bit more unusual ones. So this shows the non-linear. Okay. The non-linear piece of it. That we have an individual entering custody at a county jail. They have.
You're good.
Serious and persistent mental illness history, and they've been civilly committed in the past. Bail was set. Court date is a month out. Then the inmate decompensates. There's assaults on staff, covering themselves in the cell, in feces and urine, refusing to clean themselves, outbursts, rants. There's all kinds of things happening. I'm sure that you guys are very well aware of that, what that looks like. There was hope that we could speed up the commitment process. And so the jail requested a Jarvis hearing to force medication. And then the Rule 20 was requested at this point. So we just talked about how long that process takes. It took this long to get to the point where the Rule 20 is ordered. So through this process, even though I said what generally takes, a couple weeks, couple months, we also had times where the person just flat out refused to do anything. So the whole process stalled. It stalled out. And that makes this even more challenging when there's refusal to participate. Or how does an examiner do an examination on someone who's completely refusing to participate? So it's, again, this is a little bit more linear fashion look, but it's a case study of a very real item. The next one, the person was in county jail for over 138 days at this point. Behaviors have been erratic since the very beginning. Lots of psychosis. Then after 138 days, then the request for the Rule 20 came in criminal court. The inmate was found to be competent. That changes things. They had additional court hearings. Then there was a second request. So again, it doesn't just go in that order that we talked about. There are so many twists and turns to these situations. I'm sure that you all have plenty of these kinds of scenarios. We're going to go into a whole section here on data. And so we have that really messy civil commitment process. And if we were to overlay it, the data that when legislators or counties or any of you ask for from the state only has data that's located over on that red box, because that's the part of this that they're involved in. They're not involved over here in the green area. And so as MACSSA, we said, fine, we'll try and collect what we can to try and get a picture. It's not super scientific, but we went ahead and collected data from the majority of counties. So we had a high majority of response. 70 some counties responded out of 87.
Angie, what were you collecting? Like the number of Rule 20s,
Yep.
the number of individuals committed?
Yes.
Okay.
So we collected data from all of 22 and 3/4 of 23, because no one could say, well, is 48 hours really 48 hours? No, 48 hours is like half a year. That's what it feels like. That's what it looks like. What is it really? DHS could never say because frankly, they're not part of that process. They don't have the data. We can't ask them to produce it. So we took data from Human Services, worked with jails and worked with courts to try and get some data. And we looked specifically at 48-hour rule data. I have a lot of data. I'm only going to show you the 48-hour relative data from this.
Right, we've seen the slide. I'm gonna skip over it. Is that okay, Angie?
Yeah, that's
Okay.
fine. So priority admissions to all DCT programs, 2023, that's half a year. It didn't just drop. That was only a half a year reporting at that point. So priority admissions are going up and up and up and up. So although the timeline in that last chart, we saw they're responsive, this is showing how direct care and treatment are admitting more people than ever that are deemed priority admissions. This one is total admissions to ANOCA. So ANOCA is generally the place where we go. And sorry, this specific data is DHS data. I will let you know when we have county data. This shows you the inverse effect that took place. People used to come to ANOCA from hospitals. Now people only come to ANOCA from jails. So you see this inverse happening. Look back to 2013 data and to 2023 data. Direct care and treatment used to treat most people who were civilly committed. So the majority of people that were civilly committed as mentally ill, so this is just committed as mentally ill data, is the blue. So of 1,644 people, direct care and treatment, so the state treated 1,467. So the majority of people received state level services. That's what we have historically been used to. The reality in 2023 is we had more commitments. We've got more commitments than ever. 2,242
Hi there.
as mentally ill, only
I'm
800
well. How are you doing today?
were treated by the DCT facility. This is the same data, but I'm using it differently. Same data as the last slide. We are relying on the community to provide most of the treatment now. When we talked about institutional level care, we were relying on our institutions, on our state hospitals back in 2013, which honestly feels like yesterday to me. 90% of the time they were admitted. And now when someone's civilly committed, as of 2023, only 36% of the time. So where is the treatment happening? It's happening in the community.
What does that mean, Angie? Does that mean that individuals stay at home and then go to appointments to be treated? Okay,
Yep.
that's one.
They're-
Do they live in, I don't know, a group home?
Yep, they may live at home, they may live in a group home, they may go to an IRTS, an intensive residential treatment service, so like up to 90 days of intensive treatment in lieu of a hospital because they were civilly committed while they're in an emergency department. They don't meet high priority criteria. They're able to be treated and discharged from the hospital to the community, but they still met that commitment threshold. And so we follow them in the community. Do you have a question?
So I know that the graphs, I think there's, looks like there's just less beds, right? There's less. That's true, but it also looks like there's a much larger number of people.
Yes,
committed.
you're absolutely.
Is there a reason like that there's seems to be such an influx of the of people being civilly committed?
So the comment was the graphs, yeah, the graphs show that there are less beds available, yet the graphs also show that more people are being committed. Is there a reason for that? Guesses?
I don't think we don't know exactly. There's no data that tells us exactly why. I think there's a number of reasons. One, I think, people are more aware of mental illness and the need, to get treatment, that's one thing. All of us are more aware of it. Okay, as a prosecutor, what we have seen on our end is an increase in Rule 20 motions being made, which results in many of those defendants being found incompetent, which results in many more referrals for possible commitment. Not all of them are committed, though. I mean, I want to be clear about that. Just because there's a Rule 20 motion doesn't mean that the person is going to be committed. We decline in Hennepin County. We get a lot of referrals. We decline probably 2/3. So, but I think that's part of the increase. COVID is probably a contributing factor.
Guidelines aren't like, was there notice in like trends, like maybe 2013, it was much. I don't know what word it's, but less easy to be civilly committed, and also like, with, and now it's a little bit harder. Or excuse me.
The other way around, I
That's the
mean,
opposite.
yeah, I don't think so. I mean, I can't imagine that the lawyers who are reviewing the cases for commitment are gonna take a different approach. I think it's volume, that's probably a piece of it.
But I think, and you're absolutely right, there's a need for much more study about this, but I mean, what I observe in the course of my job is there's been a steady erosion in support for marginalized groups, people living in poverty, communities of color, going back to the 1980 date that we were talking about earlier.
Right.
And if someone's got a genetic predisposition to mental illness and they're living in poverty and don't have any supports around them, or maybe don't even have a way to get to the doctor, much less, see a doctor on a regular basis, the chances that they're gonna, their illness is gonna progress to a point where commitment is necessary, I think is greater. I mean, there's just not enough support.
And do you think that that's by way of an encounter with law enforcement and then the criminal justice system, and then there's a Rule 20, or is that,
Right.
or they're gonna end up in the hospital, or maybe both?
Well, I think we see a lot more people getting arrested that I'm not sure would have been arrested pre-1980s.
Yeah.
Because there was more support for them
Right.
than there is now. If you're starving, you're gonna look differently at surviving, right?
Yeah, so I think there are multiple factors, but we don't have hard data to demonstrate that.
Someone ought to.
What's that?
Someone ought to study this stuff.
Yeah. Okay, Angie, Kevin, add that to your list.
Sounds good. We're on it.
It's a funding.
Yeah. All right, we got
Okay.
quite a bit more data. We have about 10 minutes.
Okay,
And I'm sorry, for those online, I have lost the entire,
you've lost the chat.
the chat is gone. I don't know where it went.
Okay.
Okay. So when I had said that, MACSSA conducted some data analysis, this is, just a sliver of some of the data, that MACSSA, put together. And so this was really done by behavioral health supervisors, managers, and there are a few key directors across the state. Matt and Fiona from MACSSA worked tirelessly on this. And so pulling this data together, we have the window of all of 22 and 3/4 of 23. We're asking for another round of data at the end of 24 now again, and we're gonna run it all again. So during that period of 7 quarters, we had 15,699 accounted for. Higher than that because we didn't get all counties responding. We got almost all counties. Total sum of days waiting in jail after meeting the 48-hour criteria. I don't have the data from before it. How many days before that? Striking number. There were 381 people or instances. Sometimes it might have been the same person in that period of time, but we're talking about humans in this. It's a lot of people. The average length of stay in jail, once they met the 48 hours was 41.2 days during that period of time. The maximum length of stay was 240. So here's where it gets kind of messy, and you can only see on the key, a few of the counties that responded. By and large, Hennepin, you win. These are the number of people meeting the 48-hour rule criteria by county. So it's what you would imagine, where you have the kind of population centers, Hennepin and Ramsey. But then we move into other counties. And some of them are kind of curious how they have high instances. So go ahead.
That is interesting.
This is the count of placement at the county of placement, county. The count of placement at AMRTC, CBHH, and St. Peter. So of those, did they get placed at Anoka? Did they go to a CBHH? Or did they end up going somewhere else altogether? Because that can happen too. And by and large, the majority went to Anoka. Some went to a CBHH, meaning they likely didn't have security concerns, their behavioral concerns, things like that. They're more easily to be managed by the time that they were ready to transfer. This is, again, broken down AMRTC, and then some of the CBHHs are listed. So it's relatively evenly spaced to the CBHHs across the state. I would say the data collection shift in tracking that occurred and that's occurring right now, which is why we did kind of like that 7-quarter period of time. We were looking at 48-hour eligible. So according to the rule, the 48-hour language prior to July 1st, in jail, civilly committed, Rule 20 finding of incompetency. Now we're tracking, and again, the words are high priority. They're in jail, they're civilly committed, and they need hospital level of care, and they're prioritized by the framework, which can include competency. This is some state data. Again, this is recent data back when we looked at what's happened since the framework was put into place. So this is data from the review panel that the state has put together for us. They overlay the 2023 referrals that are considered high priority. So they meet that priority. It was the 48-hour rule. Now it's the high priority. And what was curious about this is that in July, all of a sudden there was a huge spike in need. No, that was the definition change. That's when you didn't have to have a Rule 20 as well. So what that shows me is that spike up there in the orange is probably where all those numbers should have been before. We just didn't have, we had to count if they're Rule 20 as well. So it gets us a step closer to determining what does the need truly look like in jails. I would say if you take the jail component out of it and we just want to look at civil commitments, that number is going to go way high again. And that would be a more accurate picture about need. So when we talk at the legislature and people say, well, we don't know how many beds we need. If the state were to build something, how many would it be? We have to take this data and take it another step further. And that will help us get to that number. We've seen this one, average wait list. To me, this is the golden goose. Is that what you call it? I don't know. It's the number that you want to track. To me, is it okay that someone waits 26.5 days before they get an ICU level of care bed at Anoka? Nope, not in my opinion. I want to see that number come down. I think everyone wants to see that number come down. Everybody does.
Shall we go on, Angie?
Yep. And then these are some case study examples that the state provided to us. So the shortest wait time was 1 day, an MIND person. In a community setting, needing a revocation of his or her provisional discharge, and they returned to forensics in St. Peter. That's been a fear. Forensics is full. And what if we need to revoke the provisional discharge of someone who's MIND? That is a whole different level of conversation. And I'm really glad they were able to do it same day. I don't know how they did it, but they did it. Longest wait, 792 days. Part of the wait time, they were at AMRTC before returning to jail and then sent to forensics. So in some instances, people are being treated at AMRTC, going back, waiting in jail until a bed opens at forensics. That's a curious loop.
Yeah, we've seen that can happen, for sure.
And yeah, there's just other active wait list. So
Want me to go?
examples.
Move on?
Yep.
Okay. That's the conclusion.
So the conclusion, the 48-hour rule worked. What's that?
We have more slides.
Oh, I thought that was it.
No. Oh, no. No, I had slides to share with you. That's okay. All right. Oh, doesn't matter.
Starting to bump up against the 12 o'clock.
Yeah, doesn't matter. This is the conclusion. And since Angie and Kevin are actively working on this, I don't know if anybody has ideas. Really send them to Kevin and Angie, because it's gonna take all of us to figure out this problem, and yeah, we've got to rally, kind of circle the wagons here.
Yeah, and we'll talk about it more this afternoon. What's the solution? I don't think we have the perfect solution yet, but we're interested in the conversation.
Judge?
That last sentence, disparity in access to mental health care, do you mean in comparison to traditional medical care or based on?
The intention of that is that we still have disparity in access to mental health care across the state. So depending on where you are, you may have easier access to mental health care dependent on the type of healthcare that you need. So we don't have a system built yet where if I need a specialized type of mental health care and I am in northern Minnesota, I may not get it. Or I may only get it virtually. And I may need it face to face, or I may need it residentially, and I don't have access to it. And I might get it if I move to the metro, but I might have a long waiting list. And so I still have an access issue.
Well, and you shouldn't have to move, right?
Right, exactly.
Geography should matter. So, okay, I guess.
Question.
Oh, yes.
Question, is looking at who's tracking what? Is anybody consistently tracking how many people per day are waiting on an MIND bed at St. Peter versus how many people are waiting on an AMRTC bed?
Yes.
And is it, because that should be information for the legislature in terms of their funding.
Yes, there's daily tracking of that. That is part of our dashboard. I just did not include that slide. So the waiting lists have changed over time. It's been greater than 100 at times. It's been less than 100 at times. It fluctuates. The waiting list for forensics in St. Peter dropped greatly when they opened up a unit over the summer. So that was helpful. But my guess is it will start raising back up now.
Real quick, before we wrap up here, could you talk about the role of the dashboard of what this came out of the task force as a recommendation saying that we need to get numbers, right?
Yep.
And we need to make them available to the people who are tracking this information.
Yes.
Your colleagues, sheriff,
Yes.
others. Maybe
So,
talk a little bit what that's going to look like.
so this was really in the spirit of transparency and the fact that we can all, in our roles and as we advocate for future change, we can all do better if we have better information, better data. And so part of the priority admissions task force was to say, let's actually track if this framework thing is making an impact, and let's make the data more accessible and transparent to others that are interested in this system and that make decisions around this system. And so our first meeting where they showed us the dashboard, it was a first run at it, and they showed us a number of elements. And we gave a lot of feedback of things that were missing. And I will say the second meeting that we went to that they came back at, they did provide substantially more information. And it was helpful because it felt more real time. In the past, it was always a year old or 6 months old or something like that. It was very concrete and not easy to manipulate. I think they've taken a significant advancement in looking at that. And it really was about the transparency piece, that we need to know those things about what is the waiting list looking like, because it's so hard to say, how is the impact in my county when we don't have the data? We know what it feels like, but if we can't talk about it, both from that feeling and that data, hard data perspective, we just have a series of opinions then.
And we're anticipating that will be a public dashboard.
The hope is that it will be a public dashboard, yes.
I say we are anticipating. We are.
We are.
But I think DHS is trying very hard to provide that
They
information.
really are. Yeah, I was very impressed at the work that they put together this last
Well,
month.
folks, should we, thank you.
That's better.
So this session, a jail but not convicted, the growing backlog of people in county jails waiting placement in secure psychiatric facilities. On our panel for this session is Sheriff James Stewart and Sheriff retired, right? That's Executive Director of the Minnesota Sheriff's Association. Plus, Chris Thompson is the Cass County Jail Administrator. And Mark Maslakowski is the Stearns County Jail Administrator. And welcome, I think Sheriff Stewart will start.
Thank you, and good afternoon, everybody. We appreciate you taking the time to be here, whether in person or online, to be a part of this very important discussion. And as we address this topic that's been kind of haunting our jails and our sheriffs and many of our community partners for a long time. So I was asked to be here today just to share some observations and experiences from my roughly 4 decades in the public safety arena. And yeah, I know, yes, I did start when I was 8. Thank you for acknowledging that. But the reality is the experts that are sitting to my left and in the back of the room are the ones with the firsthand practical daily knowledge of the challenges that we're facing. So I'm going to be as brief as possible so that you can actually hear from them. Some of my observations are that as we come together to talk about this, we just need to acknowledge that this is yet another topic in which we've seen societal breakdowns or issues emerge that ultimately end up being thrown, for lack of better options sometimes, into the law enforcement arena. Law enforcement steps up, plays cleanup, does what they can with the situation, and then when it fails, we can blame, it's easy to point the fingers at the breakdowns within the law enforcement or the jails in this case. And I, for many, many years, worked a lot of different roles and responsibilities within the public safety arena. And we used to say tongue in cheek, but sadly it was true. The great thing about our job is no matter how you do it, someone's unhappy with your performance. And that's kind of another element that is tied to this morning that we're talking about. So this is a long-term problem in which the system has continued to fail those who need mental health services and are incarcerated instead of hospitalized. And we're hearing that time and time again. We have a mental health system that has not kept up with societal needs over the decades. And in fact, we saw the slides and where we're going in the wrong direction in many ways. And we're seeing individuals that are in need of mental health services that are often criminalized and left to languish within our county jails. And that's one of our biggest concerns. This is a significant issue that sheriffs have been asking to be fixed and addressed for decades. as the jails continue to deal with a situation that they're quite simply not designed for this purpose. And the facilities and the communities often pose many limitations in providing expanded services. And as you also heard earlier, jails are not one size fits all. The counties are not one size fits all. And some of these conceptual best practices that we talked about with the response model as an example just aren't realistic because the communities don't have available resources to pull off, again, what I think are good intentions, but the real world isn't always able to deliver what those good intentions would have asked for. And knowing that those baseline mental health services are what we're about, we need to really pay close attention to the black and white language of a law. And we've addressed how some of the language within the 48-hour law has been modified and the expiration of what's coming up. In simplest form, the 48-hour law has not been being followed, and that really creates some challenges. The law dictates that a person shall be transferred to a state hospital following that commitment. However, since there's often no room at the inn, as it were, pending approval of an available bed, these patients are often then left as criminals and are left in our jail cells for months on end. And sadly, these are not rare instances that we're talking about, but they become very common practice. And of course, the state of Minnesota created yet another task force to look at this problem and to try to address this issue. But to date, I would say they're having difficulty making any substantive improvements. And I would personally argue, the world according to Jim, I would personally argue that it appears more focused on liability management and or liability displacement from the state level to the county level, rather than providing the needed treatment and care for these individuals that are caught up in this broken system. So if some of the recommendations come to light, some areas could be helpful, and I would like to see that possibly be the case. In an example, the regional response teams that were designed in concept to close a gap where there are not community resources to assist those that are being held in the jails. However, the problem is still leaving them in the jails, and I'm sure you're going to hear more about that. Honestly, I'm amazed that anyone thinks that this is a fair or humane response to leave somebody in a jail cell because they're having mental health challenges. The elected sheriffs of the state routinely see the results of these individuals that are caught up in the system. They'll see the results on our streets. We've all seen the headlines of the naked individual swinging a sword and running around the street when they fell through the cracks. So when these individuals deteriorate or break the law or hurt themselves or others, the sheriffs get to see that firsthand. They see the results in our courts and in our jails. And when they're booked into our jail that is not designed, as I said, for this, nor equipped to provide proper mental health treatment services. And to liken it to something our staff relates to, the individuals that are routinely found naked, possibly covered in feces, and assaultive towards staff. Not to be overly graphic, this is the world we're living in and talking about, and everyone needs to clearly understand what is going on behind the scenes when the sheriffs say, please help us and help these individuals. And they see when the mental health system allows these individuals to simply disappear from their radar as a criminal in jail environment, rather than being transferred to a mental health treatment facility. As the caption of or the title of the entire conference today, they are jailed but not convicted, and often even already completed their local criminal processes. And to me, that seems like we're violating their rights and criminalizing their illness. So there will not be visible solutions or improvements without a willingness to completely acknowledge the problem, step one, and then rethink how we as a state do business. So the ask of the elected sheriffs around the state is to stop criminalizing mental health patients. I'm going to now ask, as MSA strives to be a part of positive solutions, some of the folks you're going to continue to hear from in our uniforms today strive to do that every day. I'm grateful for their partnership and for their support. It's my job to support them, and I'm going to let the masters and the experts in the uniforms do the rest of the talking. Thank you.
Master, what was it? Master and what? You hear that, Sheriff? I don't think I'm getting paid master level. My name is Chris Thompson, Lieutenant with Cass County Sheriff's Office, assigned as our jail administrator. I took that roll on in 2016. Shortly after that is kind of where my involvement with the mental health portion of this began. One of my staff came in and said, I think so and so in holding or in medical cell is doing a hunger strike. So I went and met with this individual. Was not that he was having a hunger strike. His IQ was too low that he didn't know he had to get up and pick his tray up to eat it. So he hadn't eaten in two or 3 days. So that's where I'm like, what are we doing here? And then over the past 8 years, it's kind of led me here. Executive director brought up the title of this is jailed jailed but not guilty. We actually in Cass had an inmate, former Olympic athlete for the bobsled team, absolute physical specimen. That's all he did is work out all day long. There was muscles coming from places I didn't think muscles could come from. We held him, but first we had a contract with Crowing. They couldn't hang on to him. I should say that I'm from Cass County, which is a very small county. We don't even have a hospital in our county. When you say we don't have resources, we don't have resources. So they sent him back to us. He broke out of our high security. He broke 3 windows that are 60-minute glazed. That we were to the point we brought firearms into our jail in case he came up, because it came to that. The solution was to put somebody that is not convicted of a felony yet in Oak Park Heights for 158 days. That was our answer. That was the only thing we could do. Because the beds are full. We hadn't gone through the Rule 20 process because he was not cooperating with it. So obviously that's the worst case scenario. I guess I should let you introduce yourself. Getting running off at the mouth.
I'm Captain Mark Mazankowski. I'm the jail administrator in Stearns County, so St. Cloud area, for those that aren't familiar with that. And I've been in my role for the last 12 years as the jail administrator. Prior to that, I'd worked through the ranks, started as a corrections officer, promoted to sergeant, lieutenant, then into my current role. So I've gotten to see that. I've been working in the jail for a little over 21 years. So I've watched this progress or process change and how we've addressed it at all levels, from the line officer working in the jail all the way to my current role. So it's been a unique process. I think when we start talking about access to services and things like that, and even in the last presentation, they talked about disparity between some jurisdictions and some areas the haves and have-nots, and trying to deliver that equitable level of services is just something that I'm not sure how we systematically can ever get there, just because of the range of from rural to metro, and getting even as simple as finding providers that are willing to live out in those areas to deliver those services is going to be a huge challenge. I know even in our area where we're only 45 minutes from the metro area, we have a hard time finding providers that want to even live in our area, much less up in Cass County or beyond. So, as of this morning, I have 2 inmates sitting in our jail right now who are in custody on lower level offenses. So we're talking about misdemeanor, gross misdemeanor level offenses, who are going through the Rule 20 process that we're very proactive on, where we're running a Rule 20 process side by side with a commitment process that we've kind of established, doing them at the same time, so that we're trying to cut down on the amount of time, the big long table of how we make those decisions of where people go. We're proactively trying to run those side by side so that we're not making it any longer than it needs to be. But we still have 2 inmates that have been in custody in excess of what they would actually serve on a sentence on a minimum level offense, who are still sitting in jail. And they will continue to sit in jail for probably another 30 or 60 days while we continue to go through that process. So we really are criminalizing mental health. And I have access to services, but I don't want to be providing them in our jail. Our sheriffs across the state are running the largest mental health facilities in the entire state. So when you look at St. Peter and you look at Anoka and the number of beds they have, our jails across the state far exceed the number of people they're serving than any of those systems are right now.
Brought up a couple of things. Why are these commitments going up, and why the increase and why the disparity? There's a few things. 5 years ago, Rick Hodgson from the MSA came to our conference, and we discussed Rule 20s, and he made it clear to us as jail administrators, you're now the interested third party. You're in charge of their healthcare. You're in charge of their meals. You can now make them recommendations to the petition screening teams, and so that might be leading to a little bit of it as jail administrators or our line staff saying, hey, we need to start the commitment process and Rule 20. So we're starting that a little bit earlier too. So maybe that's leading to some of that. But the big thing for us is in law enforcement is we're the system that can't say no. We're obligated to deal with this, whether it's okay. Beginning of my career, Andrew brought it up earlier, is, you know, we had somebody suicidal or threat. I would go sit in an emergency room for 2-3 hours with that person. And a bed was found. And I complained about that. It sucks. We have to go sit at the hospital until they, you know, now I wish for those days back, but to where we are now. And the other thing is the DOC is requiring that not only we provide them medical, but now mental health. And it's easy to say from St. Paul for Commissioner Schnell to say, hey, you in Cass County, you're going to provide mental health. Well, where am I supposed to find that? Okay, we're in Walker. We got 2 little clinics, you know, and it's near impossible. But they're requiring it, otherwise they're going to threaten to shut us down. I don't want to get on tangent of DOC.
So kind of just a little bit more backstory that maybe sets Stearns County apart from a lot of our counties in the state. So I've seen the gamut of healthcare and mental health services being provided in our jail. When I first started with the county, our human services department, our public health nurses were providing our medical care in our jail. And that was great, but those nurses were hired as public health nurses and they wanted to work Monday through Friday. And they didn't, like, they had more training obviously than our corrections officers did, but they still weren't psychologists, and they can partner with those people and they can ask questions, but they were still just public health nurses. And I don't speak that as like ill of them for just being public health nurses, but that's what they were hired to do. And that was their expertise. Beyond that, we moved into an era where we had a private healthcare provider who came in and delivered services. And that worked out okay. It was better than our public health because we now had medical services that was there 6 days a week at least. And they did nighttime, and they were passing our medications, and those services were being delivered by a medical professional and not a correctional officer, which brought us into the next era. And now, at least in Stearns County, we're super fortunate. We have a true partner with CentraCare Health, who's one of our largest medical provider in our community. They run our the St. Cloud Hospital, and they run all of our clinics largely in the area. And we've partnered with them for almost 8 years now, so that we could improve that continuity of care for patients while they were in our custody. They are able to see the same mental health professionals that they're seeing in the jail once they're released into the community. They're able to see that same population. Unfortunately, like we've talked about with this population, they continue to cycle. They see those professionals in jail, they see them in the community, and then they're rearrested and they're back in jail. But along those same lines, that partnership has allowed us to really connect in our system, our attorney's office, with our mental health professionals who are actually delivering the services, along with our private bar in our area for our public defenders, as well as our private attorneys, really to try to deliver that level of service that these people really need and get them through the process as quick as we can. But at the end of it, we can get them through that process. But where we kind of talked about here a little bit is that 48-hour rule, we're still having people that are ready to go to those services that we don't have a place to send them. And then we're still sitting on it for the next 30, 60 or 90 days. And they're decompensating while they're in the facility, and only getting worse because we can't deliver the level of service regardless of what that might be you know, we are trying, and with the legislative changes that have happened, and I think you touched on them earlier. We are probably a rarity as far as jails go, that we have Jarvis people in this and forced medications. Under the new legislation that was passed to allow us to do that. I don't want to do that. We shouldn't be doing that in jail. That I appreciate the legislative change that allows us to do that because we have people who are sick and we need to try to help them. But we're not at a service level that really can do that on any regular or long-term basis. We're doing it out of necessity right now because we have people who are so sick that they're not caring for themselves. I can't get them anywhere else. They're dangerous to themselves. They're dangerous to my staff and my officers. We have these people who we take them to the hospital for evaluations because they're beyond the care that our providers are able to provide locally. And they assault staff at our hospitals and then pick up more charges and come back into custody.
And then the hospitals say that they're not a threat to themselves if they're in custody.
Right.
I literally had one of our female inmates tell me, if you turn your back, I'm gonna kill myself. I will find a way to kill myself tonight. I brought her personally in and we sat in the ER for 4 hours and the doctor came in and said she can go back. I said, no, she can't. But she's not a threat to herself if she's in confinement.
The time that during the task force discussion when, you know, very knowledgeable, experienced stakeholder said, well, I mean, I'd much rather have them in jail than in the hospital. So that, I mean, it's some of that we're dealing with.
And we talked about earlier, when Angie talked about all of our priority admissions coming from the jails. Because we have a partnership with our St. Cloud Hospital who has this, we've actually had conversations that they have people in the hospital who are assaultive and present all of these behavioral health that they want them arrested from the hospital so they can come to our jail so that they can get into the services that they actually need, because they're more likely to get an admittance out of the jail than they are out of the hospital. So we're putting them in the justice system so that they can get the level of mental health service that they desperately need.
What would you say is the level of care that you think can be reasonably expected from jails in a situation where they have adequate funding? They can get the staffing available. So those logistical hurdles, I know
It doesn't exist.
We're in La La Land now, so this is for heuristic purposes only, so we can bracket that. So talk a little bit about, if, you know, what are the hard limits, you know, given everything that could go well, you know, when does it become unreasonable to certain expectations?
Well, the first thing is, you brought up in the opening, you know, jail is not a substitute for mental health institutions. The minimum requirements to work as a corrections officer in CAS is a valid driver's license, high school diploma or equivalent, and the ability to pass a background check. Does that sound like any nursing staff to you or any kind of mental health treatment staff to you? They shouldn't have to be tasked with that. And we are tasking them with that. And then when something happens, it's our insurance that's hitting for $2 million. Because we're the one they throw the blame in. You should have done something. Well, we've been trying for years to do something. But as far as, you can answer this law question.
Just to clarify, our hiring requirements are almost identical to what theirs are because we've been driven to the point where law enforcement can't find anybody to work. So we had a 2-year degree requirement in Stearns County when I was hired, but that has dropped to a high school diploma because we weren't getting anybody to apply for our positions, and we're paying them well, but nobody wants to work 24/7, 365 and work nights and weekends and holidays. That's all law enforcement. To answer your question, that's a moving target for every individual. So if you have a compliant person who's willing to take their medications and speak to our mental health professionals, I think that's the level where we're at. But when we're talking about somebody who's not taking their medications, they're not willing to participate in their own care, we're not equipped to deliver those that level of service. We can provide some treatment programming if we had the providers to do that. I think some of our facilities have that capability. Our current physical plan doesn't allow for that. And I think the sheriff this afternoon is going to talk about his behavioral health unit that he's building. We're in the process of hopefully building a new jail in Stearns County, and that's a large component of what we're talking about having to build out within our new facility, is a unit that's specialized and can deliver those services safer than what we can in what our current physical plan is. But again, we're going to spend millions of dollars to build out a housing unit for something that shouldn't be happening at jail to begin with. So if people are, to your question, to kind of circle back to that, if people are willing to participate in their care and they're willing to be compliant, I think that's where we're at. We're unfortunately not equipped to do a whole lot more than that because of what we have for physical plans, what we have for staffing, and all of those pieces.
You know, you mentioned that you now have the ability, if you so choose, to administer Jarvis orders in jail. And you said that that's something that you don't want to do. Or maybe feel like you can't do. Yeah. So what are the, practical logistical hurdles to doing that? Let me just preface that by saying, because I think you're aware that there are many people in the mental health community that are looking for solutions here. And one of the solutions is, providing as much mental health care as possible in the jail. And of course, the as possible is the nub there. And that's kind of what I'm trying to drill down on.
And we're trying to say it shouldn't be our responsibility. Okay, this is a state issue. The state has dropped the ball. We had the inverse graph of people, volunteering, and now it's all jail related. So that kind of demonizes, I guess you would say, since 2013 to 2023, that the jails clogged everything up. Well, no, you also saw since 1990 we started shutting everything down, and there's no more beds, there's no more beds, there's no more beds, and that's what's driving. The state isn't even providing what is needed for those in jail. We're not even talking about the general public. I mean, the ones that are sitting there committed that are not justice involved. And I think those numbers should be on the graph the next time.
So logistically, when you talk about Rule 20s for individuals and Jarvis orders in jail, we've done a couple, as I've noted. We evaluate those on a case-by-case basis. They're real individualized approaches. There isn't a, hey, in this case, in every case of a Jarvis order, this is exactly how we're going to do it. We work closely with our medical provider, our doctors, our nurses, our psychologists, all of those level of folks to get us to the point where that order is issued. Then we meet as a team and try and come up with how are we going to deal with this person? We're going to ask them, on several days consecutive to take those medications on their own. And then if they don't do that, then we're actually going to go to the point where we're potentially using force or restraint to restrain a person, to actually have a medical professional provide that dose of medication. And depending on if it's a short acting or a long acting and what their history with that medication is, oftentimes these people have a history of using those medications with success, which is, if they have that history, it means we're not going to necessarily have our nursing there 24/7 for as long a period leading up to or following that dose of medication, because the rule requires us to have appropriate level of medical and mental health services on site and available. So it all kind of is on an individual approach. The logistics of it is very, very complicated. And Kevin and I chatted a little bit about this beforehand. At the end of the day, our corrections officers weren't trained to restrain those people differently to give them medications. We don't have a different set of tools to provide that maybe a hospital level or hospital setting may have. So we use the tools that we have available to us, and we make those decisions on best case scenario, and we limit the number of these we do to the situations where we feel that if we ended up in a legal battle over it, we have a really good standing of saying this person was so mentally ill and they were in such a hazard to themselves that we'd rather defend ourselves for how we provided that care than defending how the conditions that we left them in and allowed them to continue to get worse.
Do you have information on how many lawsuits are pending or have been filed or paid out relative to things that go south when people have a mental health crisis in the jail?
I don't have that information. I'm sure I would think MCIT might be able to help us with that kind of numbers as far as that. Because I think the ultimate go south is our suicide rate. And the number of suicides that we have in our jail, because most often those people are connected with a mental health issue. Sometimes it's a known mental health issue, sometimes it's an unknown mental health issue. So I don't have a good way of putting a stat to that. I wish we did. The best I could probably tell you is probably the number MCIT could maybe handle, or Minnesota, our insurance company could probably give you a better answer to that.
So one more question is still drilling down even further, because I think a lot of people have a hard time conceptualizing what actually is going on as you're going through this process. So could you walk us through, you've made a decision to administer neurolectives, neuroleptics, you've got a Jarvis order. There's someone in a cell someplace. So what happens? Walk me through how that you get the person, you go through and so people can see what all is involved.
So to back it up just a little bit, this Jarvis order and these neuroleptics in the jail came from a brainstorming thing with the task force. We all sat around thinking, well, what can we do? The original plan for this was the DHS was gonna come in and they are responsible. They're committed to the commissioner of DHS. They're gonna come in and administer the neuroleptics, which then by the time it made it to rule was they'll provide the funding and the training for it, and then we can do it. But no, it's us bringing in a cell extraction team, because most of these aren't gonna go quietly into the night. Whether that's, they're wearing all the riot gear and all that with shields. We're gonna forcefully put them into what we term a restraint chair, which is essentially a wheelchair that's got arms and ear buckled at 8 different points. And they're gonna force the shots onto them, and then we'll have some sort of nursing staff. But when, we were contracted with a company called ACH for a medical provider for a while. And they flat out said, we're not gonna do it. You can have Jarvis order if you want. We're not gonna do it. So well, what's the alternative?
Yeah.
And they said, well, call your local ambulance. They might give it to them. So you're gonna shirk the responsibility onto an ambulance. Okay, so so might have some more to add.
The one you want to speak to, I mean, the 70% of the jails are using those providers that won't do it.
Yeah, so that's a good point. Like Executive Director Stewart brought up, is that 70% of our jails in Minnesota are contracted medical services with companies that aren't interested in delivering that level of service or don't have the capability of delivering that service. I'll take it just a step a little bit further beyond that. So you have to remember, prior to us even getting that Jarvis order, we've probably had 20 or 30 days of an individual sitting in a cell, in the worst case scenarios, naked or urinating or spreading feces on the walls of our cell. They've randomly been banging on our door. The odor in that area just emanating from that cell, despite efforts to take them out of that cell on a routine basis and cleaned it to the best of our ability and either put them in a different cell that they start that same behavior in. But we've had 20 to 30 days probably of that type of behavior of somebody constantly pounding or being disruptive to our operation. And in our operation, the only place we have for that is our intake area, which we process about 5,000 people through on an annual basis. And they're parked in a cell right across from our booking desk because most of them are at a risk to themselves or others. So they've been front and center. We try to provide them as much privacy as we can, but that only goes so far in those circumstances. And everybody has watched the news articles from Care 11 and everybody else where these people are in those cells. We've had 30 days of that. And now we're at the point where we are going to intervene with a court order. And we are going to do just that. We're going to, at least in Stearns County, we very well are gonna suit up one of our special operations response teams. We're gonna work closely with our medical. We've done it both ways where we've had, to Chris's point, where we've brought ambulance crews in, we've restrained them, we've put them on a gurney on a hospital, we've taken them to our local hospital to have that medication administered. They've sat, our staff with maybe as many as 4 or 6 officers have sat in that hospital room with that inmate for anywhere from 2 to 6 or 8 hours. And then we brought them back to the jail to accomplish that, because that's how we started, because we didn't feel comfortable doing that in our jail. We had hoped that DHS would come on site and take care of that portion of it for us, but that wasn't going to happen more long term. To where we've gotten to the point where our medical provider and our nurses have been willing to, it wasn't even in our contract for them to do this, but they'll come and the nurses will stay in our jail 24 hours, or we will have a nurse in our jail 24 hours a day for as many as 3 to 7 days to make sure that we don't have any adverse reactions to those medications, so that we're meeting statute to the best of our ability. I think that kind of answered your question.
Yeah, that's really helpful. We have some questions.
So, what would one of these other treatment facilities be able to do better? Are we saying that the forensic mental health, which it's the most secure setting, we need more of those?
Yes.
Yes.
What they do better is provide care. We're providing health and security as best we can.
But
We need,
are they gonna be, is this the example of this last person with the feces, are they gonna get any better care over there?
I'm going to tell you that generally speaking, after they receive medication, they stabilize typically fairly quickly. They clear pretty quickly. It's been our experience in most circumstances, at least with our inmate populations. So if they have that constant intervention from a medical person at the level in those institutions, I do think that they would get a higher level of care. You know, to Chris's point, we're doing safety and security. They're going to get a lot more monitoring and some tweaking of those medications. And maybe if they're not getting better on one medication, they're going to get further intervention from a doctor than what we can. Like, we'll do an initial intervention, and if it wasn't successful, we might try it again, but we might wait a week before we try that secondary intervention, depending on what our medical professionals are recommending. So I think that they would get a lot higher level of care in that environment, which is where it belongs to happen.
So a St. Peter, for example, has people with riot gear that can go in and force that there, but but then they also have
nurses and doctors.
regulars.
Yeah.
I don't know if I would characterize it as riot gear, that I'm using the same equipment that the law enforcement uses, but yeah, they have protective gear. I think that one of the big differences is that, you know, you're providing intensive crisis level treatment, trying to stabilize an acute person, and you know, they're getting that round the clock, highly trained psychiatric care. And, you know, they have people who, and you know, and it's tough for them to get these people too. That's one of the biggest challenges to expanding is they have a lot of money. They still can't get the staff, and then the highly trained staff to do this kind of intervention are difficult to find. But nevertheless, you do have trained people who do this kind of thing very frequently. I mean, this is what they've been trained to do, and they're in an environment that they can then provide the services there. Once you get a neuroleptic, and correct me if I'm wrong, but once you get a neuroleptic treatment, if you're just hoping that works, right? And then, you know, you do have mental health services that can follow a person, but there's not the level of care that you would give at a psychiatric hospital. Is that fair to say?
Hospitals very good, but you're not going to get hospital level care in a jail. And there is adverse, there's allergic reactions, that can go wrong. They got to be monitored sometimes up to 3 days after they're.
That's an interesting question. You know, if something does go wrong during one of these things, what do you do?
Well, in Cass, they're going to take a 35-mile ride to the hospital, the nearest hospital.
Is that typically where they have in Stern as well?
Well, we have a hospital a lot closer than.
Yeah, right, but not-
Fortunately, we're probably 6 or 8 blocks from the hospital.
You take them to the
but-
hospital, you can't provide high-level care.
Correct, correct. We've been very fortunate, knock on some wood, that we haven't had a situation that's met that where it's went adversely. But yeah, they're gonna, we do oftentimes with these situations, we'll bring an ambulance on site for a standby service because we want to be prepared for that situation in the event that it does go that way. But yeah, they're still going to outside services at that point, which ultimately, when we're talking about that, puts our community at risk. And we talk about public safety, we talk about the safety and security of our folks, we talk about the safety and security of the people working in the ER. Anytime somebody leaves our facilities, the escape risk or elopement risk is significant, which then, at least our jail is between us and the hospital is a highly residential area. So obviously, if that person was to get out of the ambulance or out of the car, it puts the community at risk, which is obviously our number one priority is public safety. So.
Just from your lens, I know you probably don't see these people a lot of, as they're growing up, for example, but just from your own lens, could these folks that you described have perhaps not reached this state if there were some lower level treatment available earlier?
Well, being I do come from a small county, I've been here 27 years. I have watched these kids. I've coached these kids. I've two of the people that I've coached in sports. Yes. Yes, they could have, but that's a question. If it's a genetic predisposition or it's their living situation, or in our case, it's a lot of drug-induced psychosis from severe abuse. If we had the resources at a younger age, or they had those things to fall back on, yeah, probably. But at this point, we're just mainly just trying to demand that the state build the infrastructure needed to deal with this.
Because I think the question is gonna come up, which infrastructure? I think a lot of people are gonna say, well, we need one of those group homes, but that's not a setting for the examples that you gave. And so I'm just curious where some of these conclusions, we still have a lot to talk about today, but.
So when you bring up group, okay, so these settings that when we close down our institutions and then they spread this money out to these group homes, private group homes, we've got 32 of them in the south end of our county. Yeah, so provisional discharges, they end up there. And then they act up and that group home calls 911. We bring these people to jail. This whole process started that they had to held the chart over. It all starts over again. So now they're in jail for months and months and months to start the Rule 20 process, to start the commitment process, all this over again. So
To answer your question.
Sorry, go ahead.
So to answer your question on that, yes, I think we see, could there be earlier interventions? Yes, I can tell you from looking at our registers from Stearns County back to the 60s, we see a lot of the same names involved in the system, be that because of mental health issues or because of social determinants or some of those other things. And I think we're systemically trying to do better and try to find better ways with that. In Stearns County, we're participating with Minnesota Department of Health for a Parenting Inside Out project to try to educate parents who are incarcerated how to be better parents to their kids out in the community right now, so that hopefully we don't see Junior in jail down the road. And I help those parents identify the mental health issues that their kids are having or that they're seeing in their kids. So hopefully they get them the services and some of those things at a younger age to hopefully prevent them from coming into the system, and also getting the help that they need at those lower levels of mental health care than they do when they're an adult or in crisis.
Question over here.
We have a question from online. How familiar are individuals with the jail consultation team that the Forensic Mental Health Program, DHS, that has been created this summer? It is not a fix to the problem, but the concept is good. They did, however, not hire anyone with jail experience. They hired from within. Happy to send information on this team to other jail individuals and to hold DHS accountable.
I'll just the last sentence and you can do the smart stuff. I would love to see MDH held accountable. I stand firm that this is a management issue since COVID has begun. Everybody went through hiring crises with COVID. Throughout COVID, after COVID, we had to raise our wages, we had to raise our benefits, we had to do something to get those staff members in the building. I don't find it an acceptable excuse that management, in this case, the MDH, has not done that. If I wouldn't have rehired corrections officer, the sheriff gave me my walking papers. I just don't understand how the Department of Health can be ordered by a judge that this person is committed to your custody. So the Department of Corrections, when a judge commits somebody to the Department of Corrections, I can put them in a car and drive right to St. Cloud Prison and drop them off. They can't say no. They ask for 24 hours to get their paperwork in order. That's great. We'll see you tomorrow. I don't understand why it's different here. And I've had a couple of attorneys try to calm me down, but I think at some point we have to get to that, to where they're held accountable. If one of our judges gives me a lawful order and I pretty much thumb their nose on, aren't going to jail for contempt. I'm not saying we got to arrest certain people for contempt, but maybe threaten it. I don't know. So go ahead.
I'm familiar with what was formed. We have not had a great deal of interaction with them because we have built some processes that we follow. I was disappointed to hear that they didn't include any real jail experienced individuals and they hired from within, but at the same time, I'm not sure that they would have gotten anybody to move from the jail side to that, just given the history and the issues wrapped around this issue, because I think it's a volatile area. And I'm not sure that people from the jail would come in with views that would concur with what they were looking for, which is probably part of why they didn't hire anybody from jails. But yes, I'm familiar with it. I think that there's some room for there. I think that until we get a better feel for exactly what they're going to do to help us, until we have some some reference materials for other jails, especially the smaller jails that maybe don't have services in their areas, to reference of how they actually helped and was it successful and those things. I think they're going to have a little bit of an uphill battle because a lot of us are a little bit suspect about what they hope to accomplish with that.
Go ahead. Yes.
On the construction of your new jail, I don't know if you're able to talk about this, but does that new physical plant, would that have like an integrated treatment milieu in it for the services of people with mental illness, or what does that look like?
Largely, it's going to have support areas to allow for better service or delivery of services. So bringing in a lot more when we start talking about construction and those units, we're talking about more access to natural light. We're talking about more direct access to those providers, additional programming spaces to deliver those services and have providers able to deliver that both in this intense unit as well as delivering services out in our general population units. So physical plant wise, yes. And then obviously support areas. You can't ask a mental health professional to come work in the jail and not give them a space to work in. We do it right now. We don't have adequate space for that. Fortunately, we've gotten a lot of support from our commissioners on the matter and their willingness to invest in those areas because it's not inexpensive space. When you're talking $600 and some a square foot, and you're talking about a facility that's 530 some thousand square feet, and when a whole housing unit of 30 beds is going to be used for that. And then we're talking about small sub day rooms so that we can still get them out of cell time and meet all of our other standards that go with that set by the Department of Corrections. There's a lot of components that have to go into that, but those are the types of things that we're looking at is how we can deliver that. But also at the same time, we want to meet that standard of increase our ability to deliver those services to them, but also deliver a higher level of living environment for the rest of our population at the same time, so that they have access to more natural light, that they have access to more day room space than what the minimum requirement is, because we recognize that that will ultimately lead to even those that aren't being treated for acute or high level of mental health. 60 to 75% of our inmates in our jail have mental health issues. We're talking about high level in that 2 to 5%, but we want to do what we can for the other 70% that are in our general population.
Sure.
Yeah, it's more of a comment that, to answer your question, it's 21 lawsuits in right now. And when we talk about wait times and what.
Speak up a bit, Chair.
Sure. When we see the wait times that are out there, like 64 days, or the highest that the state has is 842 days. That's when the commitment kicked in from the judge. That doesn't count the 1 to 3 months that it took to get the evaluation and all that done. So there's even more time that's not even shown. And that's a big problem. Talked about that. And we currently just switched to Itasca County, who put in the jail and who has a dedicated psychologist and 6 mental health beds. But if we utilize them, we pay an additional $81 a day on top of what we do. That's not financially supported by DHS. No, they're committed.
Commissioner Clark?
I don't know if you'll be able to hear me back here. Great presentation. I happen to get to work with Captain McCaskey. A couple of things. One is, this is almost all driven by DHS, not MDH. Although we want to get MDH involved, we might get some additional better outcomes. So we should talk about that in addition to the children of incarcerated parents. As it relates to whether it's a current or a new jail, these should be DHS's, the state's patients. We are holding the state's patients, and no matter what we do, whether it's Itasca or Stearns or Lewis or anybody else, we just need to make sure that everybody gets, these are jails, not treatment facilities. Very thankful for the work that's happening, but I get worried the state is gonna turn around and just say, oh, see, the county's just got it covered.
Well, that's a great point, because they're committed to the commissioner, DHS, for care and treatment.
Exactly.
And they're being held in the jail,
At a very
waiting
young
for
age,
that.
That's what they need.
Yes, go ahead.
I'll just add a couple of other things that we're trying to, county, and we're trying to push more services into the jail. And there's a few things that we're running into as we're trying to contract with providers. One is more and more malpractice insurance companies are refusing to cover people who are providing services in a jail setting. So that's not helpful. The other piece is that, with the exception of a possible new waiver that might be coming down the road, and I think that the counties are part of that process, you can't bill insurance for, you can't bill somebody's insurance for services that are being provided in the jail. So all of that is coming directly, it's a cash payment, and you're usually not paying, MA rates for a provider to come in and do that. So there's real costs to this. And, in addition to all the things that, yep, jails are not places for people with mental illness to be. But it's adding to our problems system of trying to figure out how to push care in, that at least supports people until they can get to the care they need.
There's a lot of discussion about trying to move as much of the treatment response to jails. And at some level that makes sense, but I think what we're talking about here is that there's a threshold of what's possible, even under the best case scenario. In the discussion, you essentially say, well, either we're going to turn jails into quasi hospitals, or we're going to turn hospitals, into we're going to fortify hospitals and turn them into quasi jails. And so, the logical thing is, well, there's got to be a facility in the middle that can do both, and that's what we're looking at in whether it's state hospitals or community-based care. Is this idea that there are especially well-suited places for people to go. But one of the things I found really interesting is during our task force discussion, there was a lot of talk about what jails should be doing. And a lot of the hospitals were complaining about the aggressive behavior that they were experiencing. But I didn't hear a lot of discussion about, well, is it more cost effective to provide additional security measures, infrastructure to a hospital where they have all the other care necessary to treat someone who's undergoing these kind of crises than it is to try to bring the mental health element into, into the jails. And I think that's for people a lot smarter, than I am to figure out, but I do think it's what's good for the ganders, good for the goose, kind of in my sort of primitive way of thinking. We've got a couple minutes left. Any additional questions, comments?
I would throw another comment
Yeah,
out.
please do.
So it kind of struck a nerve to say, we want to make jails more like a hospital or hospitals more like a jail. I think there's a distinctly different approach to a secure mental health facility versus a criminal environment of a jail. And that's something we really need to wrap our head around. It's not about you can't get out the door. It's about what is the purpose and the intent of the facility, meaning criminal containment and incarceration versus a treatment facility. They might both have the same locks on the doors and might be the same vendor, but the purpose is dynamically different.
And we have to, hate these words, separate these people from general population. So imagine how good solitary confinement is on the mentally ill, and the deterioration it's immediate. But we can't put this person in general population and have them victimized either. So as far as the hospitals and jails or jails and hospitals, I think there's a statute that says the state has to provide state operated beds and we should follow it.
General, just ballpark guess, or maybe you have a number of the inmates that you're responsible for that require medication of any sort. Perhaps it's just routine, or maybe it's really mental health. What percentage of your inmates in your facilities require some medication?
So in CAS, it's nearly all. And that's usually, our probation director a few months back said that inmates leaving the Cass County Jail are the healthiest they've been in months or years. They come in, we make sure that they're back on their meds, they're eating properly. But, and we've gone it one step further to try to bring mild medications in for opioid use disorder. And now, just like Carver County said back there, insurance companies are trying to quadruple the insurance on us because we are using it. I mean, this is a medication proven to help withdrawal and coming down off of opioid use disorder. That alone will kill that program statewide, because I mean, it was quadruple or more. I think it was in actually Carver County is the one who brought it up to me, because they had scrapped the program, or one of the counties had to scrap the program because they weren't going to pay the exorbitant amount of insurance to do it.
About 90% of our inmate population's on some form of medication. It might not be for mental health reasons, but I would say about 90% of our inmate population is taking medication, with about 65 to 75% of that being for mental health purposes. That number has moved. The targets kind of changed. COVID changed our inmate population dramatically. We had a much different mix of inmate population prior to COVID. We had lesser offenses, less serious offenses in our custody. That was maybe the one upside to COVID for us. We have a lot more of the people that were actually, to coin our county attorney, that we're actually afraid of out in our community, in our jail now, than we did prior to COVID. But yeah, the rate of medication for whatever reason is significant. And to the comment from the Carver County, I would love nothing more than to figure out the insurance piece of having people's medical benefits cut off when they come into custody, and then that gets transferred to county expense, and then trying to get them reconnected to services when they get back in the community is a giant hassle. Also being able to continue to bill those services to those insurance providers down the road, I think would drive up some interest maybe in the medical industry to be interested in providing services in the jail if they knew they had a collection. Centric Care in our case has been very willing to do that because they see the savings on the other end, because we're delivering services to the same population. So while we pay them a contract to deliver services in the jail, what we're paying them maybe at best covers their costs for the delivery of those services, where they're realizing their savings is they're stabilizing that population, they're getting connected to services so that they're seeing those doctors in the community. And in year one, we had collected some data, best case scenario, our ER probably saved $5 million by being in the jail and delivering those services at the jail. So that's where those medical providers are seeing it, but you have to find the medical provider, because I know I've had several medical or other counties reach out to you like, hey, would CentraCare come provide medical services in our jail? And in our discussion with CentraCare was, no, we're not interested because we don't deliver other medical services in your area. Like they did it, they were delivering those services in Benton County Jail before because they had the St. Cloud Hospital and they had the infrastructure there. They're currently providing them also in the Wright County, but CentraCare has a clinic in Buffalo, where Wright County is. It has to fit their business model of what they have to be able to see the other end of how providing those services are benefiting them, which they're a company, they want to, I understand that too. So, you know, I've had a couple of other jails where Essentia is the provider in the area or some of those other health systems, to get them interested and get them to have that same level of partnership, they have to come to realize that they can save on their bottom line somewhere else.
But I think, I'd just like to make one observation here, point of personal privilege, I guess, is that the more I've gotten involved in this issue, I have to say that I've been, not surprised, but really encouraged to see that, you know, the folks in law enforcement that are on the front end of encountering, you know, people who are in the throes of a mental health crisis, and then the folks that are responsible for their care while they're in jail. This is not only, I think, a frustration professionally because the system isn't working. I see that a lot of people are personally frustrated on a human level, that people, that there's nothing they can do. That the extent of what they can do is put someone in a solitary cell and wait it out. How long do you have to wait for the cavalry? I don't know, but I think that's a big frustration. And so I appreciate the time here and the work that you do.
I would just like to thank everybody in the room for taking time to come today, because looking at your agenda and all the subject matter, it's great to have professionals out there seeing it from your perspectives too. And we couldn't do, at least in Stearns County, what we're doing without our partnerships from Commissioner Clark in the back of the room, but also our county attorneys, because it is a system, it's a justice system. I'm not fixing it at the jail level, you're not fixing it at the attorney level. It requires us all to partner to do that. So I really appreciate everybody in the room. So
Just to see the multiple disciplines.
Yep.
That's the only way it's gonna get fixed.
So we're gonna transition now into our next session, which is what I'm looking forward to, and that's talking to some people who have real lived experience and hear their stories about what their experiences they go through really difficult time. Angie?
Thanks. Thanks, Kevin. All right, it's all queued up if you want to set your stuff there and then. I am gonna go further. Okay. Okay, what, that sounds good. All right, the next section is about stories of people affected by mental health challenges and their experiences with law enforcement. And so as Kevin said, this is part of our session today, where this morning we talked more of that technical legal side of things, talking about the reality within the jails. Now we're going to talk about that, I'm going to steal his word, the human side of this. What does that human impact look like? What does it feel like? And how does it feel from that family member perspective as well? And so I'm very pleased to have Dawn Saxton here. She traveled from Otter Tail County here this morning, and she is here to share a story about her son. Welcome, Dawn.
So do I have that slideshow, and is it available here?
Okay.
I'm gonna just motion them down. Okay, great. Okay, cool. Okay, can you hear me okay? Okay, great. So my name is Dawn Saxton, and I'm here to tell you a little bit about my son's struggle with mental illness and his involvement in the legal and mental health system. I have a couple disclaimers. Like one, I'm a mom, so I'm here as a mom and not professional. And I also want to share, this is my first time really telling Gavin's story in front of an audience, unless you consider my support group an audience. It's very interesting to hear the discussion this afternoon, and I think Gavin's story, it touches on a lot of things that people talked about. Just first of all, this is a picture of my son Gavin. He's 27 years old now, and he has a diagnosis of schizophrenia. Just a little tiny bit about schizophrenia. It's a very serious illness, as you know, and a lot of people with schizophrenia have delusional thinking. They are sure of some ideas that are very unrealistic, or they have hallucinations where they see and hear things that don't exist. And these things are very, very real to them, and they can be very scary for the individual and for the family. Symptoms vary, obviously, from person to person. Just some like examples of delusions would be, like thinking aliens from another dimension are trying to kill you, or people are communicating with you through the TV or the radio. Overall, people with schizophrenia, when they're treated, on meds, stabilized, are not violent. But of course, when things get off kilter, they can be a threat to themselves and others, as you know. But I think it's always important to know with proper treatment that individuals with schizophrenia can lead normal, healthy lives with some supports. Someone asked about like kind of the causes and would it be helpful to have early intervention, and that is the case with, I think, a lot of illnesses. I think the tricky part with schizophrenia is sometimes you don't see any symptoms until late teens, early 20s. The person can be just sailing along, easy peasy, things are going pretty good. Some of the causes are genetic, of course, and that was touched upon. And in this case, it is something that runs in my side of the family. Trauma could be drug-induced. Those are all factors. Scientists still really don't know what exactly causes schizophrenia. Let's see, I'm just gonna zip through some just quick childhood things. We're gonna zip through these very quickly, but this is Gavin when he was a baby, a normal, healthy baby. Let's see here, I'm gonna just see where I was going here about this. Okay, this next one, so my husband, Chip, and I, and Gavin and his older brother, Sean, we live just outside of Ashby, Minnesota, in a small town in west central Minnesota, population 500. As a family, we just spent a lot of time outdoors doing fishing, camping, swimming, all that kind of thing. This is a picture of my son and his dad, and I just want to mention one trauma in my son's life is his dad passed away unexpectedly when Gavin was 11. And so that's just been something that's been hard on him and our family. He attended school in Ashby, a very small town, or 20 in his graduating class. He was a very good student, very involved in activities. He played football. There's a little football picture of him. He's in track. There he is on the right with a lot of his very good close friends. He had just a really good group of kids to hang out with in Ashby. This is a picture of me and Gavin. After his dad died, especially, Gavin and I just were really close. It's just the two of us. He really always worked hard at school, tried to make me happy, tried to make me proud of him. Early symptoms were, when he was, I would say the spring of his junior year, he would come home and he would just put his head down and cry because he was just so overwhelmed with the day. He started thinking that he could hear what everybody was thinking, and it was just, he couldn't concentrate, he was anxious, he was worried. I didn't know what was going wrong, but I knew it was very, very different than his normal, personality. When he was a senior, he ended up being hospitalized right after school started. He was hospitalized for the first time. He got on some medication, Risperdal. He got, when he was discharged, that the rest of his senior year, I'd say went really pretty well. He had some teachers who were really helpful. His science teacher just kind of took him under his wing and made sure that Gavin checked in every morning, and it was pretty good. Gavin's been ill for a decade now, so, and I can't go into detail about a lot of this, but, I just want to say over the last decade, he's had some periods of stability where he's been able to live and work in the community. Other times he's become very ill, requiring involuntary hospitalization. We've gone through the commitment process 3 times. And he's received follow-up treatment, care. He's been in facilities. What would cause a decline? Sometimes it would be that he didn't think he needed his medication. Sometimes the side effects were terrible. That was a problem. He wasn't able to keep taking that medication. Sometimes the medication just stopped working. We didn't know what was going on. Also, someone mentioned drug-induced psychosis. Gavin has had issues with marijuana usage mostly, but other drugs as well, and that has always made things a lot worse for him. He has gone through chemical dependency treatment, and he has gotten good support through like the Narcotics Anonymous program. He's been clean for quite a few years now. When things would start to unravel, I would, pretty fast sometimes, I would definitely need the assistance of a lot of people in this room, law enforcement, social services, ER. We spent lots of times and, sometimes hours, sometimes days in the ER. Probation officers. A lot of Gavin's delusions over the years have involved religious themes, like thinking, it's the end of the world, things about the Antichrist, aliens, that type of thing. One time he thought that the rapture had already happened and that aliens had replaced the brains and the souls of the people that had been raptured. And so he thought, everybody was acting weird because of that, which you can imagine how scary that would be. And also how scary that was for me to have that happen. There's lots of different things I could share, but, and some of them are personal and I almost hate to share them, but I just think they're good examples of how real these things can be in their brain and how they can act on that. One time he was convinced that the Antichrist was living in Osakis. I need to drink water for this one. He ended up leaving the facility where he was at. It was 20 below zero. He just had the clothes on his back. He had his phone, but he got scared. He threw his phone in the snowbank. He ended up stealing a car. He ended up we didn't know where he was for a couple days. It was very scary, so he knew he was making really outrageous decisions about things. And then I'm just going to jump ahead to a little over a year ago. Gavin was living in an IRTS facility, intensive residential treatment. he was under a commitment, so he was there on a provisional discharge from, and so he was still under a commitment. And he was doing really well at this facility. In fact, he had met his goals, he was stable on meds, and plans were in place for him to be to go to a board and lodging care where he would really, he'd have kind of his own living space and be able to still have some supports available, but hopefully we get a job and you know, meet some new friends. We were quite excited about that. That was just a little over a year ago. You know, we went shopping, got all the things he needed, a new bike, you know, so and then for whatever reason, and we don't really know why exactly, but we just started to see some symptoms that we hadn't seen for a long time. I saw him regularly and I just could tell things weren't right. He started just getting really paranoid, thinking somebody's gonna try to kill him. Then he wasn't sleeping at night, so then just kept getting worse and worse, you know, just his paranoia was up. And we, at first we thought maybe he's just anxious about this move, you know, of change. He sometimes changes, they're hard on him. Then we thought, well, is he using drugs? Because this just doesn't seem right. And, sure, you know, he had a drug test that came back negative. So we were just super confused by why he was just this escalation. But anyway, what ended up, we later did find out that a psychiatrist who had seen him, a new psychiatrist, saw him and did a med change. And we do think that might have had something to do with the change, but really no one really knows what exactly went wrong. But what ended up happening is he started believing that his roommate was the Antichrist. And so last year on November 27th, and that date will just forever be in my brain, he attacked his roommate with a pen. He attacked him, he stabbed him with the pen, and thankfully, you know, the staff were right there, and he, no one was seriously injured, but Gavin was charged with attempted murder, and he was, and he went to the Otter Tail County Jail. Well, then, once he got to the Otter Tail County Jail, he still was quite aggressive. And there was talk about that too, how hard that is in the jail. And so, you know, he's thinking the Antichrist, that, you know, there's a battle out there and he's fighting it. He also thought the Antichrist was responsible for killing his dad and was out to get the rest of his family. So, and, you know, you could just imagine the heightened, you know, how that went. He ended up having 2 more assault charges. I think on the first day he got to jail, he hit one of the, actually, I don't know why, they put him in a Bible study. And he hit one of the other inmates over the head with a chair. And I actually talked to the jail chaplain. He said it was horrific. So, I mean, it was not a good deal. And then he also hit another staff member over the head with a lunch tray. So as a result of that, he went back to the holding cell, which of course is the only safe place for him. I did totally understandable that he need to be in the holding cell, and I just realized I'm not keeping up here on my. Oh, this is one of the stories I didn't tell you, but anyway, this is Gavin and his grandma, and I was going to tell you more about that, but we'll skip that one. Here's the holding cell. So he ended up in this holding cell in Otter Tail County. And, you know, as you can see, very small room, just a bed and sink, toilet there. Just had one small window facing the hall. You know, so we just thought that was just gonna be very temporary because he was under a commitment still. And in fact, 2 days later, there was a court hearing and everyone was in agreement that he needed to be back in the hospital. It just seemed like slam dunk, you know, obviously it was due to his mental health, needed to get back into the hospital. Due to the seriousness of the charges, though, the only hospital that would be able to take him was Anoka. So, you know, I understood that. But they were full, of course. I feel like I remember during that hearing, there was some discussion about the 48-hour rule that, okay, you know, soon he'll be transferred. So that was, I thought, the case. You know, every couple days I'd stop over at the jail, see, you know, any progress. I just keep hearing, well, he's on the waiting list. I wasn't able to talk to Gavin on the phone or visit him when he was in the holding cell. Apparently that just for safety reasons, they weren't able to get him out to make phone calls or could have privileges they considered family visits, library, snacks. And as you can see, there wouldn't be much to do and not very much interaction from staff. You know, you get your food on a tray through a little slot and eat by yourself. And I just can't even, when I see this picture, I just don't even, I couldn't imagine being there. I'll tell you, he ended up being there for 107 days. And at the time, I mean, I don't know what I would have thought if I would have known it was going to be that long, but every day just was a challenge for me to think of him there, I guess. I wanted, eventually, he did call me. And I remember the first call I got was on, December 31st. So it was over a month. I hadn't heard from him and I saw somebody call. I didn't recognize the number, but I answered the phone and Gavin said, "Mom, are you okay?" Which that was his main concern, wondering if I was okay. And I said it was. I asked him how he was. He said he was okay. And he just really wanted to reassure me that it wasn't that bad. I remember him saying, "Don't worry, Mom, it's not more than I can handle." So I think he knew that I was thinking it wasn't a very good deal. Then after that, though, I was able to talk to him on the phone regularly, and we communicated through the mail, letters. I just was gonna quick read the first letter. It's very short that he sent me. I think it kind of says a lot about the time in the jail. Says, "Hey Mom, I'm writing to these from you," or what? "Hey Mom, I'm writing this to you from one of the holding cells. So I get to watch people come in, and it's nighttime of day 43, and everything is going okay. And I think they're talking about sending me to Anoka. I did a Rule 20. And I've also started a new med called Depakote for bipolar. It's a mood stabilizer. I've been drawing, reading, and listening to some good audio tapes about Apache, Cherokee, and Ojibwe tribes. I think they are inspiring and the food isn't that bad. So just know I'm doing fine and waiting to be transported. Take it easy. Love you, Gavin." That was day 43. Oh, while he was in there, I just thought, I didn't know how he would ever get out, you know, I did hear there were 300 people on the list at Anoka, 50 from jails. And I wasn't hearing that the list was moving. I started contacting legislators, local, county, state. Every day I thought of somebody else I could talk to, call. I didn't know who the wizard was behind the curtain. I mean, I just didn't know who makes that call. You know, I tried to tell people, isn't it more, you know, he's he can't be in the general population with, he's very ill. And this is making it worse, him being in solitary confinement. But I really truly to this day don't know who made the call, but one day on March 12th, I got the call that there was an opening at Anoka, and oh, I have 1 minute. Well, this is fine. We're winding down. He's at Anoka. He went to Anoka, and I'm going to just show you a picture of Anoka. This is Anoka. I want to just show you this contrast here. It's just pretty incredible. Really, it's safe, it's secure. He's getting good psychiatric care there. Just like somebody's mentioned, people are trained to, tweak medication, make sure that he's safe. There's lots of central area out there to be able to walk. They said he walks more than anybody. He walks like 10 miles a day, they think. So he's out there walking, playing basketball, lifting weights, reading books. Just so much more conducive to mental health, obviously. So I guess I probably skipped some things, but my time's up. But I just want to thank all of you. I think that these conversations are important. I do think that we can do a lot better job. Thank you.
Yeah.
You want to
Welcome.
stay
Sit
here?
here, sure, sir.
I'll let you introduce yourself.
Angie, I'm Chris Martin. I'm the chief deputy from Clay County, Minnesota, over where Moorhead is. But we're right next to Cass County, North Dakota. Don, thank you for coming up and sharing your extremely personal life experience that you had. I do have a question for you.
Okay.
Instead of having you wait and listen through what I have to say. During your experience with this, was there something that the jail could have done different, or do you see things that you could recommend? Because you do have some jail administrators in the audience right now.
Well, how does this
You're
work?
welcome to stand up here.
Oh, services in the jail. So I do want to say, I think the jail did the best they could. I really do. And they did feel badly too, that this was what had to happen here. And they were as happy as I was when there was an opening. The medication thing, I think, is a little tricky because I think, as you can see, if Gavin would have had some really bad side effects, that's not the place you'd want to be. You want to have and he has had some very bad reactions to medication. So I think that would kind of depend, but the medication. But I asked Gavin, I told him I was coming here, and we talked a little bit about his time in jail. And I asked him what he thought would help. And I wanted to share this, so I'm glad you asked this. He said, if people would take time out of their day to talk to the person about what they want for their future. So I think just some conversation that would have helped more. So, yeah.
Okay, I just wanted to start off by thanking Kevin for reaching out to Sheriff Empting and extending an invitation to come down here and speak with you all. I think for too long, and the sheriffs and attendants can correct me if I'm wrong, but we felt like we were on our own with this, that we were having to deal with the mental health issues and treatment at the jail facility. But being here, listening to the other presenters, seeing who's in attendance, it seems like there's an agreement that the jail should not be the primary mental health provider, that we cannot criminalize mental illness. We cannot criminalize it. Our people inside the jail will be the very first people, the front line to testify. If you need someone to come down to the state and testify, they will be the first one on board to do that. They see it every day, they work with it every day, and they try to help them every single day. But to have a group of people inside the room that are in agreement with us, it's reassuring to us. But we need capacity. We need DHS to stop having the meetings, stop talking about it, and we need action with it. And the action should have been coming 6 years ago when we started no longer meeting the 48-hour rule. When we were over that, that's when it should have happened. Or maybe even 2008 when task force were starting to form. That's when the action should have happened after those formed. For us to be talking about it at 2024, we're way behind it right now. And we got to get out in front of it. My time is a brief time with you. I have a case study to talk about what a specific individual is experiencing within our facility, some delays with DHS, and how those have led to him deteriorating even more. And he's in more need now than he was 2 years ago when he first started coming with us. So coming to us. So I'm going to talk about that. If there's questions along the way, go ahead and speak up. Angie, one thing that you mentioned in your presentation was that you showed numbers from throughout the state, and you talked about Hennepin County and Ramsey County being high. And then there was number 3 on the list, which was Clay County. And she's like, I don't know how to really attest to that. Well, Clay County, we're a medium-sized county. We got 46,000 people in our county. But that doesn't count that we also have 250,000 people that live within 10 miles of us. 250,000, plus we have another 30,000 that go to college in Fargo-Moorhead. So we're over 250,000 people. That's where we're getting our numbers from. Not from the college students, but from the population density that we have in our region. And that's where it comes from. So to start off with, we have an individual that is 26 years old, and 26-year-old when an offense was committed. In 2021, he first came to us for a brief period of time. He was arrested on a strong arm robbery while he was in custody with us for 16 days. He had violations, property damage. He also formed a shank out of something that he had found within the jail setting, and he came after COs while he was in there. He was tased during that brief stay before he was finally sent back to, or extradited back to California. So we had a sense that there were issues, there were violent tendencies and mental health issues before he came back to us. It was over a year later in 2022 when he was arrested in Clay County in Moorhead, Minnesota on November 27th, 2022. His arrest was for a misdemeanor offense, domestic assault. While he was in custody for a short period of time, he was uncooperative with staff, refused to answer questions, and then started refusing to even speak with our staff. Within 2 days, as is normal, he was released from custody and put back or let back out into the public. Before he was released, our jail did as they always do. They notified the victim that he was being released. 5 days after his original arrest, on December 2nd, he was arrested in Wapaton, North Dakota, after allegedly committing a homicide in Moorhead, Minnesota. He had issues down with Wapaton. He fought the extradition to Minnesota. It was approximately a month and a half later before he was finally extradited back to Minnesota. So he arrives at our facility on January 17th. And due to our previous encounters from the year prior, and that he was having very odd behaviors when he arrived, again, not speaking with people, not completing the intake, he was placed in our mental health unit on protective custody status. Important to note that initially, for the first 4 or 5 months, we didn't have a lot of problems, a lot of issues with him, more so than some of the other inmates. But for him, we didn't see a lot. He was quiet again. He wasn't talking and did a lot of hand signs gesturing with staff, but not communing straight up with them. And because of his offense and his mental health, he went through the commitment process, which took a period of 9 months. Because we talked about it a little bit earlier with specific dates, I looked it up just to see what his timeline was. So in February February 13th of 2023, the court ordered the Rule 20. There were several assessments that were done in between there, evaluations, some motions by the county attorney, but from February 13th, 2023, the court finding incompetency was on September 13th, so 7 months later, and then finally on October 26th was his warrant of commitment. So approximately 8 months later, there was a commitment for this individual. I had in there 9 months, so we we're a little bit shorter than that period. I documented just some of his actions that were taking place inside the jail. And you'll see that they continue to escalate over the time that he's been with us. But these are just some of what's going on. So when he originally came in, he was with us just for a few days in the pre-booking area. And then it was determined that he was going to be housed in our mental health unit. That unit has more intense therapy or treatment. We have anger management treatment, exercise therapy, trauma-based treatment, one-on-one treatment is allocated to them. There's eye movement desensitization, but all the treatment in the world, if the individuals don't want to participate, it's not going to help. And you can imagine with this individual, he chose not to participate with any of these. So do we end it there? No, we continue to try to revisit those treatment models to see if he's willing to participate with very, very limited luck up to this point. You can see that we're having staff meet with him. Our mental health staff specifically are meeting with him. They're logging concerns throughout the period of 2023. He's disruptive enough, so tasers are being used. He's saying that he's going to be hurting staff. He wants to chop them off at their knees, talking incoherent at many points, covering cameras, kicking doors, self-hurting, very odd, peculiar behavior. He will be somewhat stable at times, and we move him back into the mental health wing, and then other times he has to go to our special management area where he's by himself basically. But when he does better there, we move him back into our mental health to try to give him the options and the therapy that, or not therapy, but some one-on-one work that will help him out. He passes almost on all of that. He continues to threaten staff, shoot and bury them, saying he's going to hurt them, kicking at them, kicking his door, threatened to shoot staff again in the face. He attempted to escape at one time, got out of his cell, was running around the unit, actually jumped off a portion of the unit that was only 6-7 feet tall. He wasn't hurt, but it took several staff to get him back into his cell and get him restrained. His behaviors continued to escalate, and he had to remain in the holding area. He often would tell staff that something was going to happen before it did, like he's going to go for a ride today, or you better look out today, which would precipitate his actions. As we moved into 2024, now the commitment has come. He was committed. The commitment came on October 26th, at which time he'd been in our facility for 8 months. By January, he'd been with us for a year. So January of 2024, he's been with us for a year, but just recently having been on commitment. We're still waiting for a bed for him. He's having issues, not sleeping, pacing in the cell, throwing foods. He attempts to overpower and assault staff on several occasions during the year of 2024, more so than what I even have on the board here. And I'm not going to go over all of them, but threatening to bomb the facility, which we knew he didn't have access to that, nor did he have access to a gun when he was saying he was going to shoot us. But that was all part of his mental illness, his mental health, that that our COs and staff were dealing with and continue to deal with his outbursts and further attempted assaults and actual assaults on COs, grabbing them, trying to pull them through the food slots, grabbing at their tasers, trying to disarm them of tasers and further injure them, threatening to stab them and hurt them. So throughout it all, he remains with us. He's still in custody with us. He has been sitting in our jail now for 385 days since being committed, mentally ill, and being dangerous in our facility. So we talked about some other numbers, 240, 250 days. He's one that's at 385 days. He refuses all intervention from our mental health unit. Staff continue to try to offer those. And imagine if you're working in the jail, if you're one of those COs, or you're one of those treatment providers that we contract with. We have Lakewood Mental Health that we contract with. They're continuing to try to do these interventions with him. And the answer is always no, or the action is always a return assault on the COs. But they don't give up. They continue on with it because that's what they do. That's their responsibility. We take our responsibilities very serious. We've reached out to DHS several times. We've been told there's lack of space. We've been told multiple times that he's next on the list, that they're working diligently to admit this individual, and that his priority level to get into St. Peter is as high as it can be. Multiple times we've been told he's next on the list. We had another commit that was August 6th of 2023. His was August 26th, or not, I'm sorry, October 6th, another commitment. His is October 26th. Our October 6th commitment got down to St. Peter June 30th of this year. We're now 5 months past that. We're still waiting for this individual, 385 days as of today to get him in there. He needs clinical intervention. He needs to be someplace other than our facility, not only for his own sake, but for the sake of our COs as well. It is only a matter of time until something happens where he either hurts himself or he hurts one of our staff members. It will happen. And it's not because we're not taking precautions. We have multiple COs that move him around. But for those of you that have ever had to be in some type of an altercation with either somebody on the street or somebody in the jail, it's difficult, and people sometimes get hurt, and we do not want that to happen. Our staff are tired. They're frustrated that they can't help him out. They're frustrated that he doesn't accept the help. And they're very frustrated that they feel that DHS have left us out to hang dry on this, that we're responsible for him, and that when it's on their time, they'll take him, but not until that point. And until then, we're responsible for treating him inside the jail. We are not a mental health institution. We're there to keep his safety and security. And it becomes even harder every day that he's there. The longer he's there, the harder it is for us to do that.
Sure. So what's his mental, I know we gotta wrap this up here, but what's happened to his mental health condition during the time that he's been there? Has he worsened?
Very much so, noticeably.
Talk about that a little
And
bit.
that's why at the beginning of it, we talked about first 5 months, very, very little. Not, he still wasn't talking to us a lot, but very little of the outbursts, the self-harm, the harm towards COs getting worse and worse. And I don't think it's going to change. But the bigger picture, it has to change for all the commits. We have to have DHS and we have to have Governor Walz specifically say, this is an issue that we need to address. We need to allocate funds so that capacity is increased, so that we no longer have jail sitting on these individuals for 365 days, 150 days, or 50 days. Those are all too long. These facilities are not built, and our staff, frankly, are not trained appropriately to be mental health providers, all of them 24/7. They just really aren't.
Right, thank you.
Yeah, that's all I have right now.
Yeah, is there, I mean, I think we all recognize that the impacts it's having on the people waiting, but have there been studies or research on the vicarious or secondary trauma of the COs who are watching these people languish for a year without care?
We haven't done that. I don't know if there is, but any person working in the jail that has empathy, which we expect, want, require from our staff, it has to have an effect on them.
And are you losing staff?
Jails lose staff all the time.
Right.
Law enforcement agencies lose staff all the time. They are very difficult jobs to work in, with sometimes the jail staff very little reward. As an officer, as a deputy, I'm out in the public, I see and hear, I get thank yous from people all the time. When you're working in the jail staff, your thank yous come from the letters that come back from the inmates when they're leaving, saying, hey, thanks for getting me into this class. Thanks for helping me out with this project that while I was in here. Thanks for helping me get my GED. But they don't get a lot of those. So yeah, I'm sure they're leaving because of that.
Yeah, I wanted to say, I was at a conference, a national conference last year of judges trying to look at this issue and talk about this issue on a nationwide basis. And a judge there from LA County, I was sitting next to me and I said, oh, I've been meaning, I want to come out and see your facility because your jail is the largest provider of psychiatric care in the state of California. And he's like, don't, it's horrible because we are expecting COs to do what a mother would hope their son, to provide the care a mother would hope their son would get from a psychiatric nurse or a social worker. So don't come out and see it. It is not what we should be doing. It's a horrible outcome. So having you two speak together has been very powerful.
I would just say, let's not categorize our facility like that, because I think we go above and beyond. I think we were state of the art when we built it 6 years ago and added our mental health wing to it. And we've had multiple other offices come up and look at ours to include Stearns County, just so they can see the concept that we're providing.
And I'm aware that locally, we also get really good care. It's not the right place. Just to highlight your point, it's not the right place for someone to expected to get better. And that's what our system should be delivering.
Thanks, Judge.
Thank you, Chris, and thank you, Don. This was a very important segment for today. Because as I said before, we can talk statistics, we can talk all of the technical side of things, but what really matters is what's happening within our families, within those that we love, and within those within our community. And I think it just gives us more fuel for continuing to move forward with this. So I really appreciate those very real examples.
So you can see I flashed up our break. We still have 2 sessions to go, and in my humble opinion, they're really worth listening to. So let's take a 5-minute break, and if people have to kind of straggle in after we get started, so thank you.
Yeah.
All right, folks, let's get started. If there's anybody outside in the hall that you know, come on and grab them. Let's do that. We're running a little bit behind schedule, but
I don't even remember.
thanks for sticking around.
Here I have a slide.
So
I might have to go back.
all right, we're gonna start now. The title of this session is Court Actions, Defense, Offense, and the Likelihood of Successful Litigation. And we're packing a lot into this, but I know this is one of my main interests in this particular topic, having been a litigator most of my career. Yeah, so I bring that. On the panel here, we have Dan Gustafsons, who's at Gustafson Gluck. Christy,
Caribou.
That's easier than I thought. Who's an assistant county attorney, and Susan Herlovsky, who's an assistant Hennepin County public defender. I'll just start by saying that, once you get your post-commitment order, and you watch your client sitting in jail, and they're committed to the care, custody of the commissioner of DHS, and they're not getting that. They're not just sitting in jail, they're not going anywhere. The thought comes up, well, maybe I ought to do something. And one of the things that has been across people's mind, being lawyers, is we can bring a court action. We can get a concerned judge to take a look at this and then force DHS to put him in that facility. And that doesn't always work so well. So maybe, Dan, maybe you could give us a little state of the situation we're in now.
Yep, thank you, Kevin. Well, before I start on that, let me just say that, this is a problem. This is a mental health problem that is pervading our state and communities right now. It's a serious problem and it needs attention. So I hope all of you, if you take anything away from this today, I hope all of you would make an effort to talk to everyone you can, whether they be political leaders or others, about finding a solution to this problem. As you heard in the panel before, our law enforcement folks work hard to do what they do, but they're not equipped to do what they're being asked to do now because of the problems that we have. And so while litigation is one way to press on those who make policy, it's only part of the problem. We need to sort of stand up and say, this is an issue that needs to be resolved statewide, countywide, citywide, everywhere, so that we can get a solution that's a workable solution for the long term. So my firm has been involved in a bunch of litigation. And what I say to everybody when I start is, the first question you have to ask yourself when you're going to litigate is my goal here to get my client placed, taken out of the jail and placed in a healthcare facility appropriate for her needs, or is my objective here to change the system? And along the way, the third question, of course, is, should I have a claim that ultimately results in damages? But let me talk a little bit about the several approaches. First of all, I always think that your first obligation to your client is to get them someplace safe, right? Get them someplace where they're supposed to be, and get them in a healthcare facility appropriate for them under the jurisdiction of the state as the law requires. And that sounds easy, but it's not. You have several claims that you can bring. You can bring a procedural due process claim. As most of you know, there is almost no process. In the beginning, no process at all. These people were committed. They were returned to jail after the commitment order was issued. At the time this started, the 48-hour rule was in effect. The state essentially ignored the 48-hour rule, and your person would linger in jail awaiting action. You'd file an action and you'd bring like a mandamus petition or a motion for preliminary injunction. But what happened was there was no procedure in between the commitment order and the decision not to transfer them, right? So your first claim is, look, you got to give my client notice and an opportunity to be heard that you're not going to transfer her within the 48 hours. Or now under the amended statute, which you've been talking about all day, the 48-hour, now the medically appropriate bed, you need to give her a notice and an opportunity to say why she can be transferred, or if she can't be transferred, what can be done in the interim to minimize her injury, right? So preliminary procedural due process, very good claim right off the bat. Two things. If you make a claim in Minnesota State Court for a constitutional violation of preliminary procedural due process, the Minnesota Supreme Court has not recognized a claim for damages, right? I think that they will someday, and I think that this court that currently is sitting is a good court to try that theory on. But there's a half a dozen Court of Appeals cases that say the Minnesota Supreme Court has never recognized a claim for damages for a violation of Minnesota constitutional right. Okay. There's a solution to that. You can allege a 1983 claim, 28 USC 1983 claim, 42 USC 1983, right, which provides a right for damages for federal constitutional violations and can also be litigated in state court, but most likely the Attorney General's office is going to remove you to federal court. Why is that a problem? Not at all, except for that removal process takes 2 or 3 months by the time the case is removed to federal court and the federal judge is assigned and he or she sets a schedule for the briefing on your motion for preliminary injunction or your motion for mandamus. And by then your guy has been in jail already 3 or 4 months, right? So adding that federal claim for damages or adding that federal cause of action almost assures you that you're going to be taken out of state court into federal court, and there's going to be a significant delay. So if you want to get quick action, forego the claim for damages, bring the writ of mandamus, bring the motion for preliminary injunction for procedural due process violation, and you have a very good chance of getting a court to act quickly on your motion. What's the problem with that? The state comes in. Now under the amended statute, it's much more complicated because now the medical appropriate bed has become part of the statute. Beforehand, it was just a straight 48-hour rule. So you just say, hey, 48-hour rule, they violated it. The state would come in and say, we don't have a place to put them, right? In law school, I would hear all the time, that's an easy answer. The 48 means 48, you win. But in reality, as you all know, judges are people too. I've had them look at me and say, what would you ask me to, what would you ask me to do? Should I tell the state to kick somebody out of the Anoka Regional Medical Center so that your client can get put there? Or should I tell them to, buy a, building tomorrow that's suitable? I mean, right? It's a problem that can't be solved immediately. And then along the way, on a related but separate problem with the sex offender program, the Minnesota Supreme Court issued the McDeed opinion, which was a little different. It wasn't following a statute. It was following a rule, a court order. So the court had ordered them to transfer a person from Moose Lake, the high security facility, to St. Peter, the low security facility, and they didn't have room. So they just ignored the court order. It's the same kind of thing as the 48-hour rule. Instead of ignoring the statute, they ignored the court order. And finally, the Minnesota Supreme Court said, no, you have to follow that court order. But then they put in this phrase, within a reasonable time, right? Which doesn't seem unreasonable to me, but that issue within a reasonable time has now been 2 years in litigation about what a reasonable time is. And of course, the state is arguing we don't have the space for them. So is a reasonable time the time that it takes the legislature to appropriate money, build a new facility, hire new staff? That doesn't seem reasonable to me, right? But reasonable has become the test and may very well become the ultimate test here in litigation. So that's kind of an overview of litigation. But what I would tell you is that there are all sorts of claims for substantive due process, intentional infliction of emotional distress, things like that you can bring. But I have come to the conclusion in my little experience with 6 or so of these cases that an immediate motion for mandamus and an immediate motion for a temporary restraining order or a preliminary injunction ordering the move based on procedural due process is the fastest way to get a court to rule on whether your client has a right to be in a mental health facility under the law. So I'm going to give you one analogy, and I'm going to talk about one thing that happens. So I had a federal case about this MSOP problem, the sex offender problem, high security to low security, so not exactly the same. Court order, they were routinely waiting 600, 700, 800 days before they transfer these people after the court order. So my client, we went to federal court, we moved for a temporary restraining order, converted to a preliminary injunction because the state responded. Judge Thunheim ordered them transferred within 7 days. They defended on the ground that there were no beds. Ordered them transferred within 7 days, and then miraculously they found a bed, right? So then they say, okay, Now your case is moot, right? So I find another guy who's on the list, right? Because there's a waiting list, right? And I make the same motion and I get the same answer and I get the same result. I get them transferred, but I'm not actually changing the system, right? That has not been the case in the 48 hours, not quite as quickly as it was in the federal cases with the sex offender program. They were because he ordered them to transfer them within 7 days. The problem is that the state is intentionally mooting these cases so that they can push this issue down the road for another day. You know, you have the argument, it's not technically moot because you have the argument that it's capable of repetition, right? It's the same rule that was born out of the abortion cases back in the 70s. The problem is that your client has now been moved. And so one of the things that you always have to consider is, I think the sheriff was talking about earlier about how people are getting moved out of priority on these lists, but that's the sort of lay of the litigation. I think I now have about 5 or 6 cases that are pending. They were consolidated in St. Paul, and the judge there, I'd remember his name if I thought about it a little bit, but he stayed everything pending the appeals of the early cases. And so there's appeal on the mandamus issue, and there's an appeal on the on whether this federal court has jurisdiction over state mandamus petitions. So everything is sort of at a standstill, and as we know, the problem continues, no end in sight.
Thank you very much.
Yeah.
Let's see how you want to progress from here. You want-
I'm happy to go first since my step is then before the commitment. If that
Okay,
makes
yeah,
sense.
sure, go ahead.
Okay, so I'm Susan Herlovsky. I'm with the Hennepin County Public Defender's Office. I've been there forever, but I have been doing, I've been on what we call the Rule 20 or the competency calendar for the past 6 years to address all these folks that are coming into court that essentially are getting to the commitment. So the issue being, if you do any criminal practice as a prosecutor or a criminal defense attorney or someone on the bench that deals with criminal cases, you are part of this. Because if there's ever a scenario where a competency motion is made, where there's concern about a client's inability to proceed and have meaningful conversations with their counsel or assist in their defense, and that is threaded and connected to mental illness and or cognitive impairment, that incompetency finding that could come later is what gets our clients to this commitment door. There's also been changes in that process. For the longest time, Minnesota Rule of Criminal Procedure 20.01 was the rule that everyone utilized in sorting out what the requirement was in finding incompetency for either a defense attorney or the prosecutor or the bench to be making those motions, the process for how the examiner would come to their conclusions, then offer the opinion, and then ultimately that incompetency finding. As of November 1 of 2024, Minnesota Rule of Criminal Procedure 20.01 has now changed. And it is fashioned to be really pretty consistent with the new legislation that became effective April 1 of 2024. That's 611.40 through 611.59, which is essentially the new competency statutes moving forward. The idea, or one of the most significant changes, really with changing the Rule 20 before and after November 1, is language in that when someone was found incompetent, it used to be that the court must make a referral to pre-petition screening, which would mean a group of social workers and pre-petition screening in part of that county would get together, make a determination within 5 days if they believe that it should be forwarded to the county attorney's office to seek a commitment for some sort of petition or a petition for commitment. Those petitions can be mental illness, MI, they can be mentally ill and dangerous, MIND, they can be chemically dependent, CD, they can be DD, developmental disability, or some combination of those. And so it used to be that there'd be an individual who'd be found incompetent. then a referral would be made, and then there would be some delay to see if a commitment was going to issue. So now the language is may, that the court may make a referral to pre-petition screening. I don't know that we know specifically what that means or how that's going to change things. One may result in less commitments being sought by the county. The other, I suspect, is more people trying to utilize Minnesota statute 611.40 through 5.9 to essentially be now what used to be the commitment process. Within that statute, it talks about restoration of competency. It talks about assigning forensic navigators to support people in the community to get the services they need to be restored to competency. It talks about timelines, many review hearings in regards to assessment reviews. Lawyers can make the request of them, forensic navigators can make the request of them. And the scenario moving forward is, what is the statute or our new commitment process going to look like? It used to be with the commitments that if someone was seeking a Jarvis order or an order to force medications to a criminal defendant, there'd be the process through the commitment, through certain hearings and requirements.
Let's do it.
So there's a new portion of the statute which allows motions to be made, including by a prosecutor, to seek that order. I haven't seen that done yet, but there is real change within that statute in how this may look moving forward. Things to consider about this is that when the incompetent finding is made, the criminal case is suspended. And as I explain it to my clients, it's as if we're taking the criminal file, we're putting it up on a shelf, and it's going to be reviewed in about 6 months if they're found incompetent to see if they've been restored to competency and will return to the criminal track or will remain in the realm of more mental health. So in this scenario, if someone is confined under pretrial confinement, this becomes the issue. And how does the criminal case, and how is that impacted by commitment or by this new statute? What's worth considering in this process is just a reminder that when we're looking at people that are found incompetent, the majority of those cases are cases that are pre-trial, that the only determination made by the court at that point is whether or not this probable cause standard is met to charge. That's typically it, which is a pretty low bar. And in that scenario, if someone is incompetent and is now confined, and even if they're committed for significant periods of time, as a criminal bar, we can be making motions because even though the criminal case is suspended, both the continuing rule of 2001 and the statutes in 611, they do authorize motions to be made where the court does have authority and continue to have authority over bail, condition of release, and any other orders that they see fit. We in the criminal bar can make challenges and can be raising issues as should bail remain? Should bail be lifted? Should a client no longer be held on a criminal case when they have been found incompetent? Does it violate equal protection? Does it violate due process to continue to confine and pre-trial confine an individual who's incompetent, which only threshold standard that's been raised is probable cause? So one of the cases, the most helpful cases that I provided is Jackson v. Indiana, which is the United States Supreme Court, where the idea there being that for the court to consider if someone is going to be detained, there's two things that are important. One is that someone who has only had the essentially test of probable cause should not have less rights than someone who's been able to go through the criminal court process, be able to raise motions, challenge evidence, challenge for suppression, have sentencing hearings, ultimately have a plea or some resolution. But someone who's incompetent and held on probable cause shouldn't have less rights than someone who's entitled to that whole process. So that's one thing to consider when we're thinking about length of detention of this pretrial detention. The other piece that Jackson also addresses is someone can be confined, but there has to be demonstration that there is a reasonable connection to the restoration of competency within a reasonable period of time. So again, we're using this word reasonable, which is difficult because what is reasonable for someone who is incompetent that's in a facility? Because a reminder that incompetent isn't an unwillingness. Incompetent isn't a choice. A finding of incompetency is where a psychological examiner, a professional, sometimes a psychiatrist, a forensic examination has been done. There has been an opinion of incompetency, and either the parties have agreed to that, or there's been a hearing where the court has found that and found that the individual that's now being pretrial detained is incompetent and unable to have meaningful discussions with their lawyer or make reasonable decisions. And sometimes that can be difficult because as I was listening to the deputy who spoke before, and I thank deputies all the time, because when I go to meet my clients in the jail through the mail slot at their door, and the deputies say they won't allow me to go meet with some of my clients without them being present, the deputies are always saying, can you help this individual? We don't know how to help this individual. Can you get this person to a hospital? How can this be done? And it is difficult for everyone, but it's also difficult for our clients who I understand in some circumstances have been charged with serious crimes. That is not missed. And the scenario though is this is still an individual, a human being who is sitting in the square, cold, hard, loud room 24 hours a day, especially when we talk about putting folks in protective custody. That typically means SEG, which means they're not getting out of that room. And I appreciate that jails and deputies want to talk about how they want to make things available to our clients in those facilities, but they're choosing not to, or they're refusing. I want to remind people, incompetency is not about choosing or refusing. It is an inability. I often, when clients want to better understand what this means, because many clients worry that incompetency means someone saying they're dumb or something really negative. And I try to talk to the client to say, this is where your own brain is betraying you a little bit and not helping you get to where you need to go. And so the goal for everyone is to get the treatment for you. So
I have a question.
Yep.
Is the new rule resulting in situations where the courts don't enter a commitment order and so these people are further in limbo?
I would say I have not yet seen, so far, referrals continue to be made, at least in Hennepin County. There are times, and I'm sure we can hear in a moment how when there are declinations to move forward and why that is. To date, I have not seen them not make a referral to pre-petition screening. I expect that will be coming in the future with this new change in both the rule and the statute.
And then where does that leave people? I mean, it's like they're incompetent to proceed with their criminal case, but they're not being committed, right? They're not being referred for the committing, so they're in limbo between the two of them. Is that what we see coming?
Yeah.
No, I would say no.
I would say in many of those instances, those folks are released from custody when there is an incompetent finding and a non-commitment. And that was the idea in the new legislation on assigning forensic navigation, but yep.
Yeah, you're right, Susan. First thing I'm going to offer is a glimmer of hope, is because I was involved in that competency legislation process, as were several people in this room, and it also felt like moving a mountain. But that was, people can complain about the legislation and be unhappy with pieces of it, but that mountain was moved by a consensus bill that was supported by the Public Defender's Office, the County Attorneys Association, NAMI, the sheriffs, so everyone got on board to fix it, and that can happen here too. But it can happen. And so what I say about the people lamenting in jail and lingering in jail is the initiative for that change, at least from a county attorney's perspective. My name is Christy Caribou. I'm in the Hennepin County Attorney's Office. I've been a county attorney almost my whole career. the impetus was that we were seeing individuals in the situation you've just mentioned, Dan, coming to us on commitment referrals because they're found incompetent and not meeting commitment criteria, which meant nothing was happening for them. And so the competency statute was drafted and enacted, and the legislature has spoken that those individuals deserve treatment, but within their criminal file. And so that is why the criminal file now has control over their conditions of release, court-ordered treatment, medication, if it is deemed necessary by the court. Those things are happening for that population. I know our focus today is on the individuals under commitment orders and still being held in custody, but I wanted everyone to remember that glimmer of hope is it can happen, and I believe it will happen. As far as the Rule 20, I had 3 things I wanted to talk about. First was the echoing and highlighting the amendment to the Rule 20 of the court may refer individuals for civil commitment once they're found incompetent. Honestly, that was a slip when the statute was drafted and enacted. We kind of forgot about Rule 21 saying that you must make commitment referrals. There's this whole statute now that says what to do with someone when they're incompetent, but there was still this rule. And so the rule change was made for those people who do appear to meet commitment criteria to a judge in a criminal case. They should absolutely refer them, but they no longer are mandated to make those referrals. It is important to note from my perspective as a county attorney and those doing my practice, I think we petition 1/3 or less of the commitment referrals that come to us because they simply do not meet criteria. And so that is why that statute will take over.
So can you, for me, maybe helpful for others, can you explain the 2/3? Those are findings by the judge that this person can't participate in his criminal case, but you don't believe they're meet the criteria for commitment. So that leaves them back in the community.
That's exactly the struggle we had, Dan, is that these individuals were found incompetent to proceed, not necessarily mentally ill, not necessarily a risk to themselves or others. That is not the court's analysis on incompetence. So then when you get to civil commitment, we're forcing a square peg into a round hole, trying to get these individuals help if we can, but not being able to meet the statutory criteria you heard about earlier this morning. And so the competency statute was to address that population and no longer have them falling through the gap, which is what you heard in the news all the time. That was what that was meant to address. And it is obviously a work in progress with a tremendous amount of infrastructure that still needs to be put in place to make that a useful statute. But that law exists, it's progress, and the change can happen here too.
Okay, I don't like to minimize these kinds of things, but are we talking about something like commitment light here? Like these folks need medical treatment, they need help, they need counseling, they need things, but they don't need to be committed.
Yes.
Right? So we need that infrastructure to be added?
Yes. So civil commitment is not a great thing for folks. It's one thing to be incompetent in a criminal case or to be convicted of a criminal case. It's quite another burden to bear to have been civilly committed by the court. And so, yeah, they're separate analysis. And the statute was created to address that population that for years and years had been left out in the cold. Will there be constitutional challenges? I'm sure there will be. But at this point, commitment referrals should start to focus on individuals who truly need treatment under a commitment act, rather than individuals who can be treated through a criminal file, if that makes more sense.
And so to both of you, maybe, what percentage of these 2/3 of the folks that don't satisfy the commitment criteria, how many of those are staying in jail? Right, where from my perspective, there's the worst, I'm not you guys, but from my perspective, the worst outcome is leaving them in jail. So how many of that 2/3 are staying in jail awaiting something?
So I can't give you a number. And as I'm thinking about it, I'm seeing like 8 different pathways. I mean, there are folks who are incompetent, who are not committed, and typically then I'm making, or my colleagues are making an argument that someone who's incompetent can't just sit in the jail and then should be released. And the majority of time that happens. However, there are instances where incompetent people then are put on conditions. And if there's allegations of violated conditions, which in some instances is EHM or electrical monitoring, and someone ends up back in jail because someone didn't know where someone was for a bit, and now that person's sitting because someone's saying, I'm not sure where they should go. They're not under commitment, so there's case management that's not working on them. They're in custody, but the bail remains. And so that is a percentage of some of the population. There are also instances of individuals who are in custody, found incompetent, committed, sent to, say, AMRTC. You guys, I think all know that acronym right now. Okay. And so then AMRTC says this person no longer meets hospital criteria. We'd like to send them to a community-based program. And if bail remains, then that person, instead of going to a community-based program, comes back to the jail where there is no one to do programming planning. And then that person sits there and we have months and months and months in hearings about how that person shouldn't be held or continue to be confined. So there's numbers and there's a number of different pathways. I don't think the majority, though, of incompetent folks who aren't committed are in custody. I think that is a minority of the population.
Yeah, and that gets tricky because, of course, not much has changed about their situation with respect to public safety and the bail setting in the first place, except that a commitment wasn't filed. But moving into
Can I
kind
just
of,
take one break here? So
Yes.
Kara, there's a hand up here. So do I let them talk or how do
I'll handle.
you handle it? Yes, that's a good idea. I'll try to ship it across here.
well, speaking of like what we can do in the meantime, as Susan's indicated on the back end of folks that come back into jails after they've been committed, that's a communication issue. Is the prosecutors need to be communicating with the commitment attorneys, the defense attorneys on the criminal side should be communicating with the defense attorneys on the commitment side so that people can make factually correct arguments with respect to bail. And oftentimes the commitment attorney, even if they're from the county attorney's office, are probably an ally to the defense position on that case to help explain to the prosecutor or the court, this person has completed an IRTS program. They are doing well. They should step down into a group home. This probably mitigates your public safety concern. And usually a solution can be crafted. So in the meantime, as practitioners, I invite everybody to communicate more. The other thing, if we can move to that slide about the notice, the other thing that's happening now in light of the new 48-hour rule is there's notices coming out to meet Dan's point and his legit concerns about due process. These are new things coming from DHS that are hitting the commitment files. This is a letter sent to the committed person, I believe through their commitment attorney. It also goes to the county attorney's office. Of course, it's in the district court, and it goes to social services. This is, in my reading, an invitation. What they're saying in this letter is that this individual has been reviewed for priority admission and that they should be going to Anoka Metro Regional Treatment Center. But later in the letter, yes, please. There's an offer to provide more information. Any interested person may provide additional information or request updated priority status for your referral. So my thought is time to see how meaningful this is. Provide the information, make the calls on all sides. If you're a criminal defense attorney, send information. If you're a respondent attorney on commitment case, send the information. If you're a case manager, if you're in the jail, if you're recognizing that this person is suffering, send the information. I don't yet know how meaningful this process is, but when Dan goes to court later on cases like this, it's going to be real nice for him to be able to show that efforts were made to provide the notice to DHS and to request something different than what's being given. So that's something new I saw and something I think is of import moving forward if you want to make a difference in the short term.
Shall versus may. Does that mean that someone is determined to be incompetent, the case is dismissed, and then they're set free? There's no commitment.
Not necessarily, no. It depends on the level of offense for one thing, and then yeah, the other thing to bear in mind is we're looking at incompetence. And again, I know the focus is on committed persons, but incompetence can be a lot of things. You can be incompetent because you have dementia, but you're well cared for at your home by your significant other.
Not a danger.
Yes, that is a ridiculous commitment referral for the court to make. And so that is why that rule change is appropriate.
As I understand, when I listen to it, they're trying to avoid the situation where the judge is forced to put somebody into the committing process or into the committing queue when they're clearly not somebody that needs to be committed, right? That there's an alternate path they should take. It doesn't really affect the question of whether they should be free or not because they're a danger or not. That's a separate question that's handled on bail, right?
Right, it would,
But they've committed a crime with no consequence.
well, so in that scenario, if someone is charged with a crime, we don't know if they've committed it. We know they've been charged with a crime. And what we're talking about truly is a level of probable cause. And in practice of, in defense, there's a lot of instances where people are charged and those cases are later dismissed, whether people are competent or not. So a mere charge of probable cause doesn't always mean someone has committed the crime. But in following up your thread there of then incompetency finding. So with the new legislation, that the only cases that are being dismissed and not that many is some misdemeanors. They now have a list of targeted misdemeanors that even with an incompetency finding, those cases aren't being dismissed if the prosecutor is filing a notice of intent to prosecute when there's restoration. And that can continue for a year. For gross misdemeanors, that can continue for 2 years. For felonies, that can continue. At this point, I have an incompetency case from 2004. So in thinking about they're just going to be dismissed, that has not been the main practice of the way these cases are handled, I would say.
The flip side of that too, by the way, is many of these people who have previously been referred to the commitment proceedings, since there's no beds to go to, are actually spending more time in jail than they would have if they would have just pleaded guilty to start with and got their 90-day sentence. They would have been kicked out without any of this stuff. I mean, the cycle here is broken. And you're listening to two people who have very good ideas and are working towards solving those problems. But imagine being charged with a misdemeanor where the most you can be, is it 90 days?
Yep.
Misdemeanor, the most you can be sentenced to is 90 days. And you stand up to say, I'm guilty. And the judge says, no, you're not competent. We're going to put you in the jail. We're going to send you into the queue to be committed. There's no beds. So you're put on hold and everything goes. And you end up spending 6 or 8 months in jail, when the most you could have spent was 90 days, right? And so this may versus shall is one good solution in which we can say, this is not a person that needs to be committed, right? This is a person that doesn't fit the commitment criteria. So it's progress.
And that's fair. There are a number of instances where people do spend significantly more time confined, pretrial detention, than if someone had been competent and pled guilty and had been intentionally committing that crime. There are a number of people who have, through both their secure confinement in the jail and secure confinement in the hospital, have served more than 2/3 of a presumptive sentence, some beyond the maximum of a sentence. So, and yet criminal court jurisdiction remains. So there is, there's quite a window of how criminal court jurisdiction continues over these folks who are found incompetent because of their inability to be part of the system and make the decisions for their cases and work with their lawyers.
One of the other things.
Flip side to the flip side is that there would be a public concern that this will be used to reduce the pressure on the system that we just learned is under a great amount of stress for certain amount of crimes that may on their face be not as harmful as some trespassing, domestic violence. The person is incompetent. The judge chooses not to commit because the trespassing is, they weren't doing much other than going someplace where they weren't, where they were prohibited. So then the case is dismissed. And they are released. They continue to trespass, or they continue to commit domestic violence, all misdemeanors. But creates at the very least, I think,
a consternated public that the system is not working to protect them.
That, if I can jump in real quickly, that was a lot of the impetus between that competency statute being passed, was to address what you're talking about. People who are not under commitment, so not our focus today, but people who are incompetent, and making sure that public safety is addressed, and that no longer is a criminal case put on the shelf, but that there are going to be active efforts to both monitor those people's movements. No longer will misdemeanors, like, here's side note, and then I promise to get us on track, Kevin. Misdemeanor domestic assault. Assault your significant other, get arrested, found incompetent, get it dismissed because it's a misdemeanor. You assault them again and again and again. And every time they're misdemeanors, because those don't aggravate. So your misdemeanor offense is dismissed over and over and over again. And that is terrible. And so one of the things the statute changed was that targeted misdemeanors, as Susan has addressed, will no longer get dismissed automatically upon finding of incompetence. There's a big difference between misdemeanor shoplifting and punching your significant other in the face.
They're listed that in this statute.
That is in the statute. And I think this identifies perhaps a need for training on the statute, which we can look at. But moving into our focus for this afternoon, one last thing I wanted to talk about was just as a practitioner on the county level, and Dan, hopefully you can give some insight, and you too, Susan. I have seen courts try to hold DHS accountable for violations of the 48-hour rule in the state district court. And I think it might be helpful to discuss how some of those cases come about and what the challenges you have, what you face in those cases. And again, understanding that when those challenges are brought, there's rarely anyone in the room who denies the problem. The county attorney's office certainly doesn't deny that there's problems with admitting people to state operated facilities. But what I have met with, and invite discussion from my fellow panelists here, but what I've met with is a brick wall, is that we get an attorney general shows up at our district court, and they tell us, you don't have authority over the commissioner, she's not coming, find another way, essentially. And courts have acquiesced because the Court of Appeals has approved that technique and that tactic. So I'm interested if you guys have comments or thoughts that would help practitioners out there in meeting those cases in the immediate state district court level to try to get around those jurisdictional challenges.
For sure, many of for the first part of the problem is the mandamus statute in Minnesota is older than all of us combined times another 10. The mandamus statute has not been construed very often. It does not provide jurisdiction over the commissioner. The Court of Appeals ruled in, I'll tell you the case as I'm paging through as I go, in the Cristo Dolo case. I'm not sure I said it right.
Nobody can pronounce it.
Yeah, okay. But basically they said, the commissioner is not subject to the mandamus statute because of her position. And so you can't order her to do things. So you have to direct it to DHS. When you get to federal court or you bring a 1983 action, it's hard to name it's hard to name state entities because they're protected by the 11th Amendment. There's all sorts of jurisdictional issues that stand in the way. And it's also hard in federal court to allege that the commissioner made the decisions that were unconstitutional because DHS is a process of working through. I just took the deposition not long ago of Nancy Johnston, who's the head of the MSOP, who testified under oath that she doesn't consult with the commissioner before she decides not to follow court orders that order her to transfer people. Again, not the 48-hour rule, but you're going to see is that the commissioner's oversight is not the kind of oversight that gets currently her implicated in these litigations. I think what Christy says is very true, that the Attorney General's office has been very aggressive defending these cases. They basically say it's impossible for us to comply with the law. And the judges have been moderately sympathetic to that. You occasionally find some that order them to do it anyways. They appeal. The appeal goes on for a long time. The person gets transferred and they move on to the next case. I've been working on these 48-hour cases for about 3 or 4 years now, and I've yet to get a final judgment in a single one. All of my clients ultimately get transferred or released, but it's not solving the problem.
One caveat to that too, that I wonder what will happen moving forward is DHS is going through a restructure, as you've probably heard, where the commissioner is no longer taking responsibility for direct care and treatment and is delegating that by statute, which happened this summer under the radar, in my opinion, to the board, the executive board. And so I'm curious how that might change some of those actions or some of that pressure when now it's an executive board.
Yeah,
So-
I mean, I think it's the first question that will arise is, does the executive board rise to the level of a state agency or a state entity that is given, 11th Amendment protection? So you can't go after them for damages, but you always can go after these folks for injunctive relief. So, but I'm sure that there's going to be discretion in that board, and we'll just have to see how that plays out. What I can tell you is, no matter where I'm at, state court or federal court, I get this constant reluctance from the judges. And it's not judges who are plaintiff oriented or judges who are defense oriented. They all get frustrated eventually with the process, but they all look at me and say, what is it you want me to do? Like, there's no beds. What do you want me to make them do? Right. And I say, well, make them, and I always use the analogy that if they came to you and they said, we don't have enough money to feed people, so from now on, Thursday, Friday, Saturday, Sunday, we're not having food, you wouldn't tolerate it, right? But this feels different to the judges because it involves physical space and staff and stuff like that. And they struggle, the courts are struggling with how to remedy this problem. It's just a reality. And, I say, start fining them $25,000 a day.
Other states have.
Yeah, right.
There's
I mean,
Washington.
Right,
Oh,
this reminds me a
Colorado,
little
yeah.
bit, of what started this problem, really, if you think about it. We deinstitutionalized everybody who had mental health problems back in the 70s and 80s. We had these state institutions, Minnesota at Cambridge and other places, North Dakota at Jamestown, and the federal judges were saying, you can't keep these people locked up. So now we let them go. We let them out of these institutions, and we're still struggling with how to handle mental health issues, especially where they intersect with the criminal. Because as you know, some of these folks get into situations where they are violent or they are a danger to themselves or others. And so it's not simply an issue of mental health, it's also an issue of public safety and all the rest of it, so.
Right, because in a lot of those instances, when we're making arguments, we're saying, send them to the hospital. We just want them out of the jail, send them to the hospital. And that continues to be the problem, and I think that's, we're all making that request. The issue becomes, where are they gonna go?
So one of the issues that was driving the 2023 amendment to essentially eviscerate the 48-hour rule is that because of the 48-hour rule, as Dan was saying, you allege a violation of that rule and it should be good to go. Now you've got jurisdiction issues and that sort of thing. The courts have found that the commissioner wasn't a party to the commitment proceeding. You're bringing an action in that proceeding. They don't have jurisdiction. And a lot of courts have gone ahead, even sua sponte, and ordered, and the Court of Appeals has said that just doesn't work. But I think you'll recall that there was a hearing with Keith Ellison, Attorney General Ellison, and Commissioner Harstead. And I think what Keith Ellison was saying is, I don't want to subject my client to possible contempt orders. And so all these lawsuits, it's just a distraction, blah, blah. And at one point she said, well, I'm taking to walking around with my toothbrush in my purse. So one of the first things I did when we met is, you're never going to be held in contempt. You can leave your toothbrush at home.
Well, she's not going to be put in jail.
Yeah, I mean, she may be held, but she's not going to go to jail. Absolutely not. But I do understand that it is frustrating. And I think one of the things that we continue to hear is that the litigation we're talking about, it does have an effect. Now, for them, they view it very, very negatively. And in our last panel meeting, had a whole section on how much money the litigation costs and all the damage it's doing. And at one point I just said, well, people bring litigation because they're trying to fix an intractable problem. I mean, it's a last resort. And the other thing is, if you weren't the Attorney General's client, he would be the one who's suing you. in light of the failure to follow the statute and all these other things. That's what he does. He's what he does for everybody else. And I hope that brought a little perspective. So.
Yeah, and let me just add,
Please do.
let me just add a couple things. The statute expires. It's got a sunset provision and it expires in 2025, if I remember right. And so we're gonna be back to the 48-hour rule. There's not gonna be the medically appropriate bed language that, unless they change it again, and they need to do something. But you're right, the Attorney General is defending the state of Minnesota when he would be suing them if they were not the state of Minnesota. It's a problem that needs to be fixed. The problem that needs to be fixed.
Well, that's a great transition because the next session is going to be what is going on at the legislature, and some of the things that we raised here will be discussed in more depth. So thank you very much to the panel. It's been a pleasure getting to work and know at least two. I already knew Dan, but it's wonderful to have a public defender and a county attorney locking arms on this, a show of unity. It's lovely. Kumbaya. So thank you very much.
People who actually know what they're doing.
Yep. Go ahead. Put us up and do it.
I assume it will still be funny.
Make sure Carol doesn't go off that. Or Matt.
What is that all?
Nancy's, I'm afraid of her, so I'm not gonna say.
You're not afraid of me. Yeah, we do. And where my wrench is at. What does that tell you? No. Our problems, we could go on a really long time, couldn't we?
That catches everything. It'll catch you. Thank everyone for staying, for the, I can't say the best because they've all been good, but I think one that is, very prescient for those who are wondering, well, what happens next? What are the solutions gonna look like? What can we do? And, so in this session, we're discussing the, recent legislative developments. And on our panel today is Commissioner Carol Clark. She's a commissioner in Stearns County. And Nancy Haas at Pool Haas Government Relations. Now Nancy has been helping the MCAA and the Sheriff's Association, and I think a bunch of other groups too. But so I've worked closely with her, and it's been great. And then Matt Freeman from the Minnesota Associations of County Social Service Administrators and the executive director there. And I think he's got fingers in a few other pots too that have been interested in this. So we have a great panel, and with that, whoever starting first, please do.
Great, thank you, Kevin. And I don't know if we can advance, I don't know how to advance the slide.
Do it yourself.
Oh, sure.
You can drive.
Okay.
You seem like the driver.
All right, here we go. I always like to be the driver. Thank you very much. Well, thank you, Kevin. And as he mentioned, the lens with which I come to this conversation is being hired by the Minnesota County Attorneys Association. And so I have to give kudos to both Kevin Magnuson and John Choi, because I don't know what it was, but they knew something was coming. And so in 2023, leading up to that session, so actually 2022, they said there's something is going to happen on the 48-hour rule. We need to get our ducks in a row and be ready for this. And so I don't know what you knew, but thankfully we were ready for the conversations in 2023.
And really, we started from a county attorney perspective saying, let's try and protect the 48-hour rule. Let's get a little bit more transparency in the decision-making, something you've heard a lot today about. And could we get some better uses of funds and going to try and help in the capacity setting? And so we were moving along, trying to draft a bill, and all of a sudden we got called to a meeting with, and we had some interest from the public safety legislators. And we got called to this meeting and we kind of ran head straight into the healthcare legislators who called a meeting with, with the Department of Human Services, and they just had a different view. And you just heard, they were really facing the lawsuits, and they were very concerned about being called to court. I think the Attorney General was talking about how much money he'd have to add to his budget to defend cases. And so, I mean, a legitimate concern, but coming at it differently from us, which was we want to enhance and protect the 48-hour rule. And so that led to this was the statute in 20, actually. Okay, so this is my first draft, not my last one. Yeah, I don't know if.
I think you're,
All right, well,
let me see if I could
so
keep talking.
I guess you've seen a lot of the 48-hour rule in terms of the statute. I guess to start with, there was this whole conversation about moving to a medical director to make the decision versus a jail-based priority. So this tension at the legislature was around who makes decisions, and do we get a public safety preference or do we get a medical preference? And from my client wanted the public safety preference, but you can see where it's a legitimate discussion to talk about. There's the mental health challenges associated with that. So what ended up happening was the 48-hour rule was changed, and it was changed to say that patients who are described who are in a jail setting, in a correctional setting, must be admitted to a state-operated treatment program within 48 hours of the office of the medical director, determining that a medically appropriate bed is available. So that turns the tide on a jail-based priority based on public safety. That is now a medical director will say, you need a bed, here's why you need the bed, and then is a bed available. And so it also said really in 2023 that for 2 years, no court cases can be, there can be no litigation. And in terms of how did they kind of make counties feel a little bit better, perhaps, or under the auspice, because that's what the legislature does is, well, let's try and walk this right down the middle. Let's give you a little financial relief from paying for some of those services. And Matt can correct me if I'm wrong. I think it's about $13 million. They said during this time of no lawsuits and this new medical determination, you don't have to pay the $13 million to the state. And so that was another piece of the 2023 legislation.
Angie talked about that one earlier in the amount per day, about $2,300. And so it's not an even number across the state. It's as those come up, but it was waiving a DNMC cost for folks who were committed as mentally ill and dangerous.
And then the other thing the legislation did in 2023 was created an acute care transitions advisory council. And that was important because we wanted more people talking about what's a statewide implementing and thinking about what is a statewide vision and systematic approach to the acute care transitions that you've heard about all day today. And also get information about the barriers. And so previously the County Attorneys Association did not have representation on that group. We got representation. They just actually delivered their report October 1st. So that will be presented to the legislature, and there'll be more discussions about that. And then finally, in 2023, there was establishment of the task force on priority admissions. So you're going to hear a lot more about that today. And I will just say that the first report was due on February 1st of 2024. At first, that language said it would be 2 years for a report, and we just said we need some sort of report as soon as possible. And I will just say the most important thing that happened, I think, after all these, some people would say this wasn't great, we didn't like this. It was a compromise. It got people to the table talking about it, because if you've learned nothing today, you found out how complex this is, how many parties are involved, and why being at the table and having those conversations is critically important to making any progress that was mentioned that perhaps we'll be able to accomplish maybe yet this year. So 2024, so then moving to 2024, the priority admissions framework, which you also heard about earlier today, was how are we going to prioritize civilly committed patients? And I will say this framework was originally intended to cover everybody. They, you know, I will say the DHS wanted this to apply across the board to every situation. And what we were able to agree to this last year was, let's start with the jail. Let's start with jails and people coming from institutions. Let's check out this framework. Let's talk about this new priority. Let's let the medical director make the determination. And then let's also, this was I think a Kevin Magnuson special, which is let's get some notice. Let's have an ability that Christy was just talking about to say some sort of avenue for the patient, for the attorneys, and to ask a judge, you know, to report to the judge, here's why you're either eligible for a bed or here's why you're not, so that we have some tools. From a county attorney perspective, we want transparency, we want opportunities to communicate, and we want to see what the results are of those.
I need to say one thing, that when we were talking with, at our task force meeting and with the commissioner, my comment was, you're going to continue to get sued unless you address the due process issue that's there. So the way you don't get sued is by giving more opportunity for people to engage with their own situation. Sorry.
And then one thing I'm surprised we didn't talk more about today is in 2024, we also got into the bill opportunity for a reentry demonstration waiver and bringing that all together. And why that is really important is because that gets at some of the healthcare needs and the coverage for individuals who are in jail. And so that is something that happened this year that is currently underway. And that's a federal demonstration. We've got a group of folks who are getting together to talk about it. It's going to be really important to have an office and an ability in the stakeholders to say, what do we want this to look like? Because it's starting as a pilot project. And we need to learn how can we access the federal dollars and how can we implement it here in Minnesota and across jails and institutions. There was also this last year in the bill, a limited exception for 10 patients in hospital settings to immediately move to the top of the list. We just kept hearing this pressure, right? Jail-based. Folks, you've heard all about that today, why that's not a good setting. And then, but there are also people in hospitals, and we need some ability to be able to take those really extreme cases and move them to the top of the list. And so we said, okay, fine. I think I saw a report. I don't know. I've heard recently that maybe they haven't utilized that yet. Okay. All right. Tara will cover that. All right. And then also there was phase 2 of the priority admissions panel.
So I think we have the back what happened there. And I think whatever happened was most likely not my fault, not not our host. So thank you very much there for straightening out my problem.
So then, yeah, so I just went through the language. You saw a little bit more about that this morning. Financial relief for counties, this acute care transition advisory council, the task force that Tara will go into more, but that was kind of the highlights of that report. And again, just I'm sure it will be echoed, just the important, even though maybe the recommendations of the task force haven't been achieved yet, the fact that people are together and continuing to talk about it is critically important. All right, so then, so what is possible this year? So we had an election, and we have a tied House in Minnesota. It's 67-67, and the Senate has a 1-seat majority. The governor is back in Minnesota, has 2 years on his term. And so now we have kind of a unique situation. This session is supposed to be about budget, passing a budget. And so as you see here, the county stakeholders who are kind of represented here today have been, working together collaboratively for 3 years now. And the most important thing, and you've heard it today, is capacity improvements. How can we get reasonable and constitutional timelines for admissions? That's ultimately the goal of all the work that we've been doing, and we're not there yet. And so my questions that I have about what might happen will lead into Terrell's comments, but just, will there be efforts to change the criteria for admissions from 48 hours to a longer timeline? Probably. And to not have the priority for just jail-based. It is possible. I think, as you heard, that timeline ends on June 30th of this year. So we don't have to do anything else, and that could happen. But also, probably most importantly, will the administration propose improvements to capacity? That is the thing that we have been working on the most, and think that it would, as you saw in all the slides today, that's the thing that ultimately could be helpful to ease some of the pressures on, and maybe then the timelines are open for discussion. We could have a more reasonable discussion about what, it doesn't need to be 48 hours, because you also heard today, it's never actually 48 hours right now.
A lot of the protections that we're building in are sort of inversely proportionate to the amount of capacity. If there's plenty of capacity, we don't need them.
So with that, I will turn it over to Terrell.
Thank you. Good setup. So again, my name's Terrell Clark. Just a couple other things to know about me. I got to serve in the Senate with Senator Chaudhry, who's out of the room right now. And like Nancy, certainly advocated before then and since then. I also served on the Competency Restoration Task Force. There's only 2 of us that served on that are in the current, then task force, now review panel. And there have been some steps forward. There's been some steps sideways. There's there's been a lot of invisibility, which is why, Don, your continued willingness to talk and share stories, and others sharing stories, helps, because people we're talking about today are those with the highest acuity needs, right? They're the ones that really need something that we can't give them in a jail, and we don't have enough placements. And in some ways, for those of us in the so-called county coalition, the headbanging we're doing is really, we can't magically make more capacity appear, and we need that. The legislature did do some good things after the competency restoration task force reports came out. One of the things that was different about that task force than our current one is we had a whole section of our report that was really about everything from prevention through all of this, because we knew that you couldn't just be talking about competency attainment without looking at this broader array. Of that, a sliver got put into law. And that's largely, honestly, because of targets, because of money, because of other priorities. Fast forward to when this particular legislation came in, I think we all thought there's another opportunity here, even with a very narrow scope. The commissioner keeps saying, this is a very narrow scope. And we keep saying, it can't be just this very narrow scope. It's not just about those words that relate to 48 hours on a piece of paper. These are people's lives. These are just hospitals. These are jails. These are community folks. We have to figure this out. So one of the things that, while I know it's on a different slide, that was a little bit different this time is having the task force co-chaired by the commissioner and by the attorney general. There's many good things about that. They also have an inherent conflict of interest because, at some point in time, the commissioner doesn't get to agree to any proposals for anything that costs money. And it's been a long time since we've seen a full meal deal, as it were, coming out of any administration. And that's why everybody in this room and much broader has been working on these issues. But a good thing is we had people who came together, particularly from the different county groups. So Kevin, myself, Angie, Brian, we are the members that have been participating on behalf of our different organizations, and we've been learning together. And then we've been trying to work with a whole bunch of other folks. So this year on the panel, there's only one new person. So it means we at least have been learning from each other, understand where maybe some challenges could be, particularly if there was reasonable amounts of resources out there, we could deal with a lot of this. The problem is none of us can control that.
Can I say one thing real quick? And that is.
Yep.
One of the reasons that we're bringing this presentation, we put it together for the MSBA criminal law section. And in particular, making a concerted effort to reach out to defense counsel is the, the public defenders and the State Bar Association should be a part of these discussions. There should
Absolutely.
be someone on the task force. There should be people in the room negotiating these things. Right now, I think that your power behind your organization and your viewpoints aren't being heard. So we'll hope that maybe that's something that will change it.
Yeah, absolutely. And the last presentation is a really good reflection of that. We need more people coming together. So as we came together with this task force, going back to the 2024, we really did have a guiding principle that was about all people who are living with mental health disorders are entitled to have the care when they need it. Not it's a later time when they need it. That civilly committed individuals should have court-ordered treatment to achieve recovery. The jails are not a replacement for mental health hospitals or secure treatment facilities. This was brought up a little bit early. Angie and I were talking again. Just think the difference between inpatient and outpatient. Like, we really can't do inpatient. Look at the difference in that slide between what the jail looked like versus broadly thinking about what a treatment facility is. And then we had a number of key recommendations. And
I think these got.
oh, do we not have them up there? Are they out of order?
Oh,
Now you gotta go back to yours.
These
Is
are out of
there-
order. It's
Yeah,
okay.
you know what?
I can
We're
fix
kind of
it.
on the fly here, so.
Yeah, but I just want to make, I see what you mean. We're missing the song. So I'll just verbally go through some of our recommendations. If we find it, great. Don't worry about it. We're all good. Seriously, it's all good. Plus, people can get these later again too, right? And we'll know where to find each other. It's all good. As a matter of fact, you might prefer just hearing it versus seeing it. So broadly for all of us, and think about what you've been hearing about during the day. Other strategies are important. Improved ways of work and communication are important. All those things are important. But having said that, it still goes down to capacity. We need more beds in communities. We need more DCT beds. And we couldn't agree to change anything else unless that happened. And that's where it goes back to where the rubber meets the road. If the legislature doesn't have targets, if they don't are given enough money to do things, then people get somewhat creative, and that can be good, right? So one of the recommendations from the task force was a 10 to 20% immediate increase in forensic beds and a 20% overall increase in AMRTC beds. Okay, we didn't get there yet. I'll just be honest, but DHS was really working to try to figure out how to free up space. What else can be done differently? Okay, good faith effort, right? Kind of our minimal best that we could get to. That any changes to the priorities admission statute has to be accompanied by that kind of capacity expansion. And that we did, as Nancy said, agreed to these up to 10 civilly committed individuals waiting in a hospital. Under particularly egregious circumstances, might as well go ahead and just do I don't know if you call it the punchline or not, but we were told both in a task force meeting and then in the letter that was referred to previously, that they really haven't found anybody in hospitals, one exception, that meets the kind of the level that we're needing, that their conditions do not meet the need of a hospital level of care, or the conditions are not so complex that they justify moving ahead of a jail referral on a waiting list. There are more people out there waiting. There are more complex needs. There are more needs, period, which is why we need the capacity. I am the broken record part of the coalition, I think. So I'm just trying to think what else do I want to tell you. So you heard about the other pieces, the prioritization framework that's getting tested out within the jails, the funding mechanisms to effectively deliver and administer the mental health medications. As Captain Maslakowski from Stearns was talking about, boy, there's a lot that has to go into making this work. And it's a lot for counties to be doing. The relief that Nancy talked about, the temporary relief that wasn't really a full relief, and then also the demonstration project on the 115th. Those are all good steps forward. We're going to have to keep working on them. We've moved into this panel now, right? So we're supposedly even more narrow. We're reviewing disaggregated data. We're seeing what kinds of things on a dashboard the facilities are looking at and making decisions. Those are good things. The feedback on the notice, that's a good thing. We're also now talking about whether or not to change the 48-hour rule. And as Nancy said, I think I could say it even more directly. Yes, there are some that think we could just not have the rule anymore. Well, we need to have some accountability in the system. And that's part of what our coalition believes. And all of you who have been talking today reinforce that. There has to be some ability for a person to know they're going to get to be moving forward and through that. There will be some tweaking, most likely. I think that is on another slide, but we can talk about that more when Matt gets through. I want to make sure you have enough time. Tweaking with some of the issues that have come up. I think that most of the people on our task force left to our own devices would be saying we still need to recommend significant capacity. That wasn't really part of our charge, but it is something that we feel strongly about. So this communication, what can be happening so a person or people who are concerned can have more information is really important. I guess one of the two takeaways. One is in this work of progress, there are some steps that are moving forward. It is painfully slow, but it is moving forward mostly. And then two, it does go back to the capacity. We can't change that part. There are going to continue to be efforts by some, and I get it, we're going to say the jails, you have to figure this out. And our contention is that's never an appropriate place from a long-term standpoint, especially depriving somebody of their own civil rights. I'm going to turn it over to Matt so we have some time for questions at the end.
We'll come back to this slide, which kind of talks about
Yep.
what do we think will come out of that.
Exactly. I have a list, but I thought you might
Yeah.
want to get through your part
Sure.
first.
So there are other efforts. Again, Matt Freeman, I work with the human service directors across the state and with AMC, the Association of Minnesota Counties, on behalf of commissioners. This issue has been a top priority for multiple years of both of those associations, and really proud of the ability to work alongside kind of county partners and others to kind of move this forward. Going to highlight just quickly 4 different areas where other work groups or task forces are taking action or in the midst of action. Oftentimes the legislature doesn't have money. They assign a group to figure out that answer. And these are some of those, which I think there's good work going on in them. First would be this mentally ill and dangerous civil commitment reform task force. This is a part of last year's legislation. It was championed by Representative Heather Edelson, who's now a county commissioner from Hennepin County, and really charged with looking at civil commitments and what should we be doing going forward, national best practices, developing appropriate funding recommendations and adjustments. So they took some of the discussions from the priority admissions task force and shifted into this additional task force that's supposed to report by August 2025. So they're going to miss the budget cycle this year. Not sure how quickly or easily those things will be implemented. There is county representation from MACSSA, the Human Service Directors, from the County Attorney Association, and from Association of Minnesota Counties. They did not include the sheriffs in that task force going forward. Next, as mentioned earlier, in 2023, they passed an Acute Care Transitions Advisory Council. This group, again, with some county representation from county attorneys and human service directors, as well as local public health, is looking at those folks that are hard to transition from hospitals, period. So we have a lot of push from the Hospital Association and others saying, get our folks into direct care and treatment. There's a need there. We shouldn't be waiting in this line. There's also a large group of folks that don't need to go to state hospitals, but are having challenges in where they're transitioned to community. A lot of times those are complex and co-occurring dynamics, disabilities, behavioral reasons why a facility doesn't want to take them. And so this group put together some recommendations that are just recently came out. I'll go just very high level, but they say more work to be done. Let's keep this task force going. They said base funding for the state to help with some of that coordination, recognizing individual counties figuring out these placements are duplicating the work of their neighbors as well. So particularly in these challenging placements, how can we be aggregating that knowledge and developing some state expertise to support that? And then looking at the application and assessment, folks can now apply to the state for additional resources and support for these placements. And again, why this is relevant to this group is because, again, those will relieve some of those concerns in the hospital emergency rooms and other placements at hospitals that are also the same folks that hospitals would like, or same places where hospitals would like to discharge folks into direct care and treatment. Last, I think this was a 2023 piece. And again, Judge Carey and Commissioner Clark both served on a competency attainment work group going forward, trying to make some of those changes in law for developing forensic navigators and developing that program. The soft launch just started this past April, and there are 20 forensic navigators currently employed across the state and 6 certified programs. They're looking to continue to expand that. Some challenges in uplifting and getting that on the ground and running. Board members that are managing that from across a number of different perspectives in the system. And then again, that larger charge is really to work on what are the needs for forensic navigators? How do we put together that budget? How do we create standards and an administrative policy and really create that competency attainment program that had been lacking previously? Then attached to that is the certification for advisory committee, the folks that are diving into the details of the curriculum, the requirements for those programs, and certifying individuals to provide those services. And they work with that competency attainment board more broadly. Again, representatives from a number of different areas working on that. And so the forensic navigator dynamics still in development, still being tested out. I think we'll have a better sense going forward in the next couple of years about how successful that is. And all of that kind of predated this 48-hour conversation at the legislature, but is working with similar populations. So then the next group that we're talking about is been touched on a couple of times. Again, there's a demonstration opportunity, 1115 waiver. That's a chance with CMS to demonstrate a new approach. Has to be budget neutral at the federal level, but it's been designed at the state to put together a group to create a state plan to serve folks and cover through Medicaid the jail healthcare for a number of individual counties, jails, as well as state correctional facilities and some juvenile facilities. We have not seen exactly where that's come from last session. We do have county appointees. I believe there are 2 from the Sheriff's Association as well that'll be working on this. A great opportunity to look at how healthcare can be better supported with a federal funding source in our jails. Again, this is focused just on populations before reentry. So it's unlikely to be our competency folks right now that would be impacted by this, but the long range piece would be looking at how do we ensure jails and correctional facilities can utilize federal dollars to pay for healthcare resources.
Yeah, thanks, Matt. I was just going to mention that right now this is about I don't remember if it's 30 or 60 days before release, access to this healthcare, and really the goal is to have it with no disruption in service, because you heard about how long folks are staying in a jail setting, and so that's kind of on the, we got to get this first part figured out, and but there is a pre-adjudication desire to have that covered. If the sheriffs were in the room, they would say that is really, really important, because you really want a no continuation of people in terms of their access to the healthcare they need.
And this is one of those really good step forwards. Honestly, the main thing that's more than way too bad is that it's gonna be like 4 counties and 1 tribe, and there's one other it, but so it's not gonna be super huge to start with, and lots of people want to be engaged, but that's the good news. We'll get there.
Yeah, and prior, for those folks who are prior to having their legal case.
Pre-adjudication.
Yeah,
Yeah, we
adjudication
want that.
are not covered. We've seen that in a couple of other states, and we'll keep likely advocating for that at the state as well. And then we mentioned earlier as well, some of the change in how DHS is organizing itself and how that'll impact this work. We now have 2, and as of July 2025, we'll have 3 state agencies that came out of DHS: Department of Children, Youth and Families, Department of Human Services, and Direct Care and Treatment as a standalone agency. And so DCYF is bringing some folks from the public safety area, some from public health, as well as much of the children's areas, focusing on child support, child protection, economic supports, and putting them in a separate agency. DHS will keep some of its core functions. It'll really be a Medicaid-focused agency, so healthcare, but it also has adult and disability services, behavioral health, and for now DCT. But again, that transition is upcoming. They have a new homeless housing and support services. The acute care transitions really lies in that aging and disability services section. So again, one of those questions that was mentioned earlier is, as somebody's committed, will they be committed to the commissioner or to DCT? And that's a transition that's been a part of the legislation from last year, and yet to be seen how that plays out and impacts things. And then DCT, again, a new state agency. It was part of a couple of years of process. 2 years ago was the determination to create this new agency. Last year was some of the administrative processes to do that, and it created an executive council. And then July is when that is all implemented. For more context quickly on this, because it intersects with our topic here today, creates a new executive board and a new chapter in law that this will be handled. Timeline is looking at that agency originally starting January 1st in statute. That was adjusted last year to be July 2025. And then they're in the process of selecting a board for that. The governor appoints members to that board. There's ongoing work to figure out how to administer that. AMC does have a non-voting member. They were considered to be a conflict of interest to have a voting member. So AMC is able to appoint somebody to carry some of that perspective that we think is really important of what is going on in the community and not just within the walls of DCT. And part of that is, what capacity do we need to come from our safety net services compared to what's in community? And then again, those appointments are expected by January of this year. So I'm going to go take us back to that. Where are we at on the review panel question, where we can pontificate a little bit about what do we think that review panel will decide? Again, its goal is to look at that priority admissions criteria and how well that is working. But it also has a couple of other charges to make sure that we're trying to figure out what is that appropriate time period. And the discussions in our last meeting with a number of perspectives being shared of, well, we don't need any sort of time period. It's inappropriate because we can't meet it. So why are we setting a number? Others that said, well, let's suspend it for another 2 years. We suspended it. We have other measures that are going on and being implemented. We'll know better and have better data in the future. And others that are saying we need to have something that is accountable, whether that's 48 or a different specific number. But again, welcome Kevin and Commissioner Clark to share what are your thoughts about what will come out of this and how it'll play into 2025.
I was gonna say, I mean, a part of what we're really trying to figure out is, how do we have appropriate accountability? How is there still some process, at a bare minimum, not changing the 48 hours until and unless we get some more capacity? Because it's a problem. And one of the things that can be a little tricky, there's some good reasons to break this work up. So good. But a worry I have is, by breaking it all up, does that mean anybody's actually talking to each other? And what will that mean? Because passing more policy without more money, even if it's neutral to state, doesn't mean it isn't going to cost more money, and it doesn't mean it's going to change anything for the good. And so what we're all very concerned about is how do we make sure that constitutional rights for people are still at least arguably protected as we go forward. And hearing some of those obstacles, even currently, to being able to use courts as a mechanism for change or for action for a human being. How do we address that? So Kevin, you want to talk a little bit more?
Well, I was gonna ask you a question. real quick.
Okay, go for it.
What kind of money do you think we're looking at in the next, 3 or 4 budgets to get this done?
So we actually really need so there's 2 parts. There seems to always be one-time money, right? And so I'm not alone in this, but I'll just only use myself for a moment. I'm of the mind that you go ahead and you build that into the bonding bill or in some other way, so people see it in other ways as a priority, and you still start getting moving. Because for a lot of major projects that go through that bill, you get planning money. And at a bare minimum, let's figure out what it's going to take and scope it out so that they can get ready, because there's also a workforce issue, which is an ongoing amount of money, and that can get eaten up very fast. I believe we thought we really needed, what was it, 50 million?
It's like 40 or 50.
Somewhere in there to at least start getting moving. And
So this
that's
next budget.
right.
Well, at any point
Hopefully,
in time.
at any point.
No, but right.
And the longer we
But
wait,
that would be our initial
right,
task.
the longer
whatever
we
happens.
wait, the harder it is. So, you heard about our in Stearns, our voters passed using sales tax for a new justice center. And honestly, 3 years ago, it would have cost a hell of a lot less. And 12 years ago, when our board first looked at it, I wasn't on there, it would have cost like half as much money. So we're in the same boat with this, right? Every year that's delayed, it's hard. Now, the good news is we have chairs in the leads and both bodies that have wanted to know numbers. They need to know. But it's going to take a bunch since it can't seem to get out of into a governor's proposal. It's going to take us all a lot to really make this happen.
I think one of the things that's a little frustrating is that the parties are all together, and I think that the dialogue is really constructive with it. I think DHS, the Attorney General's office, some of the other interested parties, county parties, the defense bar that's been petitioned. I think it's been a really good discussion that's opened a lot of eyes, and there's some understanding. And it's not a conversation, as far as I can tell, that's really happened before. I don't believe that DHS and some of the other county stakeholders at least have had this conversation. So I think that's really important. But when they were talking about, DHS was at the legislature in 2022, and MCAA was there as well. I think I mentioned this, but we had a proposal that we wanted to get adopted, a bill that we wanted to be passed that would put teeth into the 48-hour rule. And naively, I think John Choi and I and others thought, well, once we do that, that'll give DHS some more leverage to be able to go in and get the funding that they apparently can't get. Well, now, 2 years later, I think, I was a Cub Scout at that point, thinking that it was gonna be that easy. But the DHS came in, and they were looking to essentially cut the 48-hour rule. And the fact that we were both in the legislature fighting this out, and frankly, we had a very insightful committee chair who kind of stuck between a rock and a hard place and started putting us together to start talking, and then created a spot for us on the task force and a few other things. And then there were some other things going on, and we managed to get this sunset provision, which I think was huge.
Yeah, it's what part, yes. And many things have been going. I know, Angie, because I had to miss part of the morning, I don't know if you showed the honeycomb of the many initiatives. There have been many attempts to wrestle with these issues and wrap their arms around and get something passed. And it's understandably, because there's lots, potholes are what people hear about. Let's just name it, right? If you fall into your road, your legislator knows they need to do something. So you've got some of that, but the impetus even back then, including with recommendations from the Competency Restoration Task Force, there was some really good momentum. And a challenge can be is starting to say, look what we did. We did it. Well, they did a little bit of it because it's pricey, but it will save us so much money along the way. And more importantly, human beings' mental well-being and their better health if we could start both getting upstream and we deal with this other piece. So it's not necessarily, it's not cheap, but the cost is pretty significant. And it's hard not to sit here and think about what a jail cost per person per day is versus what the cost of being in a hospital is in an appropriate placement. There's a huge difference. And the part of the question is, how can we get enough of a wake-up call so that we address this? Because trying to figure out how to pay for any of this out of levy dollars is almost impossible when this is really a state obligation.
Well, that's
not getting cheaper, and the problem isn't going away, it's just getting worse.
Exactly.
Yeah, I was just gonna say that it's a really good setup, and I was really kind of taken with Dawn's comment when she said, "Who's the wizard?" And in this case, like if you ask this question, who's responsible? Who's responsible for this situation? And so you've heard today there are so many players in it. And so when everyone's in charge, no one's in charge.
Exactly.
And so ultimately that has been the challenge we have faced because we're promoting capacity for the state. And so we need them to embrace that capacity and partner with us. And then they want to say, well, okay, there's some responsibility at the local level to work on the community part. Yep. Okay. That's a bit, none of these conversations were being had until that task force and then the Rule 20 precursor language. So it's been happening for a long time, but that is the dynamic we're being faced with is it's a multi-layer system. There are many people involved in it and and so I will just say the good news is I think that the conversations are still ongoing. Deadlines often get people to move, and there's a deadline approaching on June 30th in terms of it. Absolutely, the pause in the statute will go away, and so how much does that move people to want to actually make some changes is which is what this session is going to be all about. So,
I was going to say real quick that the point that I meant is that when we were in there in the 2022 session. It's really unfortunate that we hadn't had this kind of dialogue before because we were at loggerheads. So then when we showed up in the 2023 session saying we need money, there were a lot of people who rightly said, well, this isn't a budget year. And where were you when they were handing out all the money last year? That's the time you should have been asking. And I'm kind of looking at the commissioner, she's kind of looking at me, we weren't really there yet. And now we are. So we're hopeful that we can start. But I think the key point, I think if you look at Matt, I'll give in a second, but I think when you think of the key chess points here, it's really not that difficult. I mean, there's the accountability aspect that we desperately want to keep some way of holding, a government agency's feet to the fire. I mean, it's probably not the first time you've heard the need for that, right? And then there's this funding issue, and it doesn't make any sense to move the deck chairs on the proverbial Titanic if you're not fixing the problem. It's just going to get worse, and you kick the can long enough, everything just collapses. You're going to have to do it at some point. In exchange for that, they want the DHS and DCT that are handling this. They want to come up with a system that's more manageable, that's more workable, where expectations they think are more realistic. And I think this is an opportunity for us to say, if you're going down the road and you're building the confidence and we see a commitment, then we're a little less concerned about the stringent restrictions that we're asking for now. And to oversimplify a little bit, but
no, but
it's a trust issue.
Yeah, and I think also the slides that Angie had this morning that showed what happened since 2013 in the 48-hour rule and the discussion about how quickly folks got to beds, a timeline helps move. Absolutely. So I think ultimately, to your point, there's been conversations. Does it have to be 48 hours? Well, it's not 48 hours now. So, you know, there is room for that dialogue, but it has to be accompanied by the necessary, and to your point, good faith effort of how much capacity can we add to lessen those other pressures.
Yeah, I would say the investments that we've heard asked for direct care and treatment over the last number of years have been operating expense asks, have been some repairs. It hasn't been any expansion of service. And I'm not sure that we've heard a lot of receptivity to that. I think we had some conversations last year about what could 50 million do, what could 150, how would you reorganize the system? The changes that were made last year brought down capacity on SUD beds in order to raise forensics beds. So again, a different pinch point. SUD beds also have a wait list for folks needing locked or more extensive there. So that's challenging. I think as we look at the next session, I would expect DHS, as their medical director and their leadership has said time and time again, they want very strongly to protect the medically appropriate bed is available language. And so I think that conflict will continue in the task force and how we remedy that or what the recommendation is. And then ultimately, doesn't matter what the task force decides, it matters what the legislature passes. With the new dynamics of a tied House and a 1-vote majority in the Senate, I expect folks will be looking to have a lights on budget. Maybe this capacity is one of those bipartisan issues. I hope that we can build some momentum behind that to do that investment, but I would expect the administration to continue to say, well, if we're doing that investment, then we need to have medically appropriate bed or another 2-year reprieve or something down those lines.
And it is driven, like you said, through the legislature. Another big component is what's going on in the governor's office. It's they're prioritizing certain things in their budget, and you know, I'm not sure that this has gotten to be enough of a squeaky wheel that you know it's considered a must-do situation.
And we may also hear folks say, we're transitioning DCT this year.
Right.
Let's transition successfully, and that's a future investment that we need to look at.
So we've got a question.
Yeah, just real quick,
Yeah.
to which we can all say it takes a while to build out. So start working on your build out as well as community resources, because the community piece, whether it's ERTs or something else, is going to be really important. So we will hear that, and we have a good response to that.
Please go ahead. Thank you for waiting.
I'm sure if you already said this, I'm just trying to, I guess I would just kind of, you talked about the budget for, you know, expanding, but I'm just wondering, is there a number of beds that you're looking that you feel would solve it? I don't want to say solve the problem, but you know, help, like, is there a specific number that you're looking to?
So what we got the task force together to agree to was that, at least to start with, that it would be, I'm just going to make sure I say the right numbers, 10 to 20% increase in forensic beds, which is between 37 and 74, and 20% immediate overall increase in AMRTC or CBHH ones, which would be 38. So we got a ways to go. That's not what probably is fully needed, but that would make a huge difference.
Roughly.
Like huge difference. So, but it's expensive just to do that part.
But that's the recommendation from that task force.
Right.
It just had no,
Right.
to the point again, who's responsible? No one has brought that
Okay,
forward
so
and put it in a bill. And
You know, but
Right.
when the very first meeting that we had at the task force, the Attorney General Ellison was co-chairing, and he started out saying, well, let's come up with a number. How many beds do we need? And the experts shut him down so quickly. You know, that's almost a stupid question as the response to the Attorney General. And it seems to me that is exactly the question. You know, at least have a target. What do we think we're shooting for? And I know that that's what the committee chairs are asking for. Give us some numbers so we have.
and I think you all negotiated that on the
We did.
very last day,
We
at the
did.
very last
time we
minute.
did it.
After the meeting was supposed to be finished, Angie over there was, it's like a meat raffle. She's over here, well, we'll give you, 8 beds for this. But, we didn't get any real movement until the very, very end, when it looked like at least very close to half, maybe not quite, of the task force was not going to support the recommendation. And there was a very real chance of having a pretty significant minority report to accompany that.
Yep.
And, and we had a lot of, and not to be too cynical, I think there was a lot of goodwill. And I think people really wanted to figure out how do we come out of this with some sort of starting point. And that's, I think we're optimistic that this year we can leverage that. I really do. And then I'll
Well,
I really do feel like the commissioner and DHS have moved internally to the point where they, work through whatever issues they have to be able to say, we could recommend maybe at a higher level or more dramatically than we were able to do before. We got two questions. So Christy's got one, and then
Yeah, but you got to say something, so I'm
Yeah,
gonna,
no, please do
no,
that.
just really quickly, we just have to make sure we keep saying that changing a policy is not the same thing as building capacity. And that has been inherently where the commissioner has been at, is let's change the policies. We will continue to work harder to work things out, and we need more capacity. Okay, now go to the
For a
questions.
cheeseburger today, right?
Exactly.
Yeah, Christy.
My question was, is the capacity analysis broadening to discuss staffing in addition to beds? Because
Yes.
yeah, informally, I've heard the issue is more staffing at this point than.
It's both. It's both.
Anytime
We
we
brought
talk
up
about-
both.
Yeah, anytime we talk about capacity, it's staff and.
Right. You
rooms.
have to have
Yeah.
both. You can't just have beds.
Can't have empty rooms, yeah. Angie?
Verify the last day of the priority admissions task force, when we came to an agreement on the number. Again, it was a first step, but it was informed by looking at both what was currently on the wait list, people currently on the wait list, and the amount of churn that we can see, as well as looking at, through some discussions, what's actually available for spaces. Workforce absolutely has to be part of it. But we were saying, is it renovating a facility? Is it, leasing a facility? Is it not construction of a whole brand new thing? Because that's a different process, which is on the table for consideration. But that's why we went targeted and looked at actual new bed and staffing. We kept saying it.
Bed and staffing.
Bed and staffing. And what we tended to get back was, we'll just turn the beds over faster, that's more capacity. And
Where are they going?
while that can be great, it can also result in more returns and more revocation of provisional discharges. So there was a lot of factors in it, and it was first step. It was not the full analysis of what should hopefully that helps.
Can we just put a fine point on what you just said about when we rely on more releases or the churn?
Yeah.
Solve the problem, that tends to correlate with increased future admissions.
Mhm.
So the fine point that I would like to identify, if I'm right, I don't need to be right, I just wanna know, like, are we saying then that people are getting out too soon? What are we saying when we say that?
That was my intention in saying that, is that there are times, and I can say from my county.
Yeah.
We have had people leave before our case managers who know these individuals. They're saying they are not at baseline.
Right.
They are not well enough to be discharged yet. They're discharged. A couple weeks later, they're back in the emergency department. Couldn't have predicted it. And so that in the beginning, in the morning, we were talking about this critical resource, time.
Yeah.
And that's what it is. And I'm not saying time like in the institutional care where it's really hard to get out. We just can't rush it. You cannot rush through it because you will create this faster revolving door.
And is there any Minnesota office of budget management, et cetera, that would track that kind of cost? Because when you think about,
Talk to her.
people saying decompensated, we hear it in our daily civil commitment trials, every single hearing. The longer a person remains decompensated, the lower their
Yes.
baseline becomes.
Mhm.
And so now we have more people with more needs living in the community. And that's a disservice to the humanity that we are all either elected, appointed, or hired to serve, or, to our general obligation.
I would say to that, Weston Merrick heads up evaluation within MMB. And he is working with the folks on some of the jail medication pilots. Process, again, hasn't been started, but trying to evaluate some of that. So that may get some of that intersectionality. That results first group at MMB has been really helpful in working across different agencies and bringing courts data and other things together. So I think you're on the right piece and figuring out how do we get that return on investment or results data that we're looking for.
Comment in that, they have access to data that none of our agencies or counties or any singular entity has access to. They have access to it. So we had a empirical study done of the programs in Blue Earth County. They were able to pull and match together courts data, claims, healthcare claims data, our local data, bringing it all together, and they do have a very special interest in this topic. So as Matt said, Weston and his team, they're fantastic, and they do have a special interest in this. I hope there's more of that.
Well, so we're getting pretty close to ending here for the evening, or for the afternoon. I just want to say that, first of all, even, in this panel here, we're really fortunate to have a former state senator who's got all the intricate knowledge, behind the scenes knowledge of how this funding and budget process works. That I don't think the others necessarily have, and two very experienced, capable government affairs folks that are helping out on this a lot, which is why this is the panel. And then I just want to give a special thank you to Angie Youngerberger. She basically put on she put most of this together, along with, she had a good help, but a lot of the organization and the meat that I think was so valuable was put together by her. And which is usually the case when we're doing a project. She's the one who ends up behind the scenes doing a lot of the writing and stat gathering. So a special thank you to Andy for her help. We had a lot of great panels, so thank you very much for coming. I'm sure we'll be here as we're kind of packing up, and happy to talk and exchange contact information for anyone who wants to follow closely. Thanks again. Safe home.
Thank you.
Whatever kind of impact study we want to call it. That's not really how you get to this.
Maybe we should change the name.
And then.
Okay, no shit.
No, they've been not too bad.
It's been great.